Yo, hello. This really isn't much of anything, guys. I don't even know what I'm doing. Probably just gonna be playing games. Who knows? I really want. I've got no interest in talking about Mr. McDonald right now because it's very. It's really. Ugh. Forget about it. But I am now actually multi-streaming right now on YouTube, Twitch, and Kick. Probably for this Kick for the second time or third time ever. If you don't, guys don't know what Kick is, it's just a Twitch competitor primarily. It's another live streaming service. I really don't know what I'm doing. There's not going to be much here. I saw there was another Hanty video that dropped, but there really wasn't much to it. So that's why I didn't really bother. That's why I didn't want bother to talk about it. So. But I mean, we could just talk about whatever. I don't know. Like, I just feel like, you know what? I just feel like going live. And you know what? If that's only a couple of y'all, that's fine. We can chat, hang out for a bit. You know? Even though I have other games I still have to finish up, I'm kind of I know that I missed out on a whole bunch of content in Starfield after beating the main quest, so I feel like just going back to it. But also going back to it with mods. What I mean that is like going whole hog with mods, as in like gameplay changing mods. Because the mods that I had beforehand were all like visual. Were all purely like visual stuff. The DLSS and etc. The mods I've added now are a couple of armors that I added. One that it helps with the combat AI, for God's sake. Because Lord knows it needed, the game needed that. So. Oh my God, Nathan, stop it. I've not played, Christian, I have not played Alan Wake 2. I'm not really interested in it, right? Because right now I have Spider-Man 2. I have the Cyberpunk expansion that I still haven't finished, haven't even touched yet, and then Armor Core 6 I still haven't even finished up either. So right now, and also I feel like Starfield is a lot more chill. I think that's why I'm kind of interested in it more. Because AC has a difficulty that I'm just not interested in right now. Spider-Man 2, I gotta move my my PS5 to my PC room so I can to start streaming it. But wait, before I do that again. And then and also the Cyberpunk also kind of gets a little bit sweaty too. Raymond, it ain't happening, bro. I respect your dedication, but it ain't happening. Aw, kitty. I don't know. I feel like if you guys want to watch maybe something while I'm lugging around in Starfield. Although sometimes these veterans in politics videos are actually pretty wild. They're probably boring, but they can be pretty wild too. I know I have suggestions in the Discord. Most of them I'm saving them for later.
Good morning, this is case D521372. Thader versus Thader set today on Mr. Lewis Schneider's motion to withdraw as attorney of record, and then a second motion was from July, and then August he filed a motion to reduce fees to judgment. Then in August the plaintiff filed a non-opposition to those motions, and then also in August, a motion for sanctions and attorney's fees, and then the defendant filed an opposition counter motion for fees to that motion for sanctions. And then the plaintiff filed a supplement September 27th with supplemental exhibits in support.
This is not McDonald. We're not doing McDonald.
Fees, which Exhibit 9, the court wants to strike that as being inappropriate and irrelevant. However, they don't let me just strike one document or one piece of it. I have to strike the whole thing and ask that you refile it. Counsel, kindly your appearances for the record.
Brandon Levitt, bar number 11834, on behalf of the plaintiff, Mr. Brandon Thader, who's present, Your Honor.
Good morning and welcome.
Jennifer Abrams, bar number 7575, on behalf of Brandon Thader.
Good morning and welcome.
Your Honor, Lewis Schneider, 9683, on behalf of Tina Thader. She's present along with me as my paralegal, Roxanne Minnick, Your Honor.
Good morning and welcome.
Your Honor, can we ask to close the hearing, please?
Sure. All those who are not a party, not representing a party, will please exit the courtroom.
Your Honor, these are my client's parents, and I'm here for their support.
Do you need them here, Mom? If you want them, I will allow you to have them. There's a law that was passed several years ago that basically asked that good cause be put on the record. There are some ugly things that are going on in the background of the case. However, if you feel you need your parents to be here, first I guess I should ask you, do you feel that at this point in time you are represented or you are unrepresented? If you are unrepresented, I will definitely allow them in here.
The only reason I say that I'm not, I would like to represent myself, but I feel like I think maybe I may need an attorney. I just want peace. I don't know. I heard that you feel like I need representation, like I have to. Can I just represent myself?
Well, you can make your choice.
You're welcome, Jennifer.
A party can always
No
decide
problem.
if they want to be represented by counsel or if they don't want to be represented by counsel. But you were represented by counsel throughout the case until the very end, and there were a lot of things attached to the
the audio is on the
file
left channel.
showing that
There's almost
your
nothing on the
current
right.
counsel has a motion to withdraw, saying that there's communication, basically problems, that you guys can't communicate anymore, showing that he was trying to
taking a
ensure
break
that you
for
would wait
Sniggity.
until the forensic accounting report came out, feeling like you may not have an equal power balance in the relationship regarding the economic issues, wanting you to be able to have all the information, because generally there is no agreement in any type of case that is going to be as fair without all the information. When you have all the information,
No, we're not giving up on McDonald.
pretty much most people can make a fair agreement. But without all the information, it's kind of a shot in the dark. So I think that was kind of what your lawyer was trying to put across to you. And he had a belief that you were not in a powerful position from whatever his discussions with you were. He felt that you were in an unempowered position in that regard. But it sounds like the last thing that I saw was on Exhibit 8 was a September 16th, 10:30 a.m. Transmission to him saying, "Hi, Lewis, I have finally decided To stop all this, I no longer need your representation. Thank you, Tina Sater. And Mr. Snyder responded at 11:03 a.m.
Maybe
I
got it.
understand, Tina. Be careful and good luck, Lewis. So I felt that that was pretty clear that you were saying, I'm ready to do this on my own. If that's the way you feel, you have every right to do that. And at the time that you did that, he had filed a motion. So it's up to you. The report is out, so I know what
Really?
it says. And I think all the information is present at this time.
The only reason I'm playing this is because supposedly one of the
Today?
attorneys goes really back and forth with the judge, and it gets kind of heated.
That's
So
what she said, Your Honor.
A judgment, like,
Interested.
yes.
Are you saying you want to enter the decree?
Yes, we came to an agreement. I want everything on the table, though, as it is. Like, just that's why we're here. That's why we've been here for months, to figure out the finances on his side and what is fair. I don't want to fight. I want to make.
You're saying two things to me right now. You're saying we have an agreement.
Hey,
And
Sean.
I
I
have
want-
an agreement, and yes, I did sign it because I just want to make peace. I don't want to fight, and he could take whatever debt. And I agreed on the child support. Yes, I did. I did agree on that.
No, I
He
haven't,
can have
JT.
the house or the business or whatever.
Are you on anything right now, medicine or anything? No Xanax or benzodiazepines?
Bentos.
I just don't want to fight. I feel like whatever else it may be, like, we're not going to get along. And our kids are important.
I can't hear
Our
what.
kids are important to both of us.
And what do you
I
think?
don't feel the need to fight over money. As crazy as that may sound.
Your Honor, I have to make some representations. I spoke with my
Wait,
client.
there was a question pending by the court as to whether she's represented by counsel or not. Can we get the answer to that question? I had a request for a closed hearing, and now
I'm very concerned. I feel like there's been undue influence in the case behind the scenes in plaintiff's counsel's
based on
office.
what?
Behind the scenes in plaintiff's counsel's office.
And set it for an evidentiary.
My understanding is plaintiff himself called Anthem Forensics and asked them not to publish the report, not to send it to the judge's chambers. Is that true, Dad?
No,
That occurred after the parties made an agreement.
we signed
That
the
was
decree on.
after the decree was signed.
We
Let Brandon.
I
Let
have copies of
Brandon.
the emails from Anthem Forensics. Would the court like to see it?
Uh-oh.
Thank you.
Thank you, Judge.
You know something, Judge? If Anthem had found anything, maybe that would be relevant. Anthem's report.
Jennifer, your client filed an affidavit on April 4th, 2016, swearing that his gross monthly income was $15,000.
Right. Did you look at the asterisk that says how that calculation was made?
Yes, Jennifer, and I made a finding that day that it was over $20,000.
Right, because
Because
the
he lied.
Okay, so first of all, the judge is referring to the plaintiff's counsel by her first name, which is pretty, in my opinion, that's pretty unprofessional. So, I feel like we're caught in the middle of something, and it's okay. This might actually get kind of spicy. Oh no. Uh-oh. This is gonna get spicy. Oh yeah, I forgot this.
well, hold on. What did he lie about? The discrepancy was.
I'm gonna deal with this counsel right here. I'm not gonna have you swoop in and change the whole dynamic of this case, all right? If you want to supervise Mr.
gaslight
Levitt,
me.
you can, but I'm gonna deal with these people because it's already enough of a quagmire, and I don't think you have any right to come in and change the dynamic. So if you want to say something regarding the case, then honestly, file something. Because right now, I'm going to deal with these people. They have enough problems. There's enough ethical problems here. Don't add to the problems.
How? Just with all due respect, I am the principal.
Don't say
of the
that!
firm that
You've never
Mr.
appeared in the case.
Mr. Sater.
Never appeared in the case. These guys are pointing the fingers at each other, and I'm trying to resolve that problem and get to the merits of this thing. My understanding is this
Hey, Mike.
wife
How you doing? Or Mike
has
Goat, I
been
should say.
pressured to sign a decree
Uh-oh.
Ask her.
that has no spousal support and no piece of a business, where this husband, after 14 plus years, is currently earning an annual net between 163,489 and 172,595, and she gets no piece of the business and no spousal support. Correct? That's what my understanding is. Is that the decree you had her sign?
Your
If
Honor,
that's
that
not an
does
ethical
not-
problem, I don't know what is.
That actually does not accurately reflect the entirety of the agreement, no. It does not take into account the debt that is being taken on by husband. It does not take into account the obligations that are being assumed by husband. It does not take into account her earning capability. It does not take into account the attorney fees, the expert fees that were had to incurred, that this court already indicated would be divided or reassessed at the time of trial.
Well, I hope
But-
it's all laid out really well for the court to take a look at, because I have some real concerns about it. And the court is charged with making sure that justice is done and that it's
Yes,
fair.
I couldn't agree with that more, Your Honor. And
And
that's
I will be
really what we're
checking
looking
that
for.
very closely. So make sure if it's not completely within the four corners of that document, that I have something describing how that deal was made, because I won't be signing it unless I can see that.
Then why don't we go ahead and schedule it for a prove-up so that both parties can testify as to exactly how the terms of the agreement came on. Because I never am going to submit a decree where there's going to be any question as to the validity of the decree. If you have any concerns about that, schedule it. Well,
To me,
we
this is
actually-
not a case where there would be no spousal support. No way. Not a case where there'd be no peace.
Have you heard the evidence in the case?
I've been
my-
reading this stuff. I'm the one who ordered a forensic accounting, which your firm poo-pooed for over a year and didn't get one done, saying, I said if needed, even though the order was clear, it was ordered.
Uh-oh.
Your Honor.
Ordered. Okay?
Can
To
I
talk about ethical problems, that is an ethical problem.
I take any challenges to our ethics very, very seriously. So if there's
Then if you want to point
Excuse me,
fingers over
I was in
here,
the middle of a sentence.
the ethical problems in this case lie on this side.
No! Oh no! Oh my god! Oh wow! Whew. Man, I suddenly struck gold. This is wild. This is what is this case? Hold on. This is from Veterans in Politics. It's Jennifer Abrams, Nevada attorney, attacks Clark County Family Court judge in open court. That's the title of the video.
Side of the table. That's where they lie.
Okay.
Your client lied on his FDF. Your client did not do a forensic accounting when it was clearly ordered. I had to basically order it more than one time. He did not want to disclose his income. That's what happened.
Let's do this. The question on the table was, is she represented by counsel? We were gonna
Jennifer,
address
I'm the judge, and in a moment I'm going to ask you to leave. I'm going to take care of this hearing, all right? You're not going to come here and waylay anything today. I'm going to deal with these people, and you're not going to waylay anything. Unless you have something
people?
new to add, I'm going to ask you to sit down. Do you have something new to add today?
I do have one question I'd like the court to disclose. Is there any relationship between the court and Mr. Schneider that should be disclosed on the
No.
record?
I have no social...
Oh wow! Oh no! Woo! That's funny, Sean. Oh my god! I think you sent that to me ages ago, and I completely forgot about it. I'll have to. You know what? I'm gonna. I told myself I'm gonna start doing this. I'm gonna put a note on my to-do list right now. And then Roger Stone. You said it was a deposition, right? Roger Stone deposition. Deposition. Video. All right. All right. I put it on my tasks.
Social relationship with
That
Lou
could
Snyder.
have even the appearance of impropriety.
Absolutely not. Absolutely not. I've only seen Louis Snyder in court, just like I've seen you and Mr. Levitt. That's it.
I appreciate the disclosure.
I just find this entire thing to be ridiculous. And your firm does this a lot, attacks other lawyers and try to get the facts of the case and the substantive issues and the merits of the case mixed up with other behavior of the lawyers.
What is the basis for that statement?
I'm not going to mention other cases like you guys do,
How many-
attaching something from another client. From Bryce Duckworth's case, that's also unethical.
How
in my
many
view.
cases? How many cases has that occurred in that you're referring to? One that you ruled in my favor because there was unethical conduct on the other side, correct?
No,
Is there anything
not
other than
one,
that?
and I'm not going to bring them all up. I'm just saying I find it to be a pattern for you and your firm. And I'm not going to sanction it here. I'm not going to allow it to happen when I'm asking them, just let it all go and let's get focused on what needs to happen in this case, which is looking at the merits of the case for a change and moving toward what needs to happen, making it fair, not wearing her down to the point where she just lets it all go and says, I don't need a piece of the business. I don't need a piece of any spousal support. This is not a case that she should have nothing. Honestly.
The legislature and the Nevada Supreme Court put certain rules into place for a reason. We never file anything without a legal basis. We gave you the legal citations. It's NRS 7.085 or 065, whatever it was. The case law is all set forth in there. We have not asked for anything that our legislature and our Supreme Court have not specifically authorized us to ask for in exactly these circumstances. Those rules and those statutes were put into place for exactly
What are
this
you
type of
talking
reason.
about?
Okay? You're complaining that we filed a motion for sanctions based on misconduct, and you're saying that that's somehow unethical on our part. That's what Nevada law says we should do
Jennifer,
under these circumstances.
if there were going to be sanctions about something that
Jennifer.
really mattered right now, your client should be sanctioned, all right? That's what I took them back there to talk about. If anything was going to be weighed in the balance of why this case has been delayed or unnecessarily caused excess litigation, it was because of your client's behavior.
How is that possible? Your Honor, you appointed
I have
Jeff
made those
Nash.
findings earlier in the case.
I'm not aware of that. The
No,
court-
because you haven't
the
been
court-
involved,
There was
except
a
maybe
there
in the
was a-
background, apparently.
There was an order that was submitted without us having the opportunity to look at it.
You're right
okay?
now multiplying these proceedings. These guys know what's going on.
Okay, you know what? You're going to make allegations, just for the record.
You're taking up time because you're trying to come up to speed on a case.
No, I'm not trying to come up to speed on the case. Let me just make my record, and then I will sit down and I will be quiet. Prior to the beginning of this hearing, Mr. Levitt and Mr. Schneider were called in the back for a private conversation with you. I specifically asked A for that conversation to take place on the record. My request was denied. I then asked if I could participate in the conversation. I was specifically told that I am not permitted to have any participation in this
Between the two
conversation.
of them and me.
Some conversation took place where I would like, if the court would indulge, explain exactly what it is the message was that Mr. Levitt was supposed to deliver to me, because it's not exactly clear as to what that
The message was,
was.
I can go through and rule on these motions, but my ruling is not going to be favorable to his client. It's going to be findings regarding who has caused the excess delays and caused the litigation to cost more money and multiply the proceedings is going to be the plaintiff.
We could set that
And
for
that the
evidentiary
plaintiff,
proceedings.
and that the plaintiff, no, that you're going to do that to your client? I gave them a practical solution. I said, you can just withdraw all this stuff, get focused back on the merits, and sit down and take a look at, now that you have this forensic accounting that came in after apparently she signed a decree without representation, and see whether that's the fair deal, and look at it whether or not that's what she really should be doing. That is what I told them to do. Think about that. I said, go out and talk to Jennifer if that's your, she's the owner of your firm. That's your supervisor. Explain to her, this is what I've given you a choice of. If you want me to hear these motions, I will. I've spent a lot of time with this file. I have no problem, and this is what I'm going to rule. If you want that ruling, I'll make it. Or you can just withdraw everything and focus on getting it done, getting them divorced based on the merits of the case, not pressuring this girl until she doesn't have a lawyer anymore, which I presume is between the two of them, the husband and the wife, mostly.
Well, because I'm making my record, but because of the allegations and the conclusions that have been made by the court, my personal preference is we set this for testimony. If there's going to be a stipulated decree or not, I want testimony on the record, because I'm not going to allow conclusions to be made when there's been no witnesses on the stand. We have not had the opportunity to present any evidence. We were prepared to do that last time, and for things that should have been addressed on cross-examination when it was scheduled for trial. This case was scheduled for trial. We showed up with an expert. Okay? We showed up with an expert ready to testify.
The forensic accounting wasn't done, Your Honor. That's why the trial was continued. Before it was
Oh, you mean when your client failed to follow my orders that day?
From the joint expert who Anthem has said we would make no changes to that expert report? Yeah. Other than the kids' cell phone bills. That was the big... That was
all of Exhibit 2 means nothing to the forensic... I mean, honestly, Jennifer, I don't read the report the way you read it, okay?
Jennifer.
Really? Let's see.
Your client plays fast and loose with his personal and business expenses.
The level of talkback is wild.
Says that he plays fast and loose? Where does it say
I'm
that?
saying that. Bottom line,
Great. Let's set it... We're going to be here for the evidentiary proceeding.
Your Honor.
I'll decide that, Jennifer. You're not the judge.
It's on...
Run if that's what you want to do.
It's on
You're going to be taken out of here if you continue with this kind of behavior. So please sit down.
Your Honor, before I was interrupted by counsel, my client asked me to make this representation, that she wishes me to stay on this case so long as we stick to the facts and the financial issues. I am not to make any attacks on character or assassination to the father of her children. And I can abide by that. Is that correct, Gina? I'm sorry.
Yes.
So I will withdraw my motion to withdraw, Your Honor. I will stay on this case. I will try to resolve it. I will not make any character assassinations of Mr. Brandon Sater.
Mom, is that you're sure that's what you want to do?
Yes. Well, yes. Yes, you want represent. No, later. Say yes. You want representation.
Been through a lot, Your Honor.
No question about it.
I think it might help if the court, in light of all the new information that we have here, made some temporary orders so she has some idea where the court's going with this matter.
There's no motion for temporary orders on file right now. That issue's not before the court, and we cannot address it now.
That's a good point.
I don't need to make any temporary orders right
I just want to be done. I don't want to be represented. I just want to be done. I'm done.
Oh my God. Don't do.
I'm
Look.
reluctant to leave this case, but I leave in
now.
trust.
I've never seen anything like this before, where somebody is so not sure about what they're doing, which doesn't, I mean, she doesn't seem to really have a settled purpose, what she's trying to do.
Okay, I'm kind of a.
If she wants to be done, I suggest that we prove up the decree now and get them divorced so that she can not have to deal with this anymore.
Judge, I won't participate in proving up that decree.
I wouldn't allow that today at all. She's so emotional. There's no way.
Oh, what?
She can't make a contract right now. Is that what you think she can do?
We already made a contract, Your Honor.
That's not correct, Your Honor. That's not correct.
Oh, no,
It's
that's
before the
correct.
court. It's up to the court whether or not it's a binding negotiation, or whether it was made equal bargaining power of the parties, Judge. I was not present.
That might be. That's probably more accurate.
Still not seen it. I am still the attorney of record as this moment.
She fired you as of the 16th. And she came to my office of her own free will and accord by herself, drove by herself. She showed up at my office. We spent 4 hours discussing this matter. A decree was drafted. She signed a disclosure of self-representation that she was doing it of her own free will and accord. That language also exists in the decree. I spent 2 hours explaining it to her. Your Honor, ask her. Again, if it's this court's direction that you want to have an evidentiary proceeding on this, fine. But her testimony is going to be the same. She wants to be done.
That's what your boss wants to do. I didn't say I want that. I want to be able to look at the decree and I want to be able to see the breakdown.
Okay, I'm not having fun. Oh, okay, I'm having issues with the judge now. I feel like the judge is letting her personal animus towards Jennifer is, I don't know. I think the judge and Jennifer are really making things personal right now. So again, I kind of wish there probably is a precursor to this, but it sounds to me that the wife wants to, at some point in the proceedings, the wife is like, I don't care anymore. I want this done. I don't want an attorney. I just want this decree done and get on with my life. The judge is suggesting that there's a potential implication that she was browbeaten into signing this decree. The male attorney for the father is saying, no, she came over here of her own accord. I spoke to her for several hours, telling her about her the risk, or the risk and obligations about self-representation. There is basically speaking the case that she was not browbeaten. She did make this agreement of her own accord. It feels like the judge has some sort of personal animosity towards the boss of the firm, which I believe is Jennifer, and is, I guess due to some prior history, and is saying, nah, I'm not buying it. I grant you, Devin, I agree with you that him being the attorney and she being the opposite party, there's going to be issues, and that's the reason why the judge does have an issue with it, because based on the terms of the settlement, it does sound like the wife is getting almost nothing. It's based on the limited summary that we've heard so far. It sounds like the wife is not getting much of anything. And she's also pointed out that she had to set out a court order to force the husband to give up all of his finances to determine what his income was. I feel like there's a lot more to this than to say that one party is right or wrong, which is usually how these things operate in family court, sadly.
Of how the firm determined that it's fair.
Well, it's fair to my client.
What's his latest? What's the date of his latest FTF? His most recent, meaning.
Just a minute, and I'll tell you, Your Honor.
His FTA.
I don't think I even have it right now.
I have it, Your Honor.
It was last filed, Your Honor. Sorry, my phone's trying to download here.
December 14th, you want to approach?
Yes. December 14th? That would have been before the April 4th?
April 4th, 2016.
That is the one that I have. That's the one I was working with before. I thought that wasn't the last one.
April 4th, 2016.
That's the one where he said 15,000.
No, that was the one where he wrote 20 because that's what you wanted.
15.
Was it?
Was
Sorry.
it?
You're right.
Hold on a second.
Oh, whoops. Whoops.
But this is the same one we worked with. I thought there was another one that he corrected after this.
According to my office, April 4th is the last one that we have on file.
So we worked through this on the record, and I have notes here that show that without his credit cards, I can't tell, because actually, I think I was still buying into I was buying into what he was saying, and I show a net of 9,000. So this is wrong. I'd have to look at it again.
Again, the question still pending before the court is, does she want to be represented at this time or not?
Your Honor, my client would like to hear from the court about what your findings are of the forensic accounting.
Well, I'll tell you what I think from the forensic accounting and what was attached to the plaintiff's April 2016 financial disclosure form. The wage statement ending March 19th, 2016, excuse me, showed a year-to-date of $56,650, and that divided by 2 months, 0.61290, based on the 19th of the month, would give him $21,680.89 gross per month, but that was early in the year. And then looking at what the forensic accounting shows, at the 19,213.63, so that there, I would have to believe there's a gross of somewhere between 19,203.63 and 21,680.89.
That's gross or net?
And a net between
Oh, there we go.
13,624.10 and 14,682.98.
Okay, that's net.
And I haven't done any math beyond that. I don't even remember what he's
Maths.
paying child support.
He's paying the cap, Your Honor, at $4,360.
Happy birthday, Deacon.
I show 2,182. Is that just half of it? Or is that the whole?
He's paying $4,360 a month. I don't know if he divides it over 2 monthly payments, but I know it's $4,360.
Oh yeah, he does. It's 2 monthly.
Okay, because I show he pays 2,182, one half on the 5th, one half on the 20th, so that could be wrong in my notes. So that's a lot more than I thought he paid. Okay, in the minutes it's right, in my notes it's wrong. Okay, so that would reduce his net to, hold on, let me just do a little math here. Is mom working?
No, I'm going to school full time. And we discussed that, like going to work or whatnot, but that's not possible. I mean, I have the kids during the week, and if we have an agreement on flexibility with the kids that I wouldn't be working until I finish school in May. And I'm paying for that. I'm alone.
So after he pays for his child support, he has $10,022.98 approximately.
Then there's the $5,000 payment of the stock purchase so that there is a business to buy or business to generate income from, which he pays to Patrick Bailey and has for the last 3.5 years, and that note is concluded in 2025.
I thought that was paid as part of his business expenses.
It is not. It has to come from his personal earnings because it's a stock sale. We said this and addressed all of this at the last hearing.
The last hearing, I just yelled at you guys for not getting the forensic accounting done.
Your Honor, essentially the reason for it is that the person who he bought the business from doesn't pay taxes on the amount of the monthly payment. Our client pays that amount post-tax, which is why it was done like this. So it actually costs him, his
Hey,
taxes
Dimmer.
look like a higher number because he's
How
paying
you
tax
doing?
on all of it. And post-tax, he makes the payments to the person he bought the business from.
Correct. It has to come from his personal account. The business can't buy itself.
Which is true.
So in other words, they're avoiding the long-term capital gains on the sale of the company.
That was
And
the
it's
terms
just-
of the deal. It's always been the terms of the deal.
It's fraudulent.
It's not, Your Honor. See, this is the kind of thing. How would you like me to
Fraudulent.
respond to that? He's saying it's fraudulent. This is an agreement that was done years ago. She knew about it. He knew about it. They had their accountants and lawyers or whoever else was involved in the transaction. It's done so that he bears the taxes. The adjustment would have been made, it would have cost more. He would have had to pay a higher number if it wasn't going to be post-tax. They worked it out with their accountants this way, and then we have Mr. Schneider stand there and tell the court it's fraudulent. How would you like me to respond to that type of unfounded, unsupported allegation, direct attack against my client?
Your Honor, if there's a long-term
I asked a
capital gain
question.
on the sale of the company, then he's required to pay a flat 20% to the IRS and a capital gain, long-term capital gain on the sale of the company.
He
What
who?
they're doing is they're doing it net behind the scenes, and I don't know that, I'm telling you right now.
Does
that-
Mr. Schneider have a degree in accounting or in tax preparation? Does he have an LLM? Does he know
I was
what
gonna
he's
say,
talking
I don't
Hey,
know enough
oh,
about
I'm
this
doing
without
okay.
having it briefed for me to speak
Yeah,
to it.
me either.
But it seems like if he's paying the business out of his personal income, then, I mean, it puts him in a situation where he's not going to have much left for his own expenses.
Correct.
It has to be that way. It has to be that way. The business cannot buy itself.
That's,
He's buying the stock of the company so that he can own it. It's a stock sale.
and it's a legitimate right. What they're doing, Your Honor, is avoiding
Most
the
businesses buy themselves.
No worries,
Most
Brad.
businesses pay for
Your Honor, I've bought and sold businesses. I know what's going on here. You start a company.
Is he testifying now? Is he testifying now?
I think he's
Your
just
Honor, is she
saying
gonna
that
keep
it's
interrupting
possible
me?
to do it.
Is he going to keep making stuff up and telling the court?
I'm going to have more information about that because I don't know that it doesn't feel fair. But if there's an explanation that makes sense, I'm open to hearing about it. I kind of remember hearing about this in the beginning of the case.
If I may, this was something that was addressed in Jeff Nash's report. He was the initial joint expert that was appointed by the court, that was selected jointly by both sides. He conducted the analysis. He discussed it. He's got a section in his report where he talks about this. He's looked at the contract. I believe he even spoke with the accountant. Okay? Did he speak with
The accountant's affidavit is on file,
Oh
Your
yeah, the
Honor.
accountant's affidavit is
Who
even on
set
file.
up this whole deal and why?
All of it is explained by the accountant in an affidavit for the court.
It's not in this affidavit.
It was filed in.
All right, I'm gonna be real here. This is out of my this is definitely above my pay grade. I really don't know a whole lot about business purchases, like wholesale, like buying entire businesses, selling entire businesses, especially like public dealings with like private corporations like that have like shares and stuff. I got no idea like who's right and who's wrong on this, to be honest.
In an affidavit.
I'm talking about the financial affidavit from April.
Your Honor, I'm looking at Jeff Nash's report.
Hold on, I'll get it.
Where is it in his April affidavit?
Whose April affidavit?
Your client's
No,
April.
no, no. We have an affidavit from the accountant.
Who actually put this deal together 3.5 years ago?
Correct. That was filed with the court.
I was gonna say I need JT for this.
Buying and selling the company is. He owes long-term capital gains on the sale of that company.
Oh,
He's
so now the
avoiding it.
seller of the company is doing something
Will
wrong.
you stop interrupting me?
You guys are making this so bad when really we just need to understand everything well enough to determine what the information is, what's true, what's not true, what makes sense, and make a fair deal. Make a fair distribution of assets, make a fair deal whether there's enough for spousal support or not. It's very hard for me to believe that someone can make this kind of money and have almost a 15-year marriage and not have any money for spousal support. But he is paying a lot more for child support than I thought. My notes were $21.82. but I think that it got transposed from the minutes as half, and then I was splitting that half and half. So
Find out when the
she's
affidavit
getting a
was-
lot more in child support than I
I
realized.
just emailed Stephanie.
Okay.
She's going to send me a copy.
Okay, perfect.
So, Mom, what are your expenses? What are your total expenses?
Oh,
What's your latest, what is the most recent FDF you filed? Financial disclosure form? The last one you filed was,
oh, I think it was.
I just want to look at it really quick
The blank one?
to understand what you're trying to live off of and what you're trying to pay.
I don't know. I just go off of the child support they gave me, and I was completely fine with that.
It seems like you're on something to me because you seem like you're slurring your words a little bit.
No, I just talk really quiet. I'm
It's
fine.
okay with me if you are on something like medicine or something. If you're on benzos, a lot of people get benzos when they're going through a divorce. I just don't want you to make decisions if you are.
I just want us to be fair, like you said. Just I don't know what's so hard to get everything out in the open because I just wasn't. I didn't know everything. He just took care of everything during the marriage.
I know. That's why
That's
the
just why I want it
empowerment
out
issue.
on the table and just be.
The empowerment issue is important, and when you're going through a divorce and you've loved somebody in the past and you've trusted each other, the thing is when you get to the court, you're adverse to each other, you're adverse parties. So I need to make sure that you guys are both fully informed and have all the information so that you can each make decisions if you're going to settle it, and if you don't settle it, I have to do everything equal. So the court has no leeway. You can settle it however you want. However, if I don't feel like you've been fully empowered or given all the information, I have, a lot of concerns about signing something. If I think you know everything and you're out there feeling pretty empowered about it, I'm not going to second guess you. But I don't necessarily feel that right now. I'm trying to get there, but I don't really see that at this moment in time. And I'm trying to understand how you're going to get by on child support.
At this point, I don't know.
I mean, that's what you're getting, correct? $4,360.
Yeah.
And do you know? I mean, your rehab plan. Is that where you're going to school doing your rehab plan? You filed
I'm
that
going to school, to be a cosmetologist.
March.
Yeah, full time. I changed it, sorry, because I just started school in July.
Those are ships for sale. I only have my
So, I mean,
Starborn
working
ship and
having
the
to come back to
original.
School, I just don't see when that is possible. And Mr. Sater is.
That was the funeral thing, right?
It was. I started that, and then I decided just to go to cosmetology school at Euphoria, and that's what I'm doing from 8 a.m. to 4:30 Monday through Friday.
And you'll be done with that when?
May 6th.
And then you can make about what?
I have no idea. It's kind of complicated how you go in and you have to train, and they kind of get you a job. And you have to train, and they kind of get you a job, and
Is it for hair, for nails, for?
for everything. Yeah.
And is it something that you're looking forward to, that you
Yeah,
want
it
to?
is. It is. I'm just kind of seeing how it goes. It's just how it is.
And so he's been temporarily paying you what now?
The $4,300 a month, $4,361. Yes. On the 5th and the 20th,
And
he's on time.
how are you? That's good. How are you doing with that?
It's good. It's hard, but like the decree that we signed was that he was going to take all the debt that I accumulated, the credit cards that I had to open because I didn't have any money at the time until December, and I left him in August, so I had to like clean houses and for
How
me
much
to have
debt?
stuff in my house. I told him that to take those credit cards, like the stuff that I bought.
Approximately
Like, I've never taken anything out
$60,000.
of the house except maybe some clothes, but other than that, I had to get everything kind of furnished and be comfortable with our kids. And
So how much debt do you recall having on your credit cards?
I think it was all of it in my name was $4,500, but then I accumulated probably $3,000 since I.
He says 60,000.
Total. That's That's
But
her
these are
community
my
debt
names.
during the time of their marriage as well.
Well, yeah, but the ones
So
that are
60
my
grand
name is-
total.
Yeah.
Between her separate charges and the community debt that they acquired during their marriage. He's taking all of the debt,
Yeah.
approximately 60 grand.
Your Honor, the $5,000 per month that gets paid to the prior owner, there is an affidavit, it's attached as Exhibit 7 to the motion for reconsideration that was filed on May 20th of 2016. That affidavit is 3 pages long. It is
I'm
from...
not going to look at that right now because that's a complicated thing that I can't think about while I just want to look at what her income is, what her expenses are, what his expenses are. That other issue is something I need to understand in terms of stocks and capital gains and whatever. That's not something I have time for. I have drug court at 1.
Sure.
And you guys are going
I
to be
don't
out of
think-
here in about 5 or 10 minutes so that my staff can have a break before drug court. And honestly, what I would recommend is she at least maintains Lewis long enough so he can look up this stuff and make sure that there is enough money for you. I mean, if you feel you can be comfortable, it's one thing. And he needs to check on this $5,000 issue because that's what really puts him out of the league of being able to give you anything.
Well, that's what I think. I don't know what to believe.
If he has to do that, then it comes down to whether you have a need and does he have the ability to pay, ultimately, okay? Because the marriage isn't short, but if he does, if you have, I mean, maybe you don't have a need. I don't know because I haven't been able to even figure out when your last FDF was. Can you check that for me? Did you ever file one? A financial disclosure form?
I did a while ago, but it's changed, and so I didn't know I needed it.
She did file one, and she was in the positive to roughly $2,300 after child support was paid.
Oh, here's one.
She was in the positive, Your
had
Honor,
it.
with child support alone.
Yes, but I do a lot like shopping, and I mean everything kind of seems to add up. And I know I'm trying to work on my budget and everything, so it's not that like I have a positive and gas and me going to pick the kids up in Henderson. I mean, I'm not trying to be nitpicky or anything, but it's not like it's extra. Like I'm just woo. It's all.
Ooh.
Okay, are you still? Let's see. Where were you living in March of 2016?
At Woven Memories, where I'm renting now.
So you're in the same place when you filled
Yes.
out the affidavit?
Yes.
And so are your expenses about $3,113?
It's probably gotten more because I've got like a couple more credit cards that I'm paying, and then like the medical bill that I'm paying, just extra expensive.
Of which he's taking those credit cards.
Yes, and he agreed to take everything that I had, like so I would have extra and I could be able to.
My mom always said,
That doesn't include what's on here for the kids, but that's another 1, 2, 3. That's another 1,000. But that still would cover it. And you have the car, the Dodge,
Yeah, that I pay, and then he pays my insurance and he's paying my medical right now.
and you're going to keep paying that
Yes, ma'am.
on top of giving her the. I mean, how long are you going to do that?
I'm going to do my best. This whole situation has put me at a point of breaking the business. I'm personally bankrupt. I'm up to debt to my eyeballs, and I'm doing the best I can do to follow your orders and support Tina. And I just don't have it. I live paycheck to paycheck, and after all the credit cards are paid, I have it takes almost an army to just pay those on time every month at the minimum payments. So I'm treading water as long as I can.
so, where I was on the math. Well, it sounds like while this guy does have some, it certainly has income, they're also suggesting that he's taken on all of their credit card debt, which probably puts a damper on what his net income is.
He also owes our firm $35,000.
Just so the court is aware, Mr. Schneider's been paid $25,000 from Mr. Sater. We've been paid less than 20.
Okay, what I would recommend is this, that you look into this deal with the 5,000. Figure it out. Don't take a lot of time on it. Just try to understand it. Look at her expenses and look at his expenses. And at a minimum, I would ask you guys to agree that you do $1 a year for half the marriage so that if anything changes, that she's protected. Because honestly, that doesn't hurt anybody. I mean, it basically puts her in a situation where
I have no idea who's right,
the business
wrong.
is paid off and it's still doing well. I mean, it didn't buy this business that long ago. It's not something that they've had for the whole 14 years. I know that. So honestly, I just want it to be fair. I don't want her to make a decision when she's under stress or pressure. I feel Lewis had a view that she was kind of in a situation where she was kind of a battered person in terms of emotions and mentally. I'm not making a finding. I'm saying this is what he perceived. And so I don't want her to be someone who is just kind of folding her cards and me not knowing if it's a fair deal. So that's what I don't want to happen.
I'd like to address two things. Number one, I don't think Mr. Schneider was challenging the fact that the $5,000 a month has to be paid. I think he clarified by saying that the person who's receiving the $5,000 is not paying long-term capital gains on his receipts. But other than that, we have the affidavit. I don't think the $5,000 is an issue. Correct?
And I don't know why it can't be paid from the business. I've never heard of it.
It's explained by the accountant. This is the accountant, Shelby Kiefer. It's attached as Exhibit 7 to the motion for reconsideration. If I may, I'd like to clear this up, because if we can get this resolved now, then we can just be done with it, okay? So this person is the accountant for Harmonic Enterprises when it was owned by Patrick Bailey, okay, and is continuing to be the accountant for Harmonic Enterprises. That it says, it is my understanding that an issue has been made regarding the $5,000 loan payment that Mr. Sater pays out of his post-tax income to Mr. Bailey for the purchase of Harmonic Enterprises. I was requested to provide additional information explaining why the payment is set up this way. In the corporation structure, the corporation owns assets, and then it goes on, it talks about C corporation and income tax purposes. I don't know if the court wants me to belabor all the technical details of why this business...
I've never heard of such a thing. It just doesn't seem right to me that a business can't pay for itself out of its own receipts and not have to come out of the personal income of the...
In a stock sale, the buyer purchases the stock in the corporation from the owner of the stock in the corporation. It is a transaction between the individuals and does not involve the corporation itself. The transaction is taxed at capital gain rates to the seller. So Mr. Schneider is incorrect on that. And the buyer has a capital asset. In an asset sale, the corporation sells its assets, recognizes gain or loss on the sale, pays any corporate level tax due, and then distributes the remaining cash as a liquidating distribution to the stockholders, who then pay taxes on any gain, hence the notion of double taxation in a C corporation. So what it sounds like to me is that it was structured this way to avoid double taxation because it's a C corporation. Or at least that's what paragraph 9 is saying.
And there was an
There's
offsetting
no
royalty.
reduced capital gain tax. Look, for whatever reason they did it, this was done 4 years ago, okay? Way before any of these proceedings started. Jeff Nash looked into it. We have the accountant who talks about it. I don't think the court or anyone here is in a position to say, let's retroactively go and attack this thing. It is what it is. It's been a $5,000 payment. It goes till 2025.
Something like that. Yeah.
Approximately.
Okay, roughly 2025. And the reality is it's an amount that needs to continue to get paid. And there's never been any legitimate attack on the validity of this thing. How it's set up, the accountant deals with that, but do we care? What difference is
Well, it might be better if it can come out of the business, if there's no reason why it can't.
It can't. They have an agreement. They have a contract. He's under contract with the person he bought the business from. The contract goes on until 2025. If he defaults on it, he loses the business, and then there's no income.
And until September of this year, I believe it was September, there was an offsetting $5,000 royalty payment each month. that Mr. Sater was collecting. So it's just now that he's paying that $5,000, and it's a net, and it brings his income down.
The only other inquiry I would say that if we were having a trial that I'd be wanting to ask questions about is Exhibit 2 to the forensic accounting, and whether any of that, not the other guy, I can't remember his name, it starts with a B,
Patrick Bailey.
not what he's spending, but whatever you're spending, and it doesn't look like a lot of it, like maybe the ATM or stuff like that, where, is travel costs, is this something you would spend because you're doing your business, or are you just getting cash because
Can you explain that to
I don't need it right now. I'm just saying that's what I want Lewis to just take a look at that stuff, and so he can advise his client that he's pretty much looked at it, and this is probably the best it's going to be, or he's looked at it, and maybe we should ask for X, Y, Z and see how it goes. I don't think this needs a trial because you have all the information, but I don't want it to be one-sided. Yes, Dad?
I just wanted to say, I mean, out of all of this is 2 years of transactions and business there, and we've went through and we've gone through, and any issue that was had, I've been able to explain, and I can gladly explain. This is
Right.
over 2 years worth of 4 business credit cards, and at the most we're talking a couple $100. I mean,
That is substantiated by the forensic accounting.
So, Your Honor, if I may, I think you're referring to the meals and entertainment. Is that what the court's concern is?
Yeah, and the travel, the things that they outline in Exhibit 2 has all of them in 7 pages.
Okay.
That's what
Okay. So.
Gets for the
Okay.
I do have a
employee.
question.
Have a
They
seat,
show the
please.
payments to me. They've received $20,000. That doesn't appear in the forensic accounting. It doesn't appear in any bank account. I'd like to know how that was paid.
I think it talks about it and says it was prior to when the Nash's report was done, and so it wasn't included.
Your Honor, these are the findings from the forensic analysis that was done that reviewed Jeff Nash's report. No payments to personal credit accounts from the business accounts. That was a big issue that was made by Mr. Schneider, and that concerned the court, and the court said, look, if you're
I
paying
have
your
no
personal
idea.
credit card out of the business, we need to know about it, adjustments need to be made. This, number 2, on page 6 of the report, no payments to personal credit accounts from the business accounts. Everything matched. Number 1, it talks about the deposits and how the deposits reported in the general ledger match the deposits in the business bank accounts. So there's no question of deposits not being recorded. Everything was being recorded, is what they say in number 1. Number 2, when those deposits come in and they're recorded, they're not being used to pay personal expenses. Bullet item number 3, that there's no personal accounts that are getting paid out of the company ledger. Okay? So there's no personal expenses that he's listing as business expenses and paying
That's
out of the
not true.
business.
He paid. I'm on that ledger, Your Honor. I'm on
It
that
says
ledger.
it right here, number
That's a
3
personal
on page
expense.
6 of the report, Your Honor.
That's a personal expense, Your Honor. It's not a business deduction.
The $10,000 that was paid to Lou Schneider?
Attorney's fees is a personal expense.
Okay. But that was not included. That was not included in Jeff Nash's report as a personal expense, and they acknowledge that. Okay? And that is not number 3. That's a different number. But for number 3, there's no personal expenses that are listed as business expenses that are paid out of the business. Item number 4, no transfers between the business and personal accounts other than payroll direct deposits, which has to be because that's how they do it for everyone who receives payroll. Okay? So these 4 items are talking about how well the business books are being maintained. What comes in is being accurately reported, and what goes out is being accurately reported, and they did not find any discrepancies, any personal cards, or any personal expenses getting paid. The question was that you're referring to is the meals and entertainment expense.
The gray area.
And let's look at the gray area. What they say about the gray area is that you have 2 categories of these meals and entertainment and travel. You have David Barbash's.
The ATM withdrawal. I'm not worried about the employee.
There wasn't a significant ATM withdrawal. I
It
think
was a $200 one. I didn't really
That's-
look at it.
ma'am, that was
Stand up.
That was when I was on the road, and I believe the only thing that could be used was cash for a taxi or wherever the location was. But it was
Chicago, wasn't it?
It may have been Chicago, but it's a
Can you
legitimate.
explain to the
I
court
agree.
what-
It seems like your books are better than most I've seen in the last 14 years.
His books look fantastic. So for David Barbash's credit card, you can sit down. You know, they say that they have no issue with it because David is he marketing?
He's our national sales manager. That's what his job is, to travel.
His job is to travel
I'm
and
not worried about his
Okay.
charges.
So then what you have is you've got the meals and entertainment that Brandon charged, that our client charged. First of all, it's $227 a month average, okay? And I think that's a
Okay.
significant point. That's on page
Aight.
7, subparagraph 6A21. Oh, no, 2. It says approximately $227 a month, okay? He has people come in from out of town. He does take them out to eat, or he has people who who are vendors or who are suppliers
Trade
or who are
shows.
trade shows or this kind of thing. And this is what is significant. It says, we observed meals and entertainment expenditures in Brandon's personal accounts. Okay? So in his personal accounts, he charges his personal meals and entertainment. For his business account, $227 a month average when there's trade shows, when there's vendors, when there's suppliers, when there's business associates that you deal with. They did not state in here that they had any concern that that was a fraudulent thing. What they're saying is we're not going to render an opinion because we weren't there. Fine, fair enough. And I think the court knows that Joe Lau and I is very careful that way. For the R&D expense, I actually spoke with Mr. Sater outside. It says there's $300 that they don't know about. There is a charge, Your Honor, for Lee's Liquor, okay? And we spoke with Jenny, and she said she believed that Lee's Liquor is his personal liquor expense. Your Honor, he uses vodka to boil the essential nutrients or minerals or whatever it is, you explain it, out of roots.
To create an alcohol extract out of roots for the business, for a product we create. And I have to get alcohol, 2 big gallons of the cheapest gut-enriching vodka, because the alcohol boils off through the process. But that's the
Crystal
one
Palace?
expense in 2 years for Lee. That was what that was for.
And so there's, and I can go through it. So for the whopping $300 that she found, that's the explanation for the Lee's Liquor. Mood and Mind were supplies. ZRT Laboratory is a blood test kit to test product effectiveness of dietary supplements, okay? So really at the end of the day, out of all of the things that they say might be in the gray area, the meals and entertainment and travel expense is extremely reasonable, and his personal is found on his personal credit cards, and they report that to the court. And then the other thing was the $300, which is explained. Those are legitimate business expenses. Although, honestly, Your Honor, when I heard Lee's Liquor, I thought, oh my God, why is there a Lee's Liquor charge on here? Until he explained it to me, and I said, oh, that makes sense. You know, when we're not in the business, we don't know these things.
What I would also say is the expenses that he has on his page 4 and her page 4 are very different. Like, he has his food at $1,000, she has hers at $500. He has his credit card payments at $1,200. I mean, his car payment is almost $1,000. Her car payment is $294. There's some things that are very disparate, and that, I mean, if his were more in line with what, you know, a little bit, if they're a little closer together, then he probably would have a little bit more money left over.
But does he have a huge deficit anyway? What's the deficit over there?
And Your Honor,
He has?
After expenses, after the $5,000 payment, and after his child support, he's in the hole roughly $3,000.
Right, so if you look
Based on the expenses he has here, you mean?
well, no, if you just look at what he's left with for spending and what she's left with for spending, she's left with more because of the fixed expenses that he has. In other words, even if it says $1,000 for grocery on there, when you look at the bottom, he's in the hole anyway. So you may as well reduce it to $500, reduce it to $0. He won't eat. The bottom line is that money isn't there. Okay, the problem with the financial disclosure form is that when you've got a deficit on there, I mean, people are going to squeeze.
Why is the electricity at $5.50?
It's a large home.
I mean,
And that was in the summer.
They have 4 kids. They've
Your
got
Honor, we purchased our house, just for a little bit of background for you. I probably shouldn't be talking, but oh well. And I purchased the house and our car within probably 3 months.
Damn, electrical at 550. I think at the height of like summer, or the height of winter. I think my at first this is in Nevada. I have a tiny home. I think the height of winter and the height of summer, my electrical can get to like 125, between 125 and 150. But again, that's New Jersey, and I have a tiny house, so
3 months of separation that honestly Tina says I should have been aware of it was going to end in divorce, but honestly I had felt that we'd always probably work it out in some fashion or another, and those are just expenses that I incurred, and the timing on those, pardon my French, just sucked. And now I'm stuck with them, and now we're going through this. So that's the explanation on the house payment. My latest power bill was $500, and that was last month. And then we put solar on the house. That's $70 a month. I bought my Suburban, which everyone complains about, which she loved, and then we decided to separate.
why don't you guys sell the house?
Because I
there's
don't.
no equity in
There's
the
no
house.
equity in it. Yeah,
He
there's-
doesn't have the cost for moving expenses, for realtor fees, for transaction costs to put on a down payment for a new house, and they won't get anything out
He
of
could
it.
probably get his expenses down to about $5,000. That's all he has left anyway. If he has to still pay.
They will get
That's if
nothing.
I made him had a car that's $300 a month and all of this stuff down to the bare minimum.
Your Honor, my client seems to be okay with holding the spousal support open at $1 a year for now.
I think that's probably the answer until he could get rid of this $5,000 payment.
Honestly, you're never going to dig out of
The
this.
dollar a
Is that
year.
the rest of this then?
Look, we have no problem holding the spousal support as long as he's paying over $4,000 a month in child support, and he's paying the
That's probably the best that you can do.
right.
Your Honor, we're fine.
That's
My
right.
client advises me that she's fine with that, but she's still entitled to half the value of the business, which is $100,000, and she's agreed that Mr. Shaver will
$4,000
stay
in
the
child
house,
support?
sell it at a future date, and they will split the equity at that time, if any.
He is taking all of the marital debt, all of it, plus her personal expenses as well. That was part of the negotiation. She walks
Guys,
away.
I have 5 minutes to drug court, and these guys are union.
Okay.
Your Honor, I'll
What would
submit
you
the
like
court
us
on
to
this.
do?
Let me just ask you this, Mom. Can you do you feel comfortable just keeping Lewis on long enough to troubleshoot a few of these issues to make sure that it's fair? Or do you?
Oh, I was
want
going to
him
ask how many kids do they have? If they have
You
4,
see
then
things that I'm
1,000 for
talking
each
to
kid. Okay.
Everybody about,
But-
and that I'm concerned about. I'm trying to look at your expenses, Dad's expenses, trying to understand the $5,000 payment. Why does it have to come out of his money after all the taxes are out? And it's now his personal money instead of his business expenses, which means it's all he really has left to share with you. Okay?
Yeah, I know.
So I'm trying to figure out why it has to go that way. Because basically, really, all he has is less than $15,000. So if he's paying you over $4, and he's got expenses of over $5, and he's got to give somebody else $5, that's basically all he's got.
And yes. That's what I've been
So
saying.
I'm trying to understand it like that, and I'm also trying to reserve jurisdiction in the event that things get
Jurisdiction.
better, that he pays this debt, that he's able to help more in the future, because it's like all of a sudden. But I mean, if you're able to get by on what he's giving you, but at the same time he's living a different lifestyle than you, I mean, I want it to be fair.
No, and I choose for him to live the lifestyle that he has because the kids are comfortable in in the house, and I don't want him to move. I don't want him to move.
That's
we have
good
a lot of
attitude to
kids,
have.
and it has affected them.
It's a good attitude to have.
I,
Can you just, I mean, I just want him to be able to, I need you to have somebody to bounce ideas off and to basically say to you, are you comfortable with this? Are you comfortable with that? This is what we know. We can't be sure, but this is what we know. Are you okay with that? I mean, it seems like you're kind of done and you want to be out of it. And conflict is like that.
I mean, there's just
I know, right?
there's no more money, and I believe that. I mean, he has a lot of expense in that
I think
house.
I can tell you this. I do believe that he has honestly told everything about his money, and it's been discovered, and there's nothing left to discover. The only thing I'm not really positive about is that $5,000. Jennifer has something that explains it, but we don't have enough time to go through it. I only have 1 minute to drug court. Bottom line, I've got my staff has to have a break. And I just don't want to say, oh, just go forth and be happy right now. I want you to be able to at least have him on long enough to be able to bounce these ideas off so you have somebody that can answer some legal questions before you file your decree. Because if that's all there's going to be, and that's the best that you can do, and he's taking all the debt and all that positive stuff that you feel good about, then that's good. And if these guys are willing to put the dollar for however many years you guys can agree to, that makes me feel better, because
What does that mean?
that reserves the court's jurisdiction relative to spousal support. Alimony, the court can only reserve jurisdiction on alimony or spousal support as long as there's money being paid. And it's a fiction. He's not really going to pay you $1 a year, but as long as it's in the decree, I have the ability to modify it. Alimony is always modifiable. Let's say he starts making $500,000 a year, and that's a whole new ball game, okay? And he can still pay the $5,000 and help you. So, I mean, his business is doing really well. It's a good business, but he also has high debt, you know?
Yeah. Okay.
So I think you guys are really close to making a fair agreement, and I also feel better about it. I don't feel really good that you're trying to make the decisions without somebody in your corner that's a lawyer. And I know there's been a lot of bad blood between the lawyers, and you guys have fought about things and processes, and I've had to yell at people.
Honestly.
But it seems like you're getting to the bottom where you do know the information, and that is the basis of every good deal, is knowing the information. So I think if you could just
it's all a
process some of
corporate
this
fiction.
a little bit more for a couple hours with Lewis, just to get it down, that you feel comfortable that you did make a good deal, that you're not like, oh, hoping you made a shot in the dark and this is the one, and then later you're going to have buyer's remorse and everyone's going to be mad at each other. Because it doesn't matter what you're mad at Dad about, and I mean, you don't want to have conflict. You're going to be parenting these kids for a long time. They're little, all right? So I want you to feel that it is fair about everything. All right? So can you just do that for a little bit longer? And then if you guys get this decree done, you can vacate your October date.
The 5th?
I will sign off. If he signs off, I'm signing off. And if you don't have him, then I at least want to prove it, because I want to hear more about the 5,000.
Hey,
when I have more time.
Hey, wait! This channel re-uploaded the video for views. Oh wow, you shady bastards! Veterans in Politics. I think they re-uploaded this same exact court hearing a year after the first one, and
I want to prove it.
probably for the sake of views.
Because I don't
like
know.
I said, because you know what? At the beginning of this, you said, "How is this fair?"
This doesn't feel fair.
Well,
But I'm
because
finding out.
I
don't know.
Right. Because
I need the information.
well,
And when all I know is that there's fights and everyone's like ethically mad at each other.
Watching
and
part
that
3,
makes me
and you're saying
very
it's
worried.
boring. I'm watching for 4 hours.
Information was provided, and the reason it sounds like the information hasn't been provided is because the representations on the other side have consistently been that the information hasn't been provided, and it has. And these guys could not afford the litigation that took place. That's why we're upset. Okay?
But it seems so weird to me that they can't. And maybe it's because that extra 5,000 just seems to be just getting bled out of the community.
And that's exactly the truth, and that's exactly how it was reported on the very accurate financial disclosure form, because it says it right there. Look, a dishonest
Very
financial
accurate.
disclosure form is one that withholds or misrepresents information. We broke down the information and we presented it to the court. We presented it to Jeff Nash. We presented it to Anthem. We presented it to the court. We explained it in our exhibits, and I don't appreciate
I'll have to look
anything,
back. I'll
any
have to check it
suggestion
out.
or finding on the record, and I'd like to make clear that there is no such.
Because I actually think that Jennifer Abrams, I think they had a case involving her with our Nevada judges. I'll have to double check that.
Finding that my client misrepresented anything or that we did anything unethical when we explained that exact breakdown of that $5,000 has to come out post-tax.
You mean the part in parentheses?
The
It's
asterisk.
explained, but if you look at the filings, that financial disclosure form was not filed in isolation. It was filed along with a motion or an opposition where all of it was explained.
So maybe I was looking at it in isolation and not understanding it.
And Your Honor,
Just
they also
look,
canceled
people
forensic
make
accounting
mistakes,
that this court
just
has
like-
ordered twice.
Just like you had half of the child support that he's paying. Look, people sometimes make mistakes or you forget it was a long time ago. We're not faulting you for that, but that doesn't translate into my client misrepresenting
Okay,
something.
I'll withdraw that comment. However, I want it to be fair and I want to know it's fair. So either he's signing off or we have a prove update. I can leave it on the 5th right now. That's a
His
few more
brother?
days.
No, I haven't, Zatsu.
Leave it on
I
the
don't think I
5th.
have.
You're
Let's
close
leave it on the
to
5th.
you're close to getting it done, and you can submit an order to withdraw if. Yes.
I just wanted to add just the $1 a year, and I'm good. Do the whole thing. We went over what
I haven't seen it, Judge, so I don't know what it says.
Can he at least see it?
Can we prove it up now? She's here.
Do you care that I have other things going on in 40,000 cases and you guys are one?
Everybody's pretty,
We can prove it up on the 5th.
Well, I'd like you to do it, summary dispo if you can, if everyone feels like it's fair. I mean, honestly, we have 130 more cases this month, this year.
oh,
than
she
we
was
had
part of the
last year.
Blandino
Out
case?
of everything we went through, what's been found to make this more fair is the $1 per month.
I really feel
which
like that would be a good idea.
we have no problem with it. Your Honor, the reason it's not in there is because the $4,000 child support obligation and the $5,000 debt obligation go on for so many years.
But he is in a business.
Understood.
He owns
That's
it.
fine. And we have
And
no
he
problem with it.
has prospects that could be
It's-
unlimited.
And we're not disagreeing with you.
It's a long marriage.
It's unlikely, but we're happy to put it in there. End of story.
So for how many years?
How long were you guys married for?
14.
14 years?
She's going to come out. In May of next year, she's going to be earning an income as a cosmetologist.
Oh, right. Right. And she's going to have income starting in May. So, want to say 3-4 years?
Yeah, 3 or 4.
7.
Is the court negotiating?
7 years. Is half the marriage. 7 years.
Because I'm not asking for the house or anything or your business. That's fair.
I mean, honestly, if nothing changes, that would be the normal. That would be the normal length of a spousal award, if there was going to be money.
If we can sign today, if we can just get this over with, Judge. I know you have other things to do, and I apologize, but I think we all
We'll
have just
do
had
5
it,
for 7.
and we'll do 7.
Well, there's no problem with 7.
Everybody's just done.
It would be malpractice for me to agree to something I have not seen.
Can he just read it and then you're okay with 7 years, $1? I need a yes, not
Yes,
a mm-hmm.
yes, yes, yes.
Okay, so he's just going to review it
Okay.
and he'll sign it if it says what we talked about today,
Okay.
and it will be done.
And then it's fair. I want everyone in the courtroom to. There's not been now that
God.
we're all understand that this is fair. If he wants to bring up fees, we can set this for a separate
It's a
hearing
sergeant case.
on all of these
It's a
issues.
sergeant
This is
case.
sergeant.
You did say on the record, Your Honor, that dollar for dollar was perhaps not the best thing that you could have done in this
I'll submit to
case.
the discretion of the court.
I can just say Sergeant requires that he pay her fees. That is the law. And if the ball moves because
I assume
the
Sergeant-
wording isn't proper, the law stays the same.
Schedule it for your
His motion is on today. It's on
his
today.
motion.
For reducing fees to judgment. It's on today. Seriously, it's on today.
That's not against
Yeah, it's not against
our
our client.
That's against his own client, and he's not withdrawing.
No, it's not. It's a sergeant case, Your Honor. I want what I was willing to.
Wow.
Look, I'll come off the
Wow.
belt. Your Honor, would you please instruct me not to interrupt me?
I don't, you know what, I need some respect here because I have a drug court. I've got people standing outside.
you, Your Honor. We're
I
leaving.
got a bunch of clients that are going to be out in the hall. I still haven't had lunch. These guys haven't had a break. You guys don't seem to give a care about that. And it's
sorry.
important to me.
Don't say give a
because
damn.
I'm tired. I've been up since 3 o'clock in the morning. Really tired. Got it? I need a minute. And if you want to submit something on fees, I'm happy to entertain it.
Thank
But
you.
it's a sergeant case and I can't ignore that. Maybe you guys can both take a haircut on some of your fees.
I intend
That
to,
might be a good idea.
Can we get billing statements?
Pardon? We can leave it on in case there's a problem, but I'm hoping that this was enough conversation about it.
like to resolve it, try to resolve it on our own. Can we get billing statements? Can we order that
Yes,
we get
you can.
full billing statements?
Yes, and
Thank
submit
you.
them.
Include that.
Got it. Thank you.
Well, that was fun. Okay, I want to see what this video is, if it's the same thing, but just re-uploaded. That was 929 plus this one.
372. Thader versus Thader set today on Mr. Lewis Schneider's motion to withdraw as attorney of
Yeah, this is the exact same thing, but even worse quality. uh Oh, there was actually a case where this time it was the mom. It was the mom who was committing parental alienation. Ah, it was this one.
Well, your words were doing. Good morning. We're on the record in case D16.
This one.
5444411. Michael Mangle versus J.D. Mangle. Counsel your parents for the record.
Tracy Rao, 7494, on behalf of the plaintiff who's also present. Good morning.
Good morning. And your name for the record, please? Okay. We are here today on Dad's motion for permission to relocate the minor child to Utah for an order to show cause for failure to pay due to past due unreimbursed medical and marital expenses. There's been no opposition filed, ma'am. However, you did object to him moving the child to Utah. Is that correct? Correct. Okay. Ms. Rao, before we proceed, I'm going to let you argue your motion, of course. I have read everything, and I went through
turned up the volume
as well, seeing when the decree is entered, and then you moved shortly thereafter to Colorado. Now you've gotten married. I think I have a really good grasp on the history of this case. But before we start, Mom, I'm going to talk about your text messages to your daughter. I was appalled. You are not to text her saying this is your dad's fault. He's kept you from me. I read through them. You have involved this child. Tell your dad not to. This should never be a phrase that comes out of your mouth versus in a text message or out of your mouth to that child. Tell your dad to do this about a court case. The court actually has court rules regarding this. EDCR 5.301 says you are prohibited from doing that. So I'm going to tell you right here that is not going to happen again. Okay?
Correct.
Are we clear?
Yes.
I don't care if you think it's him, because you clearly thought it was him responding. I don't care if you think it's him or not. The issue is she's old enough to have a text phone or a cell phone, right?
Correct.
And if unless somebody deleted those messages, she would see them on there, even if it was him with the phone. Is that correct?
Correct.
Okay. I can't have that again. An 11-year-old girl should not have to go through and see these messages. When I look at them, I can't tell you how many expletives I added to my notes whenever I kept reading them. You know,
Damn.
did you know that he went back to court to sue mommy? Do you think that's appropriate?
Ooh.
To make an 11-year-old in the middle of this go back to court to sue mommy?
A lot of those things were not written by me. He has had full control of that
Okay.
cell phone.
So you're telling me you didn't write this?
There are some messages that
Okay.
went back and forth with Chris and I. He was on her phone.
Okay.
And I do agree that there are some that were definitely said by me. And,
That shouldn't have, right?
And it shouldn't have been said by me.
Okay.
But some of those were also made up by
Did
Chris.
you actually? This one I want to know. I can swear you in, and we can go through the whole perjury issue. And look, I just want to fix it. I'm not trying to bust you up forever on this, but look, Mom, when you do that to an 11-year-old little girl, you are scarring her. I just don't think you recognize what you're doing because you get upset. I get it. You guys aren't together for a reason. I get it. But this little girl shouldn't have to go through this. Do you see what I'm saying?
I understand.
And the reason there's actually court rules about it that prohibit you from doing that, or I have the power to do a lot, and I'm not trying to do that for you, but I do need you to make sure that you understand. Look, I have a theory that this is how I think that children look at it. Your daughter looks at it like, I'm half my mom and I'm half my dad, and she'll say things like, look, I have my mom's eyes, or I have my mom's smile, or this, and look, I have my dad's this, and I have this. So she relates to being half of you, right?
I understand.
Okay. So would you let somebody else reach over and slice her with a knife? You wouldn't, would you? Well, your words were doing that to her, because when you cut down something about him, your daddy's suing me, or whatever you said, I'm not going to parse through them and say which ones were yours and which ones were not, okay? But would you do that? Would you actually pick up a knife and slice your daughter because you sliced half of her emotional well-being when you did that?
I understand what you're
Damn.
saying, and no, I would not.
Okay.
A lot of those are not true.
Not anymore.
Okay.
As you know, that there wasn't a file of opposition file on my part.
Okay.
So a lot of my side.
But you
of the
understand
story,
my side
I
is-
understand where you're coming from,
Uh-huh.
and so I just feel that right now and throughout this entire case, a lot of my side of it has not been heard.
Okay.
A lot of it has been denied and taken out of court. I have audio recordings, none of which I was able to share.
Okay. And I understand that this all might be true. I'm just saying, look, I'm telling you,
I understand.
I'm taking over this bench, and I expect to be here, I hope to be here for a very long time, and you're going to have me at least until the court loses jurisdiction over your daughter, if the court does, okay? So, I just want you to be clear that I know you don't have counsel, and I know I'm
Hey,
being a
Lisa.
little hard on you, but I want you to think about what you're doing, because most importantly, it's about Molly Sue, right? It's not about you.
I understand that, yes.
And my job also is to protect the children that are before me in a case. Does that make sense?
Yes.
Okay. So, and the fact that, you know, I don't know which of these you said and which of these you didn't, so I'm going to leave it at that. But I just want you to understand, EDCR 5.301 prohibits you from doing that. Dad, same thing for you. If you do things and you send messages, be cautious that if you're, I understand when she's in mom's care, if you send her a message and says, oh, your mom's doing this or that, you've sliced her too. So I want everybody to be aware that, you know, our jobs are to protect that little girl. Your job is, and my job is, right? To protect her from this. So I just want to get that out of the way and say, look, I'm not going to go through an evidentiary to determine who did what, and I'm not going to penalize anybody, but I want you to understand this court's position, okay? Does that seem fair? Okay. I feel like I beat up on you a little. I'm not trying to, but I just want you to understand when I see that, it concerns me. So before I let Ms. Rao argue her motion, you haven't filed an opposition. Have you changed your mind? Are you fine with her moving to Utah?
No, I'm not.
Okay. Okay, in that case, I'm going to let her argue her motion, then I'll let you do an oral argument for an opposition. She didn't file one, so technically I can just rule without because you didn't file. So the court has the
True.
ability to say, done, over.
She's doing you a favor.
But I'm going to listen to you anyways before I make
Yeah,
any
she's doing you a favor.
So I'll let you have a seat. I know I've been a little hard on you, but you understand, I'm trying to do what you're trying to do. You're trying to protect your daughter, right?
Yes.
Okay, and that's what I'm tasked with doing as well, okay? Dad, same thing with you, okay? So I'm going to let you have a seat and let Miss Rao argue her motion now, okay? You're fine.
Thank you, Judge. I appreciate Your Honors having read everything. This obviously is a procedurally dense case historically prior to coming before Your Honor. So absolutely, myself and my client appreciate your effort in looking at that. We are before you today on our motion for permission to relocate with Molly Sue to the state of Utah.
I'm trying to rescue a hostage,
Prior
okay?
to filing the motion,
There's one more
emailed the
pirate in
defendant
here.
asking her what her position on the matter might be. Received a response within the time frame we requested, which was appreciated. Basically saying, nope, file your motion. We've attached that as an exhibit. After receiving that response, of course, we filed the motion. Basically, the grounds or the reason for the move has to do with the fact that my client has established a relationship and has married that individual who resides and whose family resides in Utah. They've been seeing each other for around about a year now. They've been sort of dual stating it, spending recreational time up there in Utah, and then of course my client making the commute back to Las Vegas to maintain employment and Molly Sue's schooling, etc. We respectfully assert that we have absolutely a good faith basis for the request. We're certainly not doing it in any way, shape, or form to thwart or inhibit the defendant's contact with the minor child. In fact, part of the due diligence we did in preparing the motion had to do with some online research in regards to mileage and flights and that sort of thing. And technically, Salt Lake is actually a few miles closer to her in Colorado, further with planning, which certainly the parties are able to do given the custodial schedule that's in place and the visitation schedule that's in place. To plan ahead, your flights should be something that are about the same cost, perhaps a little lower. And certainly we would encourage the defendant to do that planning. One of the issues we've had before your predecessor on this court had to do with kind of a lack of notice on those visitations. So hopefully with the prior orders, that's something that the defendant is understanding benefits her to give that notice and make those claims. So we do assert that we have a good faith basis for the request. My client has purchased a home in Utah at this time with his wife, who's present in the courtroom as well. He stands ready to do whatever Your Honor tells him to do, of course, as far as Molly Sue goes, but it is his hope to get Your Honor's permission to relocate before the start of the coming school year. Should Your Honor favorably consider that request, one of the facts I wanted to make the court aware of, which I was not aware of when I filed the motion, but certainly would have included had I known, is the school start issue. The current order as between the parties has Molly Sue returning 10 days prior to the commencement of the school year. In the event that this honorable court grants our request to relocate to Utah, either on a temporary or hopefully permanent basis, they start a little later than we do here in Clark County. So what that would mean is that in order to get, they don't start until the 20th of August. The Clark County School District here starts on the 12th. So that would afford the defendant some additional summertime, which we, of course, would happily extend. And again, just wanted to make everyone aware of that. I mean, obviously, we exist in an adversarial process, so what I'm about to say, of course, impresses as obvious. I am hard-pressed, as is my client, to wrap our mind around what the defendant's objection is going to be here. As Your Honor accurately points out, very shortly after the entrance of the decree of divorce and the articulation of a joint physical custodial schedule, she elected to move to the state of Colorado. Her time with Molly Sue, the formation and sustaining of that parental bond is in no way going to be impacted by the move my client proposes at this time as a result of the actions of the defendant, not the actions of my client. We respectfully assert that the defendant is litigious in nature. She's been a challenge in that regard, and so I will tell you we were a bit perplexed not having received a written opposition from her. It's something my office anticipated. We obviously, again, as Your Honor points out, we're not in receipt of it, so I'm operating blind to a certain extent in regards to...
Counsel, I will let you make a reply to her I'm allowing her to have a little leeway, counsel. But.
And I absolutely appreciate that. Again, even with that, the fact that we haven't been served with a written reply, opposition, I do assert that a reasonable basis for an objection simply doesn't exist here. What I anticipate is that she will likely stand up and throw some mud at Dad, and as Your Honor has pointed out, these parties are not together for a reason. There is some hostility. We do respectfully assert that more of that is generated from the defendant than from my client. We also take issue with her assertion that somehow my client texted under her phone number to the child. That just is not true. Obviously, we're not here on that. We do not desire an evidentiary hearing on that matter. Do understand, however, that should one be set, we do stand ready to evidence that. That being said, we hope that Your Honor favorably considers our request to move. We've asked for two other pieces of relief. The defendant has failed to make payment on monies owed to my client incident to the decree of divorce. As a result of that, we would ask that that amount, which is $2,000, be reduced to judgment today.
Do I need a no clip?
By all legal means.
I don't know where the last guy is.
Would apply. Our third request is, of course, for attorney's fees.
Hey, Mandy, thank you.
Should this matter?
Hey, Mandy, thank you for the gifted sub.
Go forward to evidentiary hearing. The defendant is not going to be able to overcome the burden that she has, indicating that her opposition is made in good faith. To that extent, the statutory scheme affords my client the opportunity to request fees from this honorable court, so we assert that as a basis. Secondarily, she hasn't filed a written opposition. I appreciate Your Honor's very clear language. I'm going to give her an opportunity to orally do that here. But again, I respectfully assert that there's just not going to be much to it, such that...
Look, guys, she's trying to get her money's worth, okay?
This motion should have been preventable. Had the parties worked together in good faith to meet Molly Sue's best interest, we wouldn't be here today. But we are. And we are because the defendant sent me an email saying, do it, file this motion. So on that alone, we assert that we are entitled to at least something in attorney's fees and costs. And of course, we leave that to this honorable court's discretion.
Oh my God, the space is over here.
Finally, in addition to not filing a written opposition, the opposing party has also failed to file a financial affidavit. So understand that I understand that, and that may present some procedural problems as far as the financial relief we seek. But again, my records indicate that the defendant opened via e-service our motion and related documents on the 31st of May. Further, we took the additional step of sending it to her via U.S. mail, as is reflected in our certificate of service. And the reason I point this out is because she's had ample time to fulfill her requirements as a litigant in this matter. What is all the more irksome to me, maybe to this court, maybe not, is that this seems kind of the MO here.
Oh my God, she does. She rambles. The rambling. Okay. All right.
We will. My client has spent a large amount of money to my office to move matters forward and essentially resolve them in accordance with the law. The other side raises objections, belabors, stalls, doesn't meet her obligations as a litigant, either through discovery or the necessary filing of pleadings, and still my client has to pay for those things. So we believe that equity also is a grounds for that award of fees.
On that note, Griggsy, again, I'm gonna give you guys a little bit of a break from the rambling here. I think I did tell you guys that I do plan on getting Winston a companion. Like probably around, I guess, Christmas time. And I guess some of you guys are asking, like, what kind or anything. Like, I mean, for me, if I could, I would actually love to have a Maine Coon because I really like the big cats. So, but ultimately that's just like a want. Ultimately I'll be looking for a cat from my my county animal shelter. I volunteered a couple of times at the Burlington County Animal Shelter, so they got no shortage of cats there. So I'll be looking for I'll probably be looking for a kitten, but I'll obviously take in a cat that needs a good home. Just as long as they, obviously just as long as we can make sure that they can play well with other cats, But that's kind of where I'm going with it. If it's a black kitten, all the better, I guess. Preferably a short hair because, I mean, again, other than the Maine Coon, I would have made an exception for a Maine Coon. But if I'm not going to get a Maine Coon, I prefer a short hair, so I don't have to deal with the freaking grooming. So I'll do. That's a good question, Richard. I thought about that too, but we'll see. I'll be right back.
We certainly hope that Your Honor favorably considers our request to relocate. Should you have any particular factual questions about that situation that are not addressed in my motion, of course, my client's present and would be happy to enlighten Your Honor as you see fit. Thank you.
Ma'am, it's your chance to do an oral argument.
All right, so the fact of the matter is that we came to court on February 13th. I had filed a motion to relocate my daughter and to have child support payments revised because of a change of job that I had. All of those things were taken care of on February 13th. I had brought up in court at the time that my daughter had shared with me that she was moving to Utah and no longer enrolled in the school that she was going to be enrolled in. That was part of the agreement of why she attended school here at Las Vegas Day School. Based on that, there was a letter of intent to send in as well as a deposit, which was due that same week. Chris did not do that, so he did change her schools indeed to where it's still unknown. And I brought it up in court then that he had the desire to move to Utah. He said that that was not part of the case and that was not up on the table at the time. In fact, he was actually already in contract on a new home there. So they ended up closing on a home in late March. We had the order, it was supposed to be revised and a new order was to be entered. I had to contact Tracy's office to ask on March 21st whether or not that order had been entered at that point. She told me that it was not because the courts were taking a while to get back to her with as far as the paperwork necessary for her office to create the new order. With that being said, they ended up closing on their home on March 27th. Not until April 3rd of 2019 was this order entered, and it was because Chris needed to show. So during this entire time, my child support payments were not revised to reflect what the new payments were.
Guys, we found it. We found a unicorn moment. A unicorn moment where mom's got to pay child support. I mean, it's not that much of a unicorn moment, but it is. It's a, you know, even in 2023, it's still not the most common occurrence. But yes, if you don't know, moms can actually pay child support.
I believe it's because they needed to show that as far as the income in order to qualify for their mortgage. I mean, if you look at, his mother has taken care of a good majority of his expenses over the years, including this. And so, I mean, a lot of it has just been unfair to that degree. He's asking for monies of prior, like, marital expenses and medical expenses of my daughter. In regards to that, he called me hysterical on June 17th of 2017 that our daughter had cut her hand and she was bleeding profusely. With that being said, he needed the medical insurance information and such, so I gave it to him, and I advised him to take her to urgent care. Instead, he took her to the Summerlin Hospital emergency room, and what should have been a $35 copay for 3 stitches turned into $2,000. As well as, or in addition to that, the marital expenses of things that, orthodontic as well. He, took her to the orthodontist, did not discuss this with me, did not get any agreements with me, and ended up putting braces on my daughter. So, hence a $900 copay on my part. However, our insurance covers $5,000 per lifetime, so it has actually been covered entirely by our insurance. As far as the marital expenses go, Chris broke into the marital home when I had...
Okay, let me stop you there because we're not going to retry your whole divorce case. The only issue before me is relocation and the order to show cause for you not paying medical. Okay. I'm not going to go back to the court. Already heard your motion for you to change custody and move her to Colorado in February, so I'm not going to hear that.
Right.
I only can hear up to that point, okay?
Okay, so up until that point...
So I need to know so I basically need to know the issues about your objection to relocate, for her to relocate, and also your objection to the unreimbursed medical expenses, why you don't think you should be paying them, because the order shows you guys are supposed to be splitting them in half. And that he took her to an ER, an emergency thing, doesn't really show me that, just because it costs more because you went to the ER when a kid has a cut that has to be stitched immediately, we can't wait to go to the regular pediatrician for that, right?
Right, I said urgent care, and so he calls me at the time. I advised him of where the urgent cares were. I gave him several addresses of the area that were open at the time. So, I mean, it was,
That's your objection is that he went to an ER instead of an urgent care, right?
Correct.
Okay.
I mean, to me, an emergency room should be used for life or death situations. 3 stitches on her hand was not a life or death situation. He, as any parent would, I understand that it was a very anxious time for him and high anxiety and such, but I tried to walk him through it and give him instruction of what to do next. Moving past that, as far as my objection goes to relocating my daughter, I've been trying to do this for quite some time. Although I was remarried shortly thereafter, I still remained here in Las Vegas. I was married in July of 2017. I stayed here until November, commuted back weekly on my days that...
Marnie says, I got a 1-year-old for my 13-year-old. Oh my god, I already forgot what kittens and teenagers are like. They need so much attention. She drives my elderly kitty nuts. It was funny. It's funny you say that. I actually have saved a couple of YouTube videos on a playlist that are specifically tailored to like how to introduce an older cat to a kitten. So yeah. Yes, Dad has primary custody in this situation, it sounds like.
Molly was to be with me, so I kept my work here, and I commuted back home to Colorado, where I had purchased a home with my husband. So, you know, I tried to stay as much involved as I could with my daughter. It just got to the point that it was either I needed to make a decision or, you know, trust that Chris had her best interests at heart, and we agreed upon the fact that she was at the school that she was at. He tried his best. I'm not going to paint a whole picture the way that him and his counsel did, half of which are completely untrue and easily provable on my part.
Easily.
But why I had a really tough time is that our daughter's grades has slipped from when I was still in the picture. I mean, here's a report card and how she was an A and B student. She now finished up at C's, D's, and F's. She was at a very tough school, a preparatory, that there is no room for any hiccups at home. So,
And do you think that a divorce and the fact that you moved to Colorado was also a hiccup?
most certainly it was. And so, as Chris he's remarried, he's actually already moved to Utah. It was advised by the court back in February that he was not to move to Utah with our daughter unless there was permission from the court, at which time I was advised that I could present the reason why I would like her to be in Colorado. Most importantly, I would like to be able to help her with school. I tried my best. There's a lot of times that communication was cut off between my daughter and I for weeks at a time. And this was to the doing of Chris blocking her phone number, or our phone numbers from being able to contact her. My older daughter is...
Was that prior to February 2019, no?
No.
It was after then?
Correct. Okay. So it was prior and then still during.
Okay.
My daughter that he refers to that I abandoned in Hawaii, completely untrue. She was attending a boarding school, a very prestigious boarding school with 26 kids from 26 different countries attending there. She now attends college at Metropolitan State University in Denver with us.
So she's not a child to this issue. So I'm only dealing with the child that's here. Okay.
So her sister does reside there. Her half-sister resides in Denver with us and attends college full-time. She does live at home with us while she, attends school. And, we certainly can offer Molly a very stable environment. Right now I did secure a spot for her at the Parker Performing Arts School. She just completed a 2-week summer intense acting course that she just performed in a large production.
Yay.
Enjoyed it. Currently my 2 daughters flew to Hawaii to spend time with Grandma and Grandpa. They've been doing this for the past 7 years, that they go out there for a few weeks in the summer. Especially it did come in handy with the fact that we had this going on. She talks about May 31st is when she had filed this motion. I also didn't get my daughter until June 4th. So as soon as I was finally able to reunite and connect with my daughter, now, once again, 2 summers in a row, my focus is to be switched on to this pending court case yet again, when I really, really would like to enjoy the time with my daughter. So, like I said, he's known that he was moving. He said that he wasn't at the time. And, I just think that we could help her with a much more stable environment as far as getting our daughter through school, getting better grades. I would love for him to be able to have her every weekend if that's the case. I don't want child support from him. I would rather him use the child support to be able to commute our daughter back and forth. It got to a point that financially it was disabling for me, that I could not afford to see her. So it wasn't as if I was giving up my days because I couldn't see her. I was backed up on child support. I had a change in job, and I filed
All right, guys,
for it in September. I was denied.
I'm gonna try and
because it
build a
needed 3
Normandy.
months prior of an actual of what my income was. I filed again in November. They said, sorry, you need to take this to court. So finally I filed in December and had that court date in February. The original court date was in January. I had booked a flight, paid for it, made, accommodations here, and Tracy had asked whether or not she could move that date because it didn't work with her schedule. I said, no, it does not work for me. She went ahead and moved it anyway, so I had to force
I got to tell you, I
flights.
don't believe Miss Rao did. I got to tell you that right then, the judge that was sitting here retired, and they moved everything. So I don't believe that she did, from what I can tell. Just so you understand, okay? It was that
Pardon,
judge
sorry.
retired January 11th, and everything right around January 1st on. Okay, just so you understand. So I apologize.
Hey, Far, you got to be on that live stream grind, man.
Prior to my time, but that's what I saw happen.
Hell, you know what? Mandy, change the title. Well, I'm doing a subathon. Change the title on Kick. Change the title on Kick, YouTube, and Twitch. I'm doing a subathon, baby. Let's go. Yeah, I'm super serious. Why the hell not? Oh wait. Oh yeah, I have to put like a number in there, don't I? Hold on, let me put the actually, if I'm actually going to do this, hold on a second. Let me do this. Let's see here. No, not subscribers. No. By subathon, no, not subscribers as in YouTube subscribers. I'm doing sub as in like Twitch. So as in like YouTube memberships. That's what I mean by subathon. Like YouTube memberships. Oh, let me think about this though. Let me get my overlay editor here. Chaos, I'm live on Twitch right now, even though nobody's there talking. I'm also live on Kick too. Add a layer. Goals. Wait, really? Epiphanies, we haven't started yet, but thank you for the 5. Hold on. Session. And then let's do the target 150 tier of any tier. I don't know if you guys saw that. I for some stupid reason I added I added a 3rd tier to YouTube. There's really no benefit other than if you want to. That's why I really haven't advertised it. It's not like you get much out of it. It's just you have a tier 3 sub now. It just makes you extra special in my heart. All right, so that's YouTube members. Sathale, thank you for the 6-month tier 1 on Twitch. I see you, you crazy bastard. Basically, you can gift memberships to gift memberships on YouTube, gift memberships on Twitch. Luna, oh my god. All right, let's put it the goal right here. Actually, save it so it's not in the middle of the screen. So that's only counting YouTube members though. I have 33 because the 33 is including like the previous session. I forget how to reset the session. So that's why I added to 150. So at 150 there. Keep it going. Or I could add also goal Twitch. YouTube. Well, actually, Sue. That's actually a good point. I mean, YouTube does take a chunk. Patreon takes less. You know what's funny is like there's. I wish Stream Elements did this, but they don't. But there's now a method where you could join in memberships elsewhere. That doesn't take as high of a cut from YouTube. Grifting trolls. What do you mean, Chaos? Twitch actually, Twitch actually takes a higher chunk than YouTube. As a matter of fact, that's why I don't really advertise a whole lot on Twitch, because at the end of the day, they actually take more. They take Twitch takes 50%, YouTube takes 30%. Twitch. I would say that's why I don't want to talk about Twitch subs. Twitch subs, because Twitch takes 50%, YouTube takes 30%. When any streamer does punks, people starts asking for more subs. People come out of the hiding and say they're gifting for more money for the number of subs. Oh. Well, I mean, I guess I'm not surprised about that. Mark, thank you for becoming a member. I mean, I guess I'm not surprised about that. It's something I always try to avoid. But I also make a note, like, this is what I do. I do this as a hobby. I don't need this. I don't need this as a permanent income. Uh-oh. Oh, chat, come back. Okay, good. That's why I don't ask people to become members or to tip. No. Well, Mandy, I'm treating the subathon as like a membership drive. I am doing a subathon as in memberships because that's what they do. But I try to tell people that I have a day job. I don't do this for a living. I mean, do I wish I could? Probably, but I wouldn't be doing this for a living unless I was making the same amount of money as I am now in my current job. And I would estimate as a streamer, I would probably need to have like 100,000 YouTube subscribers to get enough to feasibly get enough members to actually do this as a full-time job. Sathail, stop! Sathail's gonna do. Thank you for the 20 gifted memberships. Oh my God, there it is. I see. I'm halfway there. All right, moving on. Sathail, I know what I'm dealing with. It's just, oh my God. Anyway, let's keep playing the video. All right.
Okay.
Even if she wanted it to happen, it happened because the judge retired.
Okay. So
Just so you know.
Thank you, man. I
I
love and hate your generosity.
Had all that
Thank you.
ticket, you had to redo your ticket. Mm-hmm.
Fine at this point.
I gotcha.
There's times that I've flown here and was denied to see my daughter. So
But you still
Hang on a
have to give
second.
me the information about Utah. What you're being. Look, you live in Colorado.
So-
if you lived here, that's a different story. But you live
Right.
in Colorado, so I'm
So
still
in
looking for that. I
Utah-
think the stuff that Miss Rao is saying. Look, you're not telling me
thought it
what's
was-
your
I
big
thought Wisdom
objection
was still there.
of being there versus here,
so
other than the school change.
right. So I do.
But also remember, guys, if you want to be gifted a membership, you have. I wish YouTube didn't make you have to do this, but guys, if you want to be a gifted a membership, you have to actually opt in. So if you go to where, if you see the little green bubble where Sathail had his 20 gifts, if you click that, it'll say accept free membership or something like that, accept gifted membership, and then you click on that button. If you already did that, you wouldn't see it. But yeah, for whatever reason, YouTube makes you have to opt in to receiving gifted memberships. I don't know why.
Do have my daughter, which is her half sister, residing here in Colorado with us. I can't say that I have anything against Utah. That I mean, I'm not going to say that it's a bad place to live or anything like that. I'm sure it's a beautiful state. I'm sure it's a safe state, as is Colorado. My daughter would have very similar, things available to her as far as extracurricular activities and outdoor things that she can do versus living here in the city in Las Vegas. I just think that with having her sister there and the fact that she was away at boarding school from 6th grade through 12th grade, she's back full-time going to college there.
It doesn't work on YouTube app?
For them
Really?
to be
I thought
able
they
to
fixed that.
continue that relationship that they have. The school that my husband and I have secured a spot for her in, it's a charter school specializing in performing arts based on my daughter's learning and all that she's been through at this point. I really think, and especially over this past 2-week intense course, I really think that she would benefit from it, and that would be a great learning environment for her. I'm not going to say...
Did you guys talk about this? Because look,
Yes,
part of it
I
is
have.
you haven't really, the problem that Miss Rao is saying, look, we asked her, she sent this email, and they attached the email, and the email says we, which I assume is you and your husband.
Right,
That's not
so-
about a we issue, that's about you.
Chris and I did speak about it, and I did forward him on the information. I forwarded him on the packet. I said this is what my intentions are. If
I want you to
so, moving
co-parent, no matter
forward.
where your
Correct.
child's living, you got to co-parent.
I would love to be able to co-parent, which is why I don't
Alright, I
want
gotta
to
look up
be
that
able to
video
financially to not be able to spend time
on
with my
how
daughter,
to build the
or our
Normandy.
daughter, I should say. And the fact of the matter is, I don't want your child support. Chris, please use that money towards being able to see her every weekend or whatever break you would like. We came up with agreement back in August that he would be more flexible and he would be more cooperative with the schedule as far as the parenting agreement. Sometimes it doesn't work out, that it's a 2-day turnaround for her, so all of that fly time, and it's a $600 round trip ticket. And what the next weekend
So
would be,
if that's the case, let me ask you this. Part of what their motion said is that it's like a 30-minute less flight time. You're saying, look, all this flight time, doesn't this help it a little bit? I realize it doesn't fix it.
cost.
She's not next door. but it's
It's the cost is what is a huge issue. So
Okay.
it's the airfare and the cost of it. It's
because
not-
30 minutes, every little bit less of her on the plane and travel is
Absolutely.
good, right? The couple hours difference in the
Agreed.
drive. You say you're in Denver, and what part of Utah are you going to be living, sir?
So,
I'm very familiar with Utah. Just tell what town?
Cedar Hills, right next to American Fork Canyon,
Oh, okay.
about 25
All
minutes south
right.
of
No,
here.
I'm very familiar where that is.
Yes.
Mount Timpanogos. I know all the area. So,
Yes.
okay. Okay, so really, even the drive time is a lot less from you up there to there if you were gonna drive. So far, your only issue though is the cost difference between the flights there and the flights from here,
No, I also explained the fact of having
and the school issue. I got you.
Right,
I'm not
the
losing
s-
track
the
of
school
that.
issue and just having that time in order to help her with her homework daily, to take her to her things, to be a part of a lot of the things that she would like to do.
Do you know when the time for to just make that decision was?
I'm sorry.
Do you know when the time for you to have made that decision was? Back when you made the decision to move to Colorado.
Right.
Unfortunately.
And I tried to file before I had relocated. I tried to file.
But you had to make a choice. Like you said, I had to make a choice, right? You said I had to make a choice,
Right.
I had to pick, and I get it. And the choice was made. So now we're stuck with this point where we're at.
I understand.
So I'm just trying to figure out the difference. So far, I'm hearing the school different and you being there daily. That part was decided before. I can't undo what you did. But I'm asking like the whole issue about Utah versus it's closer. So far, I'm not hearing a negative. You say that school issues. Now, had you filed a counter motion about modification for custody based on school, the court certainly would have heard it. But I don't have anything before me on that part, so I can't even address that part, right?
Right. So.
I can only hear your opposition orally. I'm not going to hear a counter motion. That's my problem.
Right.
You've left my hands a little bit tied because you didn't file an opposition and counter motion. Okay. So I'm just trying to find out. So we got the how far it is. Okay, I got it. It's closer. And I've got the other. I'm not hearing anything else. Can you tell me what else, Miss May?
My daughter's hygiene has been compromised. She comes.
Okay, that's
to
a counter motion.
So she comes to me with no clothing, no clothing at all. So she was just given to me on June 4th. Not a single article of clothing. I asked her prior to her leaving 2 nights
Thanks,
before,
Manny.
the day before, the night
Okay,
before.
we can deal with that.
And he told her, and I heard him in the same room, your mother can provide those things for her. You're
We'll
not
deal with
taking
that
those
part.
things.
That part is going to change, just so we
So-
understand, counsel. This child is going to grow like this, and mom can't figure out what size she's in when she lives in a different state. So she needs to be sent with clothing for the summer when she goes, Dad. So we'll be clear on that, Mom.
She's came to me with shoes with holes in it. She's came to me. So all of these things end up having to get replaced in addition to the other cost again that I'm incurring.
No, I
So
understand that part. That part we can fix.
her hygiene has been extremely compromised. Her daily baths, those aren't happening when she's with Dad. I call her every night. Sometimes I get through, sometimes I don't. It's 10 o'clock at night. She still hasn't taken a bath. She still hasn't done homework yet, and she's playing on her iPad in her room by herself. Then I hear him yell at Molly, it's time to bathe. In order to have my daughter on a regimen that would be beneficial to her education and her learning and not being tired the next day. She has long days at school. She starts here in Las Vegas. She was starting school at 8:30 in the morning till 3:30, then tennis on to 5:30, 6 o'clock. Those are extremely long days. So I understand if all these things don't get done within the first, but she still could have taken a bath. She still could have had dinner. She still could have started her homework at least. A lot of those things weren't happening. And I understand Chris is working full time. It's busy. It's tough. It's a day-to-day operation, really. I understand that. These are the things that I want to be able to provide for my daughter that I think would be more conducive to her having a stable home environment as far as her education goes, and that we could really focus on those things that, right now is a little tough for Chris. I'm not saying that he's doing a terrible job. I know as a mother, she's coming up on puberty. A lot of things are changing. and
But we knew
happening.
this when you left Colorado also,
Right.
Mom.
We also
Right?
knew
Right.
this, and I tried.
You knew all of this.
Right, and I tried, as you can see, that I tried. Chris has talked to me. We've made compromises. We've made agreements. A lot of the agreements
Right.
that within a month later, it's completely out the door. I have several emails, and I have an audio tape that I would love to be able to share with the court of Chris's aggression towards me as we talk about not exposing our daughter towards, any of the ill will that he and I have between each other.
And then, but yet you still sent those some text messages. Even if you didn't send all of them, you still sent some of them. That's a little puzzling to me.
Right, and so, like, again, those are ones that you were able to see. I was not able to submit those things.
But you could have. You had an opportunity. You were served with the opposition. You were served with the motion. You had a chance to file an opposition.
So when
that was your chance, and you didn't. I'm taking a little testimony, letting you have a little leeway, but you had the opportunity, right?
Yes.
Okay, that's my concern.
Opportunity, and I've done before with my last, and all of them were denied and completely kicked out. My exhibits were kicked out. So
well, the previous judge didn't see exhibits from anybody. This judge believes that exhibits are just an offer of proof pursuant to the court rules, and I do review them. So you know in the future. So as long as I have jurisdiction over this case, understand that. But you still could have filed an opposition counter motion saying, look, now if he's wanting to move, now's the time. Maybe she moves with us, but you didn't. So I can't hear any more of that.
Sorry.
So.
Like
I understand you're doing the best you can.
I spent that time with my daughter because I finally got her.
I understand that there's just choices. Okay, so so anything else you want to add about the Utah show? I'm not seeing it so far, Mom. I got to be honest with you. So far, I'm not seeing any basis for me to say no, that he can't move.
Her hygiene has been
well,
severely
hygiene
compromised.
can
She has broken out everywhere. Right now, she has been on a much better regimen. Her just cleanliness every day. She is completely.
I got to tell you, I have 2 grown daughters. Just so I know, I do know there's periods in time when they hit certain ages when they don't do that, and you are like on there. You know what? It's like crazy to get them to do anything, let alone brush their teeth, let alone do the rest.
Severely bad.
I understand. Okay,
Her clothes are filthy when she goes to school. Her uniform's a complete mess, unwashed.
But you're not there. How do you know this? How do you see her uniform?
Other parents send me pictures. Chris never sends me pictures of any of her performances or anything that she does at school.
So we need to work on some co-parenting, it sounds like.
Correct. Correct. Okay. We do need to learn how to co-parent.
Definitely.
Tracy has been an extreme. She has brought this to an extreme level. I have been bullied. I have been harassed. I have been,
bullied.
This is just, I have a stack that high at home of correspondence from her and just non-stop.
Okay.
Last summer it was
right on,
because
Kat.
I had just, and it's always as soon as I receive my daughter, I get bombarded with all of this. So it almost
JT, we could have used your expertise. No. JT, we could have used your expertise in the last video. Darn it. That's okay. It's all right. That's okay. But good to see you, man. Everybody, if you guys want to check out a guy who knows his way around finances and knocks down financial scammers and gurus and the like, check out his channel. He's got great content.
Well, now that you guys, you've gotten through all the other litigation part, we're to this relocation, maybe it can, had this not occurred, maybe it would have already mellowed out, and I expect you guys to both start acting like grown-ups and let your daughter be the child that she should be able to be and not be in the middle of this. And I think that's affected both of you. You're saying, look, it's hit you each time, and I realize that. Okay. Anything else you want to add before I'm going to turn over to her, because we're really going long here. I've let you have a lot of leeway.
I understand. I thought that he was not able to.
Hey, Donna, A98.
State of Utah without permission from the courts.
Yeah, and that's why they're here. That's why they're here.
And he already did.
Okay, but relocating with her, she's the one who's not allowed. He can relocate anywhere he wants as long as he makes sure she's where she's supposed to be. So
right, and
that sounds like they were doing the stuff you guys were doing, the long distance, driving between 2 states. Sounds like it, and you knew about that. So
correct, and a lot of that was, he has been.
And if the court were to say no, she's not moving, like Miss Rouse said.
Back to the dawn. I'd never even heard of it.
He has to do for his daughter. So that's where I'm at. So, okay, so he hasn't technically moved without court's permission. The court is here to make that decision, okay? All right, so I've heard your oral opposition, even though you didn't file one. So now I'm going to hear a reply from Ms. Rouse.
Just briefly, Judge, because I know we are running long. In simple stuff first, in relation to our request for the reduction to judgment of the $2,000, as I'm sure Your Honor noticed, that was a stipulated order entered by this honorable court on the 13th of August, 2018. So those amounts were stipulated to at the time.
Correct.
Whatever objection she had to whatever constituted those amounts, were of course before the court and then resolved via stipulation. So, she talked a little bit about the logistics of the entrance of the last order, which I find perplexing, frankly. The issue was she objected to the visiting judge's language that it was reasonable for my client to request that during periods of vacation, she return the child to Utah as opposed to Las Vegas. Visiting judge
I
said,
saw that. I saw it was ordered that you would return her there.
and that was it. And
I
she-
reviewed all the records.
Perfect. She objected to signing the order that outlined that.
Okay.
And so the sitting court made the handwritten changes to the order. That was the
I didn't
delay.
know that.
Nothing by my office, nothing of the sort, rather her
Okay.
lack of cooperation, frankly. Again, we're encountering the same thing we did in February, which is her trying to rehash history, prior motions. I appreciate Your Honor getting her back on track there. But everything she argued today was something that she offered, at least to some extent, before the court in February. Most particularly this blocking phone issue. Orders were made as a result. I absolutely, wholeheartedly assert that my client's not doing any blocking. All we can chalk that up to is again, she's got some hostility, and that this is how she's working that out.
And counsel, I gotta be honest, with the whole issue with the clothes, that he didn't send clothes for the summer, I gotta tell you, I'm gonna tell you that I think there's a co-parenting problem here. That both parties, and mom even admits, look, you guys need to work on this. It's not fair to your 11-year-old little girl that you sent her without clothing, Dad.
Well, and if
So
I
I
can
want
address
that
that just
feature.
briefly, he did pack a suitcase for her. It was a full suitcase with toothbrush and toiletries and stuff. So I think that the issue is not that my client sought to restrict the clothing, but that perhaps they define a summer's worth of clothing a little bit differently. Absolutely, my client
I expect it's for a whole summer.
welcomes
like,
the
probably
opportunity to work on co-parenting skills, and
Right.
and that would be great. Let's see. In regards to this, seeking to secure a spot for Molly Sue at this performance arts school, it was not a discussion. Basically, the defendant said, "Here's what I'm doing. Thank you. Goodbye."
I said,
In regards to Colorado, and yeah, there you go.
You
Again,
said, here's what I'm thinking, right,
Right,
Mom?
here's what
Okay.
I'm thinking,
Okay.
and it's all in an email, and I gave him a full description, access to the sites, everything that we just had with her performance. I CC'd him on everything, so.
Oh,
that
98, I'm taking a break from that.
Even though it's my time in the
Understand.
summer.
Okay.
I invited him
Okay,
over.
Mom. I didn't want you to go on to another argument. I just was saying, I heard what you're saying. You said, okay, go ahead, counsel.
and again, just in conclusion, most of what I've heard the defendant say today here has to do with the comparison as between Las Vegas and Colorado. That's obviously not the analysis we're asking the court to undertake, but rather Utah and Colorado. I respectfully assert I haven't heard sort of recognizable grounds here. The other issue that I didn't paint in my initial argument, but I'll just touch on since she did, had to do with the significant periods of missed visitation too. That is all outlined in our motion. She, of course, offers as reasoning for that financial issues and whatever they may be. But the bottom line is she's not exercising the time awarded to her now. Molly Sue is presently in Hawaii with her folks, has been for a couple weeks. We have no idea when she'll be back on the mainland. That is information the defendant has failed to share with the plaintiff, although it has been specifically requested. So, yeah, she's very fond of pointing the dirty end of the stick at my client, and not so good at taking responsibility, in my opinion, for her own burdens as co-parent. With that, we don't want to take more of your Honor's time, only that, of course, we have issues with many of the factual assertions she made here today. Stand ready should we need to evidence that, but respectfully assert we should not have to by virtue of the fact that there is no counter motion for a modification of custody before this honorable court.
Thank you. Okay, I've heard both sides, Mom. I let you have a chance, even though you haven't filed an opposition. So you understand, you kind of tied the court's hands because you didn't file anything. You didn't file an opposition. I let you argue the
Basically,
oral opposition.
she's kinda
I don't
screwed
have
there.
a motion before me regarding the other issues. So I really have no choice, but I have to still have to go through the factors for the relocation. They've made a good faith reason for moving. He got remarried. You don't even live in this state. You live in Colorado. He got remarried. He's purchased a home with his new wife. And the distance, by your own admission, will be a little less on your daughter to travel, right? So, because I have no other, and they also went through the issues of where you live, so we went through all the issues. We went through whether it's the best interest of the child to relocate there. So the court finds that I have no option but to grant their motion to relocate because you didn't file an opposition. I heard your oral opposition, and even by that, I tried to give you as much leeway as possible, so I'm granting his motion to relocate, Mom. If you filed a motion for, for change of custody, I would have certainly heard that as well, but you didn't file that, so I'm kind of at a loss at that. As far as the other parts, Mom, the only thing you said that the reason you didn't pay half of the unreimbursed medical things is because he had to take her to the ER because she cut her hand and had to go to the ER. He said to the ER instead of to quick care. The court can't micromanage on what you go and where you take your children for emergency services, right? And you're in Colorado, and he had to do his best and had to use his best judgment. So unfortunately, you have to reimburse the unreimbursed medical according to your
previous. He broke into my home and stole $4,000
Look,
worth of
if that's
items.
all
Broke into the home.
divorce, that's like 2 years ago.
Oh, she's trying to relitigate.
Mom, you've been gone to Colorado since you said 2017, right?
He's trying to
I'm not
relitigate.
gonna litigate stuff that happened back into that far, because really only thing before me right now is a relocation. I've gone through the factors and I find that they made a good faith effort. The question becomes, in our statute, there's room for me to grant them attorney's fees if you were unreasonable on your granting his request to relocate. Do I think you're unreasonable? No, I think you had a good faith reason. I just think you didn't put it in opposition. I gave you the chance to argue that. So the court finds that you did have a good faith reason, but you didn't articulate it in opposition. So without that, I let you have an oral chance. With that, I'm going to grant them some attorney's fees, but not what they've requested. Ms. Rao requested, her request was $7,500. Counsel, I think that part of it he would have to request it anyways if there's no thing. So I'm going to grant him $1,500. I realize that's low, but look, I want her to be able to see her daughter too.
Yep.
I don't want to strap her so financially that she doesn't get to see her daughter, because that's not what's best for Molly Sue. We've also, other part of the order, counsel.
Also true.
I don't want to have to put a full behavior.
Yes, the defendant is. She's
Mom,
crying.
No more text messages to the daughter herself. You even said yourself you sent some things that made her, that was not good for her, right? I need you both to be cognizant of that. So in the future, no text messages, derogatory text messages about the other parent to that daughter. She's 11. We want her to have a good childhood, right? I think we've had this conversation. So in the order, counsel, I want you to put that no parent's going to talk. I mean, basically recite EDCR 5.301, counsel, in the
Happy
order.
to do so.
Okay. Also, Mom, did he send a suitcase with clothing, just not enough? Is that what it is? What did he send? You said not a thing. And so I went on with that.
In there, it was her iPad,
Okay.
it was chargers, it was her yearbooks,
Okay,
and
but no
it
real
was-
clothes.
And it was 2 sweaters that I had recently purchased for her on
Okay.
a visit that I was with her 2 weeks prior.
Okay.
That was it.
That was it.
So,
Okay, Dad, in the
as far as
future.
toiletries and
Okay.
nothing
Okay.
of actual clothing, no shoes, none of that.
Okay, Dad, that's not going to happen in the future. When she goes for visits with her mom, you need to send her with the proper thing, like you would to send her to your parents or your grandparents and stuff like that. Your daughter deserves that. She shouldn't go somewhere and not have stuff that she needs, right?
Understood.
So in the future, I wanted that to be a little better. Your current order as far as visitation is going to stand, Mom. Really, the only difference is you're in Colorado. He's moving to Utah, and he's actually closer to you. So that's where it is right now. If you filed a motion for anything else, the court will certainly hear it. But counsel, that will be my order. As far as the arrears, the unreimbursed medical, you're going to have to pay those. I'm going to give you a chance on how you want to pay them. Do you want to do it on a shorter amount? What do you want to do? I mean, I'm trying to give you. You can make them in payments for, like, you want to do $500 a month for 4 months? Is it $2,000 that you're happy
My
with that, counsel?
insurance
It is
had paid
2,000
Uh-oh.
is the amount outlined that she's liable in the stipulated order. And just so your honor's aware, it was broken down into payments in the stipulated order,
Okay.
which she has failed to make.
Okay, and the stipulator, so what are you going to do about that, Mom? Look, you got to get back on track, right?
So right now I'm overpaid by at least $1,000 in child support because it was not revised on time. My insurance did pay for her entire orthodontic work.
Okay, but
So-
the order says that you have in place is that unreimbursed will be divided. If you have great insurance on both sides, that's great. I commend you both as parents, but you need to get the unreimbursed part is the part you got to share. So you need to make it's $2,000. That I'm going to reduce it to judgment collectible by any legal means. That way they have to collect for it, and it's due, Mom. You've already stipulated to that, so that part is due. I realize you're saying you have insurance that covered other things, but that still doesn't take the fact that she had to go to the emergency, she had to have stitches and things like that. The court, the order is the order. You guys have to divide it.
Having legal rights, that he needs to discuss whether or not he puts braces on her without, I mean, and.
Right, but the braces you said didn't cost you guys anything. You do need to discuss these things. Counsel, I'm gonna admonish your client that you need to have a talk with him of what joint legal custody means. You have joint legal custody.
True.
That means you have to discuss those things. But if your issue is cost, Mom, you're saying, well, but good, I have insurance and it was taken care
And
of.
our insurance did take care of it.
Okay. Did you not want her to have the braces?
At the time, no, because she still had baby teeth that needed to be taken out.
Okay.
So
So I'm going to admonish you both to talk about this more. Do you guys, how else do you communicate? Do we need talking parents? Do we need our family wizard? I need you guys to start communicating for this little girl's sake.
We actually proposed the utilization of our family wizard in the past, so we think that's a great idea.
Talking parents is actually free, though. So I understand if you didn't want to do it, because look, I'm not trying to burn you with more costs. I want you to see your daughter more and more. You made the choice to move to Colorado, so unfortunately your daughter's stuck with that, right? And so were you.
He broke into my home, and I had no choice.
Oh my God, she's doing it again.
2017, before your divorce, before all of that. The only thing I had before me, that was a relocation, Mom. So I'm just trying to figure out, do you want to utilize talking parents? That's free. Counsel, I'm going to order these parties talk via talking parents. Look, no more text messages to the daughter that are bad. We've already covered that. I've reduced the other to judgment, counsel, and I've granted $1,500 in attorney's fees. Anything, counsel, you'll prepare the order and have it submitted to my court. Anything else?
Happy to do so, and hope to have it to your honor by the end of the week.
Mom, I want you guys to start co-parenting. Okay? Just work on it, both of you. Dad, you too, because you have a lot to blame too. I think the fact that if the clothes really were what Mom described, that's not okay. So that'll be my order. If you will prepare it, I believe that it meets the NRS 125C007 on the permission to relocate. You've met the factors, counsel, in your argument, and I had no opposition other than your oral opposition, which I've heard all of it. And I really didn't find a basis for him to be tied to the state when you don't even live here, Mom. That'll be my order. If you'll prepare the order, that'll.
Happy to do so, Judge. Thank you.
Buggers. Well, looks like Mom's obviously in not in the best situation, but it sounds like there's a lot of history between the two, which is usually what happens. Oh my God, no, not gonna get struck by by Disney. Okay, this is ABC. Disney's gonna have my ass if I live stream any of their crap. So no, we're not doing that. Ha. Makia Bonds fighting against a biased, egotistical judge in Clark County Family Court. Ooh, spicy. Well, hold on. Let me look. Is that Jennifer Abrams Family Court? Yeah, that's okay. That's what I thought. She was in our Nevada judges here, and I think Steve Sanson, I think, is the owner of the YouTube channel. Right? He's the owner of the YouTube channel Veterans in Politics.
Video on Jennifer Abrams versus Steve Sanson and Louis Schneider. An appeal from an underlying civil action implicating defamation and business disparagement on one side and freedom of speech on the other. Mr. Sanson and Schneider sought dismissal under anti-SLAPP statutes in an effort to fend off lawsuits brought against them and Mr. Sanson's organization, Veterans in Politics International. Interest in this case stems from Mr. Sanson's war upon the family division of the 8th Judicial District Court, with Mr. Sanson alleging pervasive corruption throughout the Judicial District and District Judge Bryce Duckworth denouncing Mr. Sanson as a corrupting influence himself, alleging he contaminates the judicial process and attempts to alter the outcomes of individual cases.
My name is Steve Sanson, and I want to talk to you about corruption in the Clark County family.
It is the height of hypocrisy to decry corruption and then engage in the very practice you claim to be attacking and shedding light on. Communication with a judicial officer about a specific case, inclusive with veiled threats, is corrupt. This is about outside interference in the administration of justice through intimidation, threats, and improper influence. This is an attack on our system of justice.
The underlying cases were disposed of by District Judges Michelle Levitt and Kathy Hardcastle. Levitt rooted her analysis in a family court case involving an exchange between Ms. Abrams and District Judge Jennifer Elliott, which was recorded, retrieved by Mr. Sanson, and published.
Yeah.
Ms. Elliott responded by ordering Mr. Sanson to take down his publications, only to later vacate that order when Mr. Sanson was confronted by efforts to have him held in contempt of court. Ms. Abrams sued for defamation, and Ms. Levitt ultimately ruled that sealing transcripts or closing a hearing does not transform a judicial proceeding into a wholly private matter, drawing connections between the legal practices and courtroom behavior of a lawyer, citing case law linking such conduct to matters of public interest, and dismissing Ms. Abrams' lawsuits. District Judge Hardcastle dismissed the claims against Mr. Scheider despite allegations the video in question was improperly retrieved and handed over to Mr. Sanson.
Yeah, so the attorney that we saw earlier, and I think it was so the attorney that we saw earlier that was going back and forth with the judge, she saw that video of what we just saw was publicized online, and then ultimately she tried to sue the owner of the YouTube channel Veterans in Politics for defamation. I think she lost. And honestly, I'm kind of siding with Veterans in Politics.
Sanson on the basis that Mr. Schneider himself is not alleged to have made any defamatory statements. We filed a media request, and Chief Justice Mark Gibbons granted that request, allowing us to broadcast live from the Supreme Court of Nevada on December 12th at 1:30 Houston. You can keep up to date on all of our media coverage by visiting our website.
Yeah, I don't think she had much of a case. Like, ultimately, it sounded to me like the only reason she sued was because she got butthurt over how bad it made her look. That's all it was. That's what it came down to.
Good morning, council. We just received your exhibit books, but they don't have an index.
All right, what's this all about?
It is an exact replica, I should have the exact replica of the proposed list of exhibits that I filed last week.
Well, you need to have an index and admitted, objected, the columns. You need to have that chart on there.
Yes, Your Honor. I don't have the chart.
You don't have a chart, okay. All right,
Your
so
Honor, may I approach the witness stand so we put a copy of these exhibits on the witness stand?
you can, but we still need an index.
Well, actually, okay, so this proposed exhibit 7,000 does have this. I guess I understand. And the door doesn't have it's just
I have no idea what's going on.
That'd be a start.
yeah. I mean, I can use it.
But this one apparently also gets spicy.
I don't mind. I can use it. Yeah, I don't mind. As long as I have titles, I'm good.
Excuse me, Ms. Bonds.
Yes.
So, excuse me, this morning you filed something called an exhibit appendix,
Correct.
and yesterday you filed a pretrial memo. I did not read it.
Right. I got all of my paperwork yesterday for the first time, and I was not aware of everything that I needed to turn in. And it was my error because when I had done an address change, I did not put my apartment number on there because I had just moved. And I just found out about what was going on, and so just my error, mistake. So when I came in yesterday, that is when I got all the paperwork. So they pretty much gave me everything, and they said that I should probably submit something because I was going to ask for a continuance so I could obtain legal counsel after seeing all the new motions and complaints filed.
Did you live at 5815 Nouveau Leon Street?
Yes, that's my address. But it's apartment 5.
So are you saying you didn't get the case management order that was mailed to you in October?
No, I haven't received anything since I think August.
Okay.
The only thing I had, and it was at my old address, was for the mediation. That's it.
Why would you not give us your apartment number?
It was just a mistake, just an error, because I came in and I had so much paperwork to file here. I honestly didn't even think about it. It wasn't on purpose. It was last minute, and I came in and I was rushing, trying to get paperwork done and file things.
Hang on.
No, not last minute. Back in October. Why wouldn't you give us, or September, when, this action has been going on for over a year?
Right.
Did you think at some point we would need your correct address?
Well, I didn't realize the error until yesterday when I got the paperwork.
Yeah.
When I came in,
Probably not the best idea. Hold on.
I don't have anything. And
you were in court.
Yeah, I would agree. I think I need to find something like at the beginning. I guess. Well, this one's a long one, but it has all 3 parts available to it.
We're on the record in the Jimenez matter. Case number D507566. Your appearances, please.
Good morning, Your Honor. Val Fuji, bar number 5955, on behalf of the plaintiff, Angela Jimenez, who is present along with family for support.
Thank you.
Attorney Don Lozano, and I have Lupe with me at my table, as well as Catherine Vies, and my bar number is 3475.
Thank you. This is the time set for an evidentiary hearing regarding support obligations and order to show cause. Counsel ready to proceed?
Yes, Your Honor.
Okay. I have one set of exhibits. Do you have any exhibits?
No exhibits to offer, Your Honor.
Okay. All right. Very good. All right.
And Your Honor, we were just given a copy of the pretrial. I was told Ms. Fuji was withdrawing. I didn't even see this until 2 seconds ago on this pretrial memo, just so you know. I was not served with it. And then for the record, Ms. Fuji was supposed to file something for an order to show cause, and nothing was filed, and it was deficient. When Mr.
This is a different case.
Jimenez did that, a matter was taken off calendar. This was then put on calendar, and it was not corrected. So I'm wondering why we're going forward with an order to show cause when in your own order it shows that her order was deficient. I'm asking just for the record because I need a record, Judge. And then you chose to go forward on an order to show cause when her order to show cause was deficient pursuant to your order. But you didn't do that for Mr. Jimenez. You overlooked his deficiencies. You didn't overlook his deficiencies, but you overlooked Ms. Fuji's, and she's a lawyer.
Uh-oh.
And then I'm asking why. I'm asking why, Judge, for the record. Because I don't believe that we're going forward on that because we actually had that matter paid off immediately, and that's part of the record as well.
And Your Honor, I believe the pretrial memo was filed last Thursday, Easter, to Ms. Lozano, who received a copy of it. Substantively, it was a recount of the events that had taken place thus far. Logistically, there's no prejudice because there are no additional witnesses and no new evidence listed as exhibits to that pretrial memo. As far as her allegation regarding a deficiency to the order to show cause, If the court recalls, I had filed 2 previous orders to show cause. Back when it was deficient, it was failure to file an affidavit with more detail indicating which part of the orders we were seeking to compel. The court then rectified that at the subsequent hearing on May 16th, 2018 in your order when you said we are going forward on the order to show cause why the defendant should not be held in contempt of court, specifically for the bonus that he was ordered to pay 100% of, and by his own admission in the court minutes, court's indulgence, he failed to pay. So those are the language of the court.
Which was corrected after the last court hearing, but her deficiencies weren't. I'm asking specifically as to that issue. Mr. Jimenez filed a notice to change this in November, right after the hearing. It would have stopped all this bleeding back then, Judge. You said no because it wasn't procedurally proper. I agree. Ms. Fuji, an attorney, then was told by this court to follow up on an order of show cause. Did not do it. Didn't correct the deficiency. But the court thought it was a good idea to correct the deficiency for Ms. Fuji. Per what she just said, and I don't believe that that's proper under an order to show cause. It has to be done properly, but...
Okay, so his attorney's trying to allude that the judge is biased against their client or biased in favor of opposing counsel. I mean, obviously.
By the litigant bringing the proper affidavit, which was not done. The court cannot correct an affidavit for a party. So I believe when you're saying we're going forward on an order to show cause, there is no reason sufficient to go forward on an order to show cause because it was not done properly. It's in your order that it's deficient.
And Your Honor, I'm referring, I pulled the minutes specifically regarding this issue and the case where the court found deficiency, which was subsequently rectified by this court when it took testimony and the defendant was admonished for not giving 100% of his bonus that was previously ordered and reduced to judgment.
My recollection is that he made the admission in court.
That's correct, Your Honor.
And that was the reason.
And that is correct.
Order to show cause.
That's correct.
And what I'm saying is her deficiency was overlooked where his was not, when this could have been corrected because his income was not $98,000 like she represented at trial. It was $78,000, but he was improper person.
Deficiency usually means that it's not up to par. Not the a filing is has a technical issue that would warrant a dismissal, or require the court or require the attorney to correct a deficiency, or else the matter would be dismissed. What she is saying is that the court, while the court dismissed or took no action on the father's supposed deficient action, when it came to a deficiency in the mom's deficient action, the court fixed it for her, allegedly. That's what's being alleged here.
Okay, so that's why we have this incredible judgment like this, and you're thinking that he's not paying or taking care of his family. They made the same income. She actually got a college degree while they were married. He helped pay for it to finish it off.
Are you arguing your case now?
No, you're wrong. I'm saying they're going backwards on a matter that we will have to go backwards on because of the income. Okay, and what I'm saying on the order to show cause, there was no proper order to show cause that was issued because, again, what he admitted to was, did you get the bonus? I got a part of it. Smith's was not properly served by Ms. Fuji's office with the order. He took what he was given as soon as he found out when we were here in court that he got a part of it still, okay? He immediately paid it back, and he said that in court as well. Okay, that we were going to take care of it. His family, right as we left, got the money orders, and she got it within 24 hours in her office. So why we're in an order to show cause on that matter is a waste of the court's time, and she needs to tell you that she got that within 24 hours.
And, Your Honor, just to make the record clear, this court has an excellent record in this matter regarding the notice and entry of the order for the wage and bonus assignment, which was filed on February 14th, 2017, and the notice and order to show cause filed on July 6, 2018, where Guadalupe is directed
I don't think
to
so,
appear
Lane.
before the court on today's date to show cause why he has failed to pay, specifically all future bonuses, in accordance with EDCR 7.21. He stated in court, he spent it, in addition, that he received the 50%, and he was ordered to then provide it to my client, and Ms. Lozano was ordered to see why Kroger is ignoring the orders of this court.
And that's because Ms. Fuji didn't serve him with the order. Right there.
We're prepared to go for, I believe that's an allegation that's unwarranted, but...
But she said that Kroger didn't get the order in court. You want to go ahead and say what she said? She didn't get it. They didn't serve him. And a pro per didn't know what to do, but a lawyer knew what to do.
Why is this not in your brief?
Your Honor, again, if I was told that she was withdrawing, there was not even a pleading, not even a document that's showing that they were going forward today. Okay, so again, I thought we had a motion to withdraw because we had that. We were talking to your clerk on Friday.
Yeah, it's set in September.
I understand that. I understand that.
Issue an order.
And then we have no documents going forward. Nothing has been complied with on the pretrial order. I didn't even think we were going forward today. We're here. Again, I did not even know that she had hired attorney again because she was withdrawing.
Judge, so for the court's edification, which really proves that she does get e-served the filings in this matter, I had moved to withdraw. I had moved to withdraw before an order reducing my attorney fees to judgment for Ms. Jimenez in excess of $15,000, for Lupe for $7,000, neither of which were being paid or ordered. I filed a motion to withdraw. It was denied. Therefore, I'm prepared to go forward today, Your Honor. And if counsel's done with her I guess it's pre-hearing argument, I'd like to make a brief opening statement.
Well, it's my understanding that he's purged any contempt.
Absolutely, Your Honor, and she knew that before coming in here today. I'm just saying, I want us to use the court's time for what you said we were supposed to do, which is he willfully underemployed?
No,
there's no time. There's nothing that's been showing that from the beginning of time.
Interrupting.
Judge, if I may, the only thing that's reserved is my attorney fees. He made an admission in open court. Regardless if Ms. Lozano believes Kroger didn't get the order, regardless of what her belief might be, Mr. Jimenez knew. And this court admonished him not once but several times about this bonus. And he admitted in open court that he received it, and that not until we brought it up was he then truthful about it and was ordered to then provide in accordance with the order to my client.
And the order was never served on Kroger by counsel. That's
Is it water bill? Yes, Your Honor, just to make it brief. Thank you. Court's indulgence. Okay. NRS 125-1507, subsection 7, allows modification of alimony and or child support based upon a, quote, changed circumstance. NRS 125-150-12 allows a review if there's a 20% change. However, that review does not entitle Lupe to retroactive relief. This court stated it in its May 18, 2018, or May 16, 2018.
I believe this is an order to show cause on a modification of not modification of custody, of child support, or it also sounds like there may have been an order to show cause that the husband hid out, hey, Fairy Dust, this is actually a different case. I'm taking a break from the McDonald one. It sounds like it's also could be the case that the father did not disclose extra income he was getting, and therefore warrants a modification of support. I think that's what the issue is.
18 order, and I will state it again, notwithstanding the pretrial memorandum confusingly filed by the defendant in this matter. The decree or agreement is not subject to modification by the court as to accrued payments. Colati versus Colati, there's numerous cases on this, judge, that go back in the 90s. Nevada law clearly prohibits retroactive modification of a support order. Payments once accrued for either alimony or support of a child become vested rights. These are rights that parties count on. These are rights that parties look forward to, a budget based upon, and therefore they cannot be modified or voided. Now, if counsel needed edification, Shriver case, 1992, explained what accrued payments are for purposes of modification under NRS 125, 150, subsection 7. You don't get retroactive credit while you're in arrears. All right? Keep this in mind, Judge, because as we sit here today, even though we haven't had an evidentiary hearing, it is my client whose alimony of $900 a month for the next 72 months, plus $1,100 for the next 36, it was her support that was suspended. Lupe, as of June 1st, the court, before this evidentiary hearing, suspended the alimony payments. So it is going to be my client who, for 4 months, an additional $3,600 that we'll be seeking here today. Now, the Minere case. Judge, where evidence of willful underemployment preponderates, presumption will arise that such underemployment is for the purpose of avoiding support.
Willful underemployment. Ooh, okay. So he's trying to say that he's purposefully not getting more work, or purposely not working to avoid having to pay child support. Interesting.
The burden of proving willful underemployment for reasons other than avoiding a support obligation will then shift to the supporting parent. Further, willful underemployment is always a factor for the court to consider in setting alimony and for modifications of the same. I'm citing Rosenblum and I'm citing Rodriguez. In this case, Judge, we have one better. You reduce things to judgment. This court entered orders. The defendant failed to follow those orders. Those orders then were subsequently reduced to judgment. By law, under Rule 60, him and his counsel would have 60 days to set it aside, or at least, under Rule 59, file a motion for reconsideration within 10 days. That was not done. I appreciate that not 3 years later, not until we finally got garnishment, finally, did he then hire Miss Lozano to take a second bite at the apple. If I may read from the court's order after May 16th. There is no evidence to support why he is demoted. He suffered a demotion. The court did not find him credible in his first motion. There were no viewed, any demotion, or any evidence to justify his complete disregard of the orders. Now on this second motion, the facts are no different. He has appeared to neglect his job duties. There is no evidence to determine the cause of defendant's failure to perform at a level he was capable of in the past. Defendant certainly demonstrated a lack of desire to support his family during the pendency of this divorce, even misrepresenting his income and falling behind on his support obligations from the very beginning. This is page 3 and 4 from the May 16th or 26th, 2018 order. Your Honor, you are going to hear no evidence in this case. This could be an evidentiary hearing that would be done by legal briefing only. I tell you this because the mere fact he now says he doesn't make the money he used to make is not enough to prove he's not willfully underemployed. Giving us a 1040 without attachments, with no W-2s, or one paycheck stub isn't going to cut it in this case. Ellis Carucci allows this court to review credibility of the party, and that will not be disturbed on appeal because you get to see these parties over and over again. As attorneys, as judges, our job involves a lot of mental forethought. We have to be prepared and we have to think on our feet. Your Honor, the evidence in this case will show that Lupe Jimenez was demoted because he failed to walk the floor daily, and he failed to hold meetings with his staff. There will be no documentation to explain that he somehow was unable to walk, or that he lost his voice or suffered from late laryngitis, nor will you hear from a medical expert that he suffered from depression or mental illness, or he sought treatment or took medication for some reason, physical, mental, or otherwise, that affected his ability to earn the same money he did for so many years.
Well,
case law, should this court require additional briefing, our more recent appellate court cases show. If you have a history of misleading the court, failing to cooperate, failing to follow orders, this court can conclude that any request to modify his child support or alimony obligation is good enough. without having to do a detailed analysis, which would not be disturbed on appeal. In addition, Your Honor, fees is something that is still outstanding. That's reserved for the plaintiff and not the defendant. NRS 125.150 subsection 3 provides that you may award reasonable attorney fees in a divorce proceeding. Also, NRS 125.180 subsection 1 may also award attorney fees associated with obtaining a judgment for support arrears. However, the only excuse why he hasn't paid his fees that he was supposed to pay before 3 years ago, and that was to me of $8,000, would be for a hardship under NRS 125B.1402 subsection C. However, he has made no allegation or claim for the same.
07.
When we go through, Judge, today, it's easier because there are judgments. Judgments that you can see even in the Register of Actions that were filed in 2017, refiled for judgments in 2018, all of which he has failed to set aside. So keep in mind when they try and do these funny numbers, if he had 6 months, he cannot change those already reduced to judgment. Now we talk about those that are accruing. I think you'll hear evidence that the defendant would like to somehow retroactively go back to October 2017 because he filed something. Your Honor, once a determination is made and an amount is reduced, those amounts are accrued and earned. If it has already passed October 2017, those are accrued and thus cannot, in no way, shape, or form, under the court statute, which you so aptly stated in your order of May 2018, and I have reiterated this morning in the case Colati, is a vested right and cannot be altered. It's unfortunate we have to go forward today. I feel like we keep recreating the rule. What always happens, though, however, is that things keep accruing. The evidence in this case will show under Jackson, insofar his expenses are affected by cohabiting
maybe my first outpost
and his roommates with his family members. We can, in fact, increase it. The fact that hers has been suspended. It took 3 years, Judge, to get this, and the evidence will show. One other thing. That waiting so long cannot give the defendant an unfair advantage. The court's indulgence. What's the bankruptcy case? Not Allen. Siragusa, yeah, Your Honor. Siragusa was a case where the guy tried to pay alimony up front super early and said the period had expired. Therefore, the wife couldn't go back in and get additional alimony. And the court said you can't do that. You can't pay early to try and avoid your obligation or to prevent her from coming in to file for more alimony. Following that same vein, you can't wait to pay. You can't wait 3 years to pay. You can't wait 3 years to pay and then say, I want to go retroactively back. And that's what Siragusa says. A supporting spouse cannot deprive the court by jurisdiction by failing to make alimony payments. And that's further reiterized by Brown. In this case, imputed income, and there's a series of cases, when someone's not making their actual earning capacity. There was a case where a gentleman relocated to Australia, got another job. The court did not modify, and it was not disturbed on appeal because
let's wrap this up.
He didn't explain any reason why he wasn't making the lateral position, even though he went out of the country and had to relocate. He didn't show any job searches, any attempts for movement laterally, any phone calls made. In this case, Your Honor, you're going to see evidence from 2016, a record of a demotion, a one-page sheet that with nothing more, without any explanation, is not going to be sufficient to sustain a request. Thank you.
Okay, Your Honor, you already know the background.
Finally.
You had a party that we were divorced over 3 days, okay? And then you took the matters under submission so that even though we had 3 days, January 26th, February 10th, and March 21st for the trials, we had the decree entered the 26th of May, but all the financial issues weren't done until, let's see, October 25th of 2016. Immediately, he filed a motion saying, look, I need to do something about this. We found it to be deficient. He didn't get it. He didn't take care of it. He had to get money together to hire an attorney. We filed it in September of 2007.
Oh, wow, really?
It's not 3 years, so I don't know the math we're doing on 3 years.
Nice.
Hasn't been 3 years. Okay? I did it less than a year after you entered the financial information. Okay, after that. How we got here, Judge, you have to understand, it was a crazy order that was never stopped by prior counsel. He had Kurt Smith on there before. She moved out of the residence. He stayed in the residence. She needed money to leave. No one stopped the bleeding.
Thanks, Paul. Thank you for the gifted,
What was interesting is I haven't even pulled the Social
subs on
Security
Twitch.
records. Okay? And it's all the way through. They're making about 50, 60, 50,
No,
60,
please don't
70,
refer.
50, 60.
Okay, please don't refer to documents
I
that
don't know.
are
This
not
is
in
not even,
evidence.
and it's not even. It's not going to be. It's only going to be references. It's not something that's in the evidence that we've even put in our book, Judge. We have it. Okay.
I don't
Well,
want
then
you
if
to
the
refer
evidence
to
is gonna object-
documents in your opening statement.
And it is an opening statement, Your Honor. Absolutely. Okay. But it'll show through his testimony. I just picked it up because I don't know his testimony. But his testimony, it'll show what they make: 50, 60, 50, 60, 50, 60. She made the same money, and she actually got a degree during their marriage. Okay. He'll ask me to testify as to what was happening because he started working for Smith's for $3.80 an hour as a beggar. Okay.
Ms. Lozano,
Yes.
this is all pre-decree.
And I understand.
I'm not going to revisit.
I understand,
Sounds
Your Honor.
pre-decree.
I understand that, and we're not arguing that. And you have a pre-trial.
But you
that
are
says-
arguing pre-decree, so please
No,
go
Your Honor.
post-decree.
Again, she was saying 3 years, and it wasn't 3 years, and no one was stopping her. What I'm saying is, this is what happened in this case. They were making the same money. We have a judgment that got out of control. She's saying we never should have ever changed it because it became an order by this court. You know that life is fluid, okay? We know that none of the orders say if you can't pay it because you truly can't pay it, and it's in good faith, okay, then you can come to this court. That's why we have statute on point. That's why we have case law on point that she's referring to. And Minier and Rosenberg, guess what they did? Huge jobs down to nothing. Neurosurgeon down to $1,200 a month. No. Or if you're making twice as much in another jurisdiction moving to Nevada, you should be making more. But that's what happened in Rosenberg. No, that's not what happened. What happened in this case was Smith's. He's been working there for 25 years. Okay, started as a bagger, got all the way through. And that's what I'm talking to you about right now. Nothing pre-decree. He's been doing this 25 years. He's not going to quit because someone had a problem with him because of a corporate changeover. What happened at the time of the divorce?
And I'm just
Kroger
gonna,
and Smith, what happened? This is going to be a testimony. Again, I didn't stop her in her opening either when she was misquoting even how long it was been since it's been in front of this court.
Your Honor, if,
I'd appreciate the same. I'm almost done, and we can finish.
Ooh.
What is
Caddy.
Your Honor, and she misstates the record because the motion that he filed was with counsel, and there was an argument, and the court heard that argument and reaffirmed its order. She made it sound like there was no argument, that he didn't get it on because service was improper. That's correct, but then he did it with a lawyer, and we had a hearing, and at that hearing, he presented his own testimony, and they lost that motion. So I just wanted to quote that. But I will be making an objection. If she filed it within a year, I don't care if she filed it within, 7 months. If it's beyond 6 months under Rule 60, they didn't set it aside for mistake, for neglect, for error of law by this court. They cannot speak to it. So in order to expedite today's hearing, it should be focused on what the court asked us to do in its May 2018 order, and that should be why, and what relief he's asking going forward as to child support and alimony, I presume, because the other things are judgments.
Thank you.
Yes, Your Honor. But if we don't show how we got here, then you don't understand how big this thing got, which out of control. When they're making about the same income, for them to have an outrageous spousal support award is incredible. In his wages, she went back 3 years. Okay, in the wages, it showed one bonus of $118. One bonus of $100,000. One time. And you use that to go ahead and calculate spousal support. That's why we're here. It's not a judge set aside the order. I already put it in my pretrial. Those judgments stand, and I already said that in my motion. I've never asked for anything different since September 29th, 2017, and it hasn't changed. What you thought was going to happen was that the position was going to open. No, he is no longer
She's
the
arguing
manager.
the case, Your Honor. I'd like
Your Honor,
her testimony.
I am arguing what he will be saying on the stand,
Okay.
and that's what an opening statement is for.
All right, you don't need
Okay.
to be so loud,
Okay.
please.
So, he will tell you about what happened with the corporate changeovers. Everything's changed in the structures of Smith's. Okay, Kroger, Smith's. All
Welcome,
things happen.
Steve
They're trying to stay
944.
ahead of Amazon and Target. All the people that are trying to do groceries. They're trying, and they're doing a lot of things to keep innovative to stay ahead of the curve. He believes in Smith's. He believes he will be able to get back up, but they've changed the structures. There is no longer manager and assistant, which has a certain salary amount. No, now it's manager and 3 assistants, which dilutes the salary. Okay, he's one of 3 assistants. So again, to get back up there is going to take a lot. She went to college and finished college during the marriage. He couldn't afford it because he was helping her get through and continue to raise the children. Guess what? He didn't go to college. They're now passing him over for people that went to college. Okay, that's at the same time. So he's going to have to testify as to what happened in that time and where we're at right now. He's trying, and he's still with the company that he believes in, that he's worked with since his only job. He's been there since he was a bagger. $3.80 an hour. They met 2 years later. They were married 2 years later. Okay, so they came up together making. There was no big disparity in income. There was no need for ability to pay. I'm saying that's what got us here, Judge. Now we have these judgments that he's having to pay. He'd love to pay the prior judgments. He wants to pay the prior judgments. He just can't afford the stuff going forward. With the stuff going forward gone, and the proper child support being calculated by this court, he'll be able to take care of it very quickly, including Miss Fuji's fee. Okay, all of which we've acknowledged, Judge. Okay.
Thank you.
All right. Your Honor, at this time, I'd like to call Lupe Jimenez to the stand.
Thank you, sir. Appreciate it.
Please raise your right hand. You do solemnly swear the testimony about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please be seated.
Your Honor, for purposes of this case and expedite, I'm going to ask to treat Mr. Jimenez as an adverse witness.
Okay.
Thank you. Lupe, you're here today asking for relief from this court for future child support. Is that correct?
Yes, that's correct.
Okay.
To be able to cater to my children,
here we go.
to make sure that they, their father can take care of them. Yes.
Okay. And where are you living right now?
I'm living with my brother currently.
Is that where you were living on or around December 2016? Same place?
No, that is incorrect. I was living in somewhere else.
Where were you living at that time?
At 984 Cove Haven.
Who was living with you then?
My brother was.
Okay. So you were living in a different place, but you were still living with your brother?
Yes, but at that time that was something that I was renting, and they were saving money to buy a home for them and their 4 children. I was only paying $5 more a month than Angela was, and the house was big enough, so I let them stay there. Yes.
Okay. And now you live with your brother?
That's correct.
And your brother's family?
That is correct.
And how big is his family?
They have 4 kids.
Okay. And the place you stay at, are you renting?
Yes.
Is your brother on the lease, or are you?
No, my brother is. My brother is. He's the owner. Him and his wife are the owners.
And so you're renting from your brother, and he actually charges you rent?
That is correct.
How much does he charge you?
$500 a month.
Okay. That is less than you were paying on around the days of this divorce in January and February 2016. Do you know that?
That was less than I was paying. Say that again?
At the time of the trial in this matter, which was January, February, and March 2016, you were paying more. Do you recall that?
Yes.
So now you're paying less. Let me ask this. The reason for your request to pay less child support, isn't that you're saying because you were demoted at your job?
That's partially, obviously the income has something to do with it. Yes, I was demoted at my job, and I have less income now, so.
Well, you say you have less income, but we know already that you have more additional funds in which to pay because you pay less rent. Is that correct?
That is incorrect, because I still have to fluctuate all the bills that I have and provide for our kids, to make sure that they have the clothing, school, and lunches, and in between that.
Okay, so let's talk about that. You say in your financial disclosure form that you pay $200 a month for your children's clothing. Is that correct?
Yes.
Would it surprise you that Angela's never seen any of these clothing that you've bought for the kids?
I don't know what she's seen, so you guys have never seen anything that I've done, but I do it.
Okay. And as you sit here today, you still aren't paid up on your child support arrears, are you?
Objection, Your Honor. The record shows that different.
I don't know what kind of objection that is.
Objection. Cause for legal conclusion.
He knows. Isn't it true you aren't paid up in your child support?
Same objection, Your Honor.
It's a question he can answer.
You can answer
don't
the
look at your
question.
counsel. You have to answer me.
Oh, I believe that's paid up. You guys garnish all the wages, so I don't have a detailed format of it. I believe that's paid up.
But you don't know for sure.
I don't see how it's not paid up.
Okay. But you don't know for sure.
It should be. I don't know for sure the details because I don't have a statement in front of me that says how much I've paid or haven't paid. But if the child support arrears should already been paid off a long time ago, because the only thing that hasn't been paid was the alimony. Okay.
When you say the alimony, isn't it true you're supposed to pay $500 towards the equalization payment of $29,000 per month? Wasn't that the court order?
Don't I pay it don't I pay that?
Again, objection. Ask for legal conclusion. He's getting the garnishment done.
Your Honor, I'd ask that counsel make a proper objection.
Objection calls for legal conclusion.
Okay. Here it is. It's over with. No team. Were you aware that you were supposed to make, were you ordered to make $500 towards the equalization of payment arrears, and you've made none?
Objection. We've had the
It's a fair
garnishment.
question.
She knows they're being garnished. She
Uh-oh.
absolutely knows because she's gotten almost $20,000. So she
Your Honor.
does know it's
Spicy.
been garnished.
Your Honor,
See you later at 98.
I can ask questions. She has an opportunity to redirect questions, show items otherwise, but I can't have counsel testifying. Your Honor, there is ample evidence in this case prior to today, and judgments that have been filed. Schedules of arrears. If there is something otherwise, I'm sure counsel will, and Lupe will give it to us, so we'll know.
Okay.
So,
Your Honor,
again,
objection, Your Honor. We have no schedule of arrearage that has been filed in this case. There are supposed to be things filed in this matter. You had a pre-trial that said file things and have things done. Can you tell me for the record, is there a schedule of arrearages that's been filed? I have none.
All right, Your Honor, counsel.
Your objection was calls for a legal conclusion. I overruled it.
And then I asked, was there a leak? Because she's referring to a schedule of arrears. Again, I haven't been served with anything, so I want to make sure for the record, is there a schedule of arrears that you
Your
have,
Honor,
Your Honor?
I can't, if counsel doesn't have the ability to read the Register of Actions, to read the schedule of arrears that were previously filed, and the subsequent updated schedule of arrears that were filed the first time he tried to do that, up until June 2000, if the court
So
recalls...
nothing's been filed since the garnishment, Your Honor?
You know, if I may, if the court recalls, you
Are you
had
going to
both
open
of us-
houses in
you
Florida,
sent both of
Brad?
us to do briefs
I assume that's the
after
case,
June,
right?
well, right after the first time we came in March 2018, and we did. We filed, and we did schedule of arrears on every single thing that were filed. If counsel doesn't have access to the Register of Actions, doesn't know the pleadings, doesn't know the procedural history, I can't be interrupted. What I don't want is to go beyond my scope of direct, because I'm trying to keep it narrowly tailed so we can get this done
And
very
Your Honor,
quickly.
she can't ignore that they've been getting money. Ridiculous.
Oh my God,
Opportunity to
spice!
cross-examine.
She's ignoring the fact that
We are not getting
Stop.
zero
Stop.
on the equalization.
Stop. Your objection was overruled.
Thank you.
Continue your examination. You have a chance to cross-examine. And yes, there are schedule of arrearages as of May 2018 that are filed in
I
this
know,
case to answer your question.
Goodness.
Were you aware you were ordered to pay $500 a month towards that $29,000 equalization payment?
On top of the garnishment?
Yes.
No.
Were you aware you were ordered to pay past gymnastics expenses of $19,000 for Ivy? And that also is not being garnished.
Objection misstates the record, Your Honor. There's no $19,000.
There's no record about a garnishment, so I don't know.
So I said absent
So
the
I have to overrule
garnishment.
your objection because the garnishment is not in evidence. Go ahead and answer the question.
Ask the question again, please.
Were you aware there's a judgment against you for Ivy's past gymnastic expenses of approximately $19,000 that's not being garnished?
I know there's a judgment, and I don't have the funds to pay those extras, so you guys are garnishing my wages, and I'm to my limit.
Okay.
yes.
So let's talk about that. So as you sit here today, have you paid anything on your own volition without it having to be garnished from your paycheck?
I have no more income that allows me to do that. Half my wages
Julian.
are gone. I have to be able to provide for my kids food, clothing, outings, whatever it may be. That's what I need to do. Before I pay any other thing, I have to take care of them.
So the equalization payment of $29,288.40, for which you were ordered $500 a month in arrears, you have not paid anything for, correct? It's a yes or no.
Well, I've been getting garnished. How can I pay it?
If I were to tell you the garnishment...
Objection, Your Honor. Calls for a legal conclusion. She doesn't know where the garnishments go.
If I can get my question out. The garnishment is coming from the district attorney's office, not from me personally, Valerie Fuji. You understand
or
that?
the court or wherever it's going, I'm still having to put that money out.
You aware it's coming from the DA's office, yes or no?
I do.
Okay. Are you aware the DA is not garnishing the equalization
I assume
payment
the
that was reduced to
gymnastics
judgment
per
for
year.
which you were to pay
I'm assuming the gymnastics costs per year. $19K a month is wild.
$500 in arrears.
Objection calls for legal conclusion. Objection calls for speculation as to what the DA's office is doing or not.
He already answered it. He said yes. So, the gymnastics that was reduced to judgment, you haven't made any payments on that. That's not included. The equalization payment, you've made no payments on that. And my fees of $7,000, you've made no payments of that, correct? You understand that's not being garnished from the DA's office?
Objection calls for legal conclusion, Your Honor.
He's
He doesn't know
allowed
what
to-
the garnishment's on. He said, asked and answered. He said that several times. He doesn't know what monies are being garnished through his wage assignment. He knows half of his income is gone.
I see.
You don't know what you're being garnished for?
No, I just know that they're taking the money. That's all I know.
Let's go back. You're saying the reason you can't pay the money now, the past items reduced to judgment, anything going forward, because you make half the money you used to make, correct?
Say that again?
You're saying you can't make these payments now that were reduced to judgment and going forward because you're making half the money you used to make, correct?
Well, it was difficult then.
It's a yes or no.
Well, it's not a yes or no. It was difficult then, and it's difficult now.
Isn't it true, even when you made the money, you never made the payments?
We got to remember, I was renting a place for $1,600. I can't afford the $1,600 anymore, so I'm paying $500. So I don't have the funds.
So that frees up $1,100 for you to start paying towards the $70,000 of arrearages.
I don't live in $1,600 home because I don't have the funds. If I did, I would live there because my kids need this. They need the space. They want their own place.
So clearly you brought your expenses down because you're making a lot less, right?
No, because I can't afford anything. That's why.
Well, we know you're making about, according to your own testimony today, from $1,600 to $500 in rent, right?
Mm-hmm.
Okay, is that a yes?
That is correct.
All right. So
I take home about $2,000. Live off of that. That's tough.
your gross pay, according to your pretrial memo, is $6,000 a month, $5,800 a month.
I would say about $5,200 a month.
How much do you make annually right now?
$62,500.
Okay. And when you made over $100,000, you weren't making the gymnastic payments, correct?
I made over $100,000 one time, and that was that year. So that is incorrect. I didn't always make that money. We've always made about the same amount of money.
I'm not going to go into the
Thank you for the
history. You
five
were here for the
gifted
trial.
memberships.
You understand that your tax returns and schedules for 2012, 2013, and 2014 were admitted into evidence in this case?
Yeah.
You're aware the court had Kroger's records as well as yourself had your health savings plan, correct?
Yes. I handed that over before you guys did whatever you had to do.
That's correct. And you recall there being testimony about stock options that were cashed out?
That is correct.
And there was testimony about a health benefit plan or a health insurance plan, which you had access to put money in?
Yes, and I was putting more money in there, but now I'm putting less money in there because I don't have the funds, again, to put any more money in there.
And I just want to knock this one out because it was mentioned in your pretrial memo. You pay for the kids' health insurance, correct?
Yes, for all the kids.
When you say all the kids, all three, your daughter Sierra's 22, so
That
she,
is correct.
let's say, and at the time of trial, you testified it was $25 each or $75 that you were paying for all three kids. Is it still the same, or $50 for the two kids that are minors?
It's probably more than that.
Okay.
But I don't have a.
Do you have any evidence to support
I'm
that?
paying the insurance, if that's what you're asking.
Do you have any evidence to support how much you pay for those kids, that it's changed?
Yes, it's on my check stubs.
Okay. And that includes you and Sierra, however.
That
Do you
is
have a way
correct.
to apportion it out?
We can probably figure it out, yes.
If I were to tell you at trial it was $75, $25 per kid, Sierra being the oldest who's aged out, would you agree that's still around the same amount, $25 per kid?
Yes.
Okay. You were demoted on or about, what, February 2016?
I believe it was April.
April 2016? And you were demoted and you're still demoted to date?
That is correct.
Okay.
I got demoted because of store conditions.
You were supposed to apparently walk the store daily. Walk the store daily. That was something you were not doing. Is it something you're doing now?
I do that. I do that all the time. The problem is we were transitioning from having good quality to great quality, and then all the competition that was coming up and the competition that I had around me, they wanted us to have the best product, and we failed to do that quick enough.
Well, there wasn't a transition in your job by, for instance, strike that.
Where does he work at?
Your pay
I
did
don't
not
remember.
change for any other reason but for your performance, correct?
No, it changed because I got demoted.
And that was based solely on your performance, correct?
No, it involves others as well. And I mean, you're only as good as your people. So, yeah, it comes down to me because I was the store manager.
Okay. So what did you do, as you said here today, to try and find or to get your performance up?
Oh, well, we worked really hard as a team to try and get the store back where it needed to be, and my boss didn't think so I got demoted.
And why, since February or April 2016, have you not been walking the store and improved your performance such that you could make what you were making before?
Why what?
Yeah, it sounded like a grocery store or something. Smith's.
Strike that. I'm going to go back. According to the paperwork your attorney has provided the court, you were demoted for failing to walk the store and failing to hold meetings with your staff. Have you since improved those things?
Hold meetings with my staff. I improve it every single day. I don't know what that hold meetings with my staff means, but what they mean by not walking the store, they mean that you're missing steps when you're walking the store. So that's what they mean. That's what it means.
In 2 years, 2.5 years, have you improved?
At this point, I'm pushing to get back.
Okay.
Yes.
And what physical limitations do you have to be able to perform like you used to during your marriage?
Well, it's all in my work, so it all depends on trying to get back up. I fought for my job, and unfortunately, I was still demoted, and so now I got a black mark, obviously, so I have to show my work again and start all over.
If for the years of 2012, 2013, and 2014, your bonuses ranged between $20,000 and $30,000, and now your bonuses are what, up to $3,000?
Yeah, my bonus potential is $7,500.
That's a part of the demotion too, correct?
That is part of my level of for an assistant.
What physical limitations do you have that you were unable to meet with your staff or walk the stores? What did you have at that time?
You mean in 2016?
Correct.
It was just that we didn't get it's not that I didn't meet with them, it's that I didn't hold them accountable quick enough. That's what it was.
Okay.
So it's not that I didn't meet with them.
Well, you were functioning well at the time of the trial, and there was testimony about your pay readily increasing over time and being well over $80,000, $90,000 for 5 years, the last 5 years of your 20-year marriage. So I'm asking you, what happened all of a sudden where you couldn't do your job anymore that you had been doing for 22 years?
Well, not only
Objection for question that states the record.
You'll have an opportunity to cross-examine.
Yeah, you have her opportunity to
well,
cross.
not only was I going through a hard divorce and losing my family, which was tough. Okay, so that kind of did not help. And then just my boss didn't think it was good enough.
Well, you're over it now, right?
I'm over it.
Yes, the hard divorce.
Over it.
The hard
Jesus
divorce.
Christ!
I gotta get.
Okay, that's a very callous question to ask. Goodness gracious, that's a callous question to ask. Wow. I'm not rooting for any. Lane. I'm not rooting for any side here. I'm coming into this blind, but that's a pretty callous question to ask. I don't think a guy, if he loves his kids, could get over a divorce like 4 years later. I imagine it still kind of sucks. I don't know. I wouldn't know. I have never been in a divorce before, but I imagine in a divorce where you have kids, it's not something that you can get over after a couple of years. Yikes.
Get past. I gotta go on with my life. Let's just say that.
All right. So you must be under the care of a physician or doctor.
Why should I have to be?
Okay, is that a no? You are not?
No,
okay.
Correct.
So you saying you've gone through a divorce, more than 50% of Americans have gone through divorce and still been able to function at their job. You're saying because of this divorce, you're unable to function at your job in your full capacity?
I said at the point in time, I was going through a rough time.
Okay. So what do you have to evidence that rough time? Do you have any doctor's notes?
Do I need to have a doctor's note for
Yes.
that? Well, no, I don't.
No, I'm going to throw it out there and say that I imagine going through a rough divorce can potentially impact your job performance. I don't think that's out of the realm of impossibility. No, I don't think that you have to. I wouldn't say you needed to have a doctor's note to say that, the mental stress of a divorce can do that impact. I don't know. I agree. I agree. Having medical evidence can help, but the way I get it. She's opposing counsel, so I get she's got a job to do, but she's kind of making me a little bit empathetic towards the husband. But let's continue on. We're kind of still in the early issues here.
Okay. Did you have any physical limitations? Were you in a car accident?
No. But what about the other 50%? Do I all go to doctors?
So let me ask you this. What did you do when your income dropped so rapidly to find or supplement that income?
Say that again?
What did you do when your income dropped halfway to supplement that income? You have kids you have to pay for.
That's correct.
What'd you do?
Got my wages garnished.
No,
That's
what did you
that's
do
I
to
did.
supplement your income to meet your obligations?
I continue to work for the company that I've been working for 25 years, so I can get back to where I need to be.
There's I don't know how
There's
many.
only so much time in a day.
How many stores are there in Las Vegas? Smith stores.
Probably over 40.
Okay. So did you make any request job applications to any of those 40 other locations to see if you could get in a higher position?
Not yet. I have not.
Okay. Did you try and get an additional job, a second job, or something to supplement to make up so you could meet your financial obligations?
I have, but I haven't had time to do anything.
And you are, in your own words, this demotion is something that's permanent. You do not believe you can ever be back where you were before?
That is not up to me, but I put my best foot forward every single day.
And you've not asked for any
Oh my God,
increases
Riku,
in
stop.
pay since April 2016?
That's the answer to everything.
We get
Supplements with OnlyFans.
evaluations every year, and my year came up, and I did not get a increase.
Did you request an increase?
I get evaluated.
Yeah, Deacon, his claim is that he was making a certain amount, and that as a result of the stresses that came with the divorce, he ended up getting demoted at his job for poor performance. The mom's attorney is arguing that he purposefully got himself demoted so he can renege on his obligations.
By a number, 1 through 5.
That's the very cut and dry explanation of what's going on here.
Did you ask for an increase?
No, I did not ask for an increase.
Did you ask to stay the same so you didn't have to pay alimony or child support?
Why would I do that? That'd be silly.
So is that a no?
That's a no.
Did you apply for any job applications at any other grocery stores?
No, what I have done is applied to Lyft.
I don't doubt that I don't doubt that purpose. I don't doubt that what the accusations being like underemployment, like getting yourself underemployed to kind of skirt on obligations. I mean, there's no doubt in my mind that that's a thing. But so far, I mean, at least it sounds like his position is plausible. But again, we are at the very beginning of these hearings, so I'm sure there's going to be a lot more to be uncovered.
I've been able to work because I've been too busy. And
So are you a Lyft driver now?
I'm a Lyft driver, but I can't work. I haven't been working.
When did you start at Lyft?
I put the app in probably in May.
May 2018? Have you had any drives since?
I've made about $600.
Is there any reason this wasn't put on your financial disclosure form?
Because I haven't been able to work, so I just didn't. Oh, I see. Yeah, I guess I could have put it on there. I do apologize for that.
Do you recall?
I didn't think about it, to be honest.
All right, that's not good for him. All right, so that's a bit of a mark. That's a bit of a mark against him there. Yeah, you probably should have put that Lyft income in there.
Do you recall us having an issue with your prior financial disclosure form when you were paying $1,800 in alimony and $200 towards gymnastics of Ivy when in fact you hadn't done either?
Say that again.
I'll withdraw the question.
That was a mistake.
I'll withdraw the question.
As far as writing a.
I don't believe I have any other questions, John.
Do you have a copy of the exhibit book, Mr. Lucci?
Yes, I do.
Do you have any objections to anything that we have in there? Because I want to offer and admit.
No,
I
that's
have
to
A,
exhibit
B,
A.
C, D, and E right now, Judge.
Okay. The only objection I have is to exhibit C and D, as they don't include the required attached W-2s and the deduction schedule. So just for incomplete, but past that, no, Judge. No objection.
A and E?
No objection.
A, B, and E by stipulation?
A, B, and E, correct.
A, B, and E by stipulation, the other two with those objections? admitted or not admitted? I'm trying to find out.
Well, you can lay foundation. I mean, it doesn't.
B and E are admitted by stipulation.
And then C and D admitted, but you have an objection here?
I'd like to hear the foundation. I don't think you can do it without the W-2.
Kaylee, counsel went back and said that there was, specifically that there were tax returns that were admitted in your prior trial. They were saying that there was 12, 13, and 14. Did you go to Social Security to get a printout of what your wages have been?
Yes, I did.
Okay, in 2012, was it 53?
Objection, relevancy beyond the scope of direct.
It's exactly within the scope. She brought up the tax returns.
Your Honor, the 2012 tax returns, 13, 14.
Look, if I'm being honest, I'm doing my best to not, like, favor one side or the other right now because it's really early. That's number one. Number two, both attorneys haven't exactly been very, I don't know what's the... Both of them have been acting really catty, so I don't really have a high opinion of the attorneys, at least, of either attorney right now. So, but let's continue on. Again, I'm trying my best to, like, look at this at a very even playing field at this moment because, again, we're very, very early into this hearing.
We're all admitted into evidence. I printed out my exhibit list in preparation for today. All the Kroger records. We had a lot of exhibits over 3 days of trial. What I don't want to do is recreate the wheel. I want to focus solely on his claim under 150 subsection 7, I'm presuming 11, for changed circumstances warranting future support. So
Also
I just
true,
don't see
Lane.
the relevancy
Attorney demeanor
in
can
2012,
actually affect the case.
2013 or 2014 that's admitted into evidence. Or judgments that nobody can touch anyways.
Your Honor, we're having testimony. We're actually testimony from counsel saying, why did you get money so you can get the double income like you did before? She keeps ignoring they made that same money. She keeps ignoring that in 2012, 13, and 14, he made $53,000, $56,000, and $54,000 already in the record. She's trying to change the record now. Let's look over at the shiny ball. Maybe the judge will forget. But guess what? We can't forget.
I'm going to object.
That's what he was making.
Your Honor, this is improper redirect.
Am I going to be able to get out what his testimony is?
Well, I'd appreciate it if you would not yell, and I'd appreciate it if you wouldn't talk over
Throw
me.
a shoe! Throw a shoe!
Okay, so you don't need to yell.
And I'd ask
whoop his ass.
One person at a time.
We had testimony regarding 3 tax returns, specifically brought up, opened the door, kicked wide open by Ms. Frogi. I am following up. That's what I'm doing.
Go ahead.
Okay. 2012. I will show you this. What is this?
That's my income since I started.
Where did you get this?
Social Security office.
Did you go there
No,
and
I've
get
never.
it?
I don't see what you're showing him. You need to show
Again,
me.
I'm not offering it for evidence.
Oh, Your Honor, even
okay?
then, he's. Whoa.
Stop. You're not refreshing his recollection.
Yes.
You're showing him a new document.
You can't do that.
That isn't an exhibit.
You can't do that.
So no.
Do you know what you made in 2012, 13, and 14?
No, I don't.
Was it $100,000?
No, it was not.
Was it
About
$50,000?
I averaged about 78,000, 74. So.
Okay. So if I tell you from this document from Social Security, you made $53,273.01 in 2012. Would that be correct?
That sounds right.
For you?
Yes.
Okay, so your combined income was about $100,000, but your income, meaning you, was about $53,000.
Yes.
Okay. The next year, 2013, $56,111.59.
My-
Did you make that income?
I'm
Yes,
just
I
going to
did.
make a continuing objection as to relevancy, because it obviously
She
doesn't
said he
include
made
bonuses.
half. It was never the record. She's muddying the record. He has never made over 100,000. She keeps saying over 100,000.
I have here in front of me, so I don't need anybody claiming that someone's muddying the records. I have in front of me order amending, order of May 26th, and final decree of divorce, filed October 2016. And at that time, I made findings as to his income, his base salary of $78,000. Bonuses. I averaged his 3 years of income because he had different levels of income.
We introduced 3
and
years.
it's all in front of me.
And Your Honor, the tax returns that were admitted were the lower tax returns. And what I'm saying is what you based your income on is the higher one. Because the only one that is the high income is 2015. And it's $118,500. That was 1 year, Judge.
And
That's why instead of having to pull backwards, we made sure go to Social Security. This is exactly what you've earned. Okay?
I'm not revisiting these findings of fact I made in 2016.
And I understand that.
You
And
have
we
a chance
didn't
to set
ask
it
for that.
aside.
But what I'm saying, what she's doing is saying, did you get
Oh my
something else?
God.
Did you do anything else? She is still with the
So
company.
angry.
He is still with the same company.
I heard that.
Okay.
We get it.
Okay. So now, let's be very clear. Did Ms. Fuji take the 3 highest years that you made to do the income
Objection.
when there was a trial in this matter?
Yes.
Okay, stop. I don't need you to argue what I decided in October 2016.
And I understand that. And I understand.
Also true.
I was just going over the
I
stuff that she thought of
averaged his last 3 years, 13, 14, and 15. I averaged that, and I averaged his bonuses. So I don't understand why we're making an argument that this information that was presented at trial may be incorrect. It seems if someone's muddying the waters, it might be you, Ms. Lozano, and I don't need that. I want you to make a record of why he has a change in circumstances, if he does, why he has a change in circumstances, that he's not willfully underemployed, and that he's entitled to the relief he is requesting.
Absolutely.
I don't need you to re-argue the trial.
Can you please look at what's in front of you, which is Exhibit A? You've had it admitted. Can you tell me what that is, please, sir?
That's the performance improvement plan that I got put on, the 30-day performance plan.
Okay. And who put you on this plan?
Sherry Wing, my district manager.
Can you explain the hierarchy on how it existed then versus now at a Smith store? How did it used to exist when you were, well, first of all, what was your position then?
I was a store director.
Okay, so what was the hierarchy from the store director from then down?
And then we had 1 or 2 assistants.
How many assistants
But
did
I
you
only
have?
had 1.
Okay.
And then we had department heads.
Okay, how many department heads?
About 6 department heads.
When it came to this particular review, tell me why the year before, which is 2015, okay, why you had your biggest year ever. Tell me what happened that year.
Because we hit a lot of our goals, and we hit it as a company as well. So
Did you ever make over $100,000 except for in 2015?
no, that was the only year that I made that much money. But then we ran into competitors, and we didn't do as well the following year.
Okay, explain to me the transition from 15 to 16 corporately for Smiths. What happened?
We had a lot of competition, and we had, like you were saying earlier, the Amazon coming through with the home deliveries and stuff, and we needed to bump up our game, and we have, where we, instead of going from good quality, like in produce, we went to great quality, so we couldn't even have things that wouldn't, keep for more than 2 days in a customer's refrigerator. So
Okay, so explain, let's walk it slow. So, before, in 2015, you're in good quality, and your people are doing good, and you said there was awards. Tell me about awards in 2015. How many awards did you win of the 6 awards there?
Well, I did have like 4 out of the 6 awards, and
yeah, I'm kind of lost. Is what Chad is saying.
Unfortunately, I still got demoted.
Okay, but that was in 2015.
Yes.
When the corporate changeover happened in 16, tell me besides Amazon, who's your competition?
All Fresh and Easy, the remodels around the same store. Our store was one of the oldest stores.
Okay, explain what store were you at?
I was at Buffalo and Flamingo, and it used to be a Rayleigh's that never got remodeled. We had Trop and Jones. They had new facility. They redid it 2 different times. Flamingo Fort Apache. That was a newer store. Cleaner.
So hang on. So you're in the old store.
Yes.
With the good.
I'm going to object to leading. I'm going to object to leading because it's going there. Just
saying.
It's going there.
Tell me what store you're in compared to the other stores within a couple miles.
Becky.
Smith's. Just
Back then?
Just Smith's, yeah. 2016.
How far or?
Conditions. Why would people shop in yours versus the others? Just tell us.
Well, they would shop at the others because they have newer and cleaner facilities, and it's painted. I mean, it's good to the eye. Where I was working, it was older. Although we had the best customer service around there, they would like to go where they have more products, just variety and whatnot, because we didn't have all the varieties that the customers wanted. So we were a lower volume store,
and that happened in 16.
Yes.
And is that when you were demoted from store manager to an assistant?
That is correct.
Okay. Are you one of their assistants, or are there many assistants? How many assistants are there?
There are 2 assistants at my store right now. So we're supposed to get a 3rd one.
Gotcha.
But they're going through their classes until they graduate. So then we'll get another one.
What do you mean? Do they have to go to a school, to a store?
Well, they have to take, I think, a 16-week course, and they look at see if they they went to college and stuff like that to make sure that they're qualified for the jobs.
So now, going forward in this new good versus great corporate structure, do they want people that are college people?
Well, absolutely. That's what they look for nowadays, to make sure that they went to college, to see if they have any kind of degrees. So.
Did you go to college?
No, I did not. I made this my career, so I did not go to college.
And is this your intended career?
That is correct.
Do you intend to retire from Smith's?
That is correct.
Do you want to work for another company?
No, I do not.
So is it true when I hear that you made $118,000 that you made half of what was before? Was that a fluke?
Say that again? I'm sorry.
Was it unusual for you to make $118,000?
Absolutely. I just, yeah, absolutely.
Are you getting your wages garnished?
Yes.
Okay. When did the garnishment start?
I have so many dates, but I'm going to guess it was last year in May.
Do you know for a fact how much is taken out every check?
$1,647 throughout the month.
Okay. Can you
And $23.50 biweekly.
Okay, let's go to that. Let's look at your paycheck stub. And there's no objection to B, correct?
No objection to B.
Can you look at B?
Shows he's still married.
Can you look at it and can you see that this year, up until the pay period, which is July 2018, July 31st, that year to date, $11,529 has been garnished out of your check. Do you know if that's been garnished out of your check?
Where's that amount?
Yes.
Where, counsel?
Can you look at page 2, where it says 203? Ms. Magino,
Yes.
this is 203. And this is ACH Child Support 1.
Yes.
Okay. And then you also see fees are being taken out of it as well.
Yes.
Okay. So year to date would be $11,529. So that would be through July 2018, correct? July 31st.
31st.
Okay. And then also on top of that would be the $28, which would be the child support fee that's taken out. Is that correct?
That's correct.
Okay.
Yeah.
And then you said before the child that health insurance was $25, but I believe you took it from your
Objection
stub.
leading.
Can you look on there and see what your health insurance is? You said before it could have been $25 at trial. But can you look on there?
The savings, $25.
No, that's for your health savings as you have to fund yours, but the one where it says for the children, the health 11.
It doesn't say for children, health 11. It just says health.
Okay, what's your plan for your
$490.
children?
What's that?
What's your plan for your children? Is it the health 11 plan for your company?
Objection leading.
I pay it as a whole, but it very well could be $490.
Okay. Can you look at your paycheck stuff and tell me what your health insurance is coming out for you?
I'm sorry, I can't hear you.
Tell me what the health insurance is that's coming out of your paycheck for the children.
Asked and answered.
Overruled.
That means you can answer.
I mean, I can't tell what's for the kids and me, but it's, I mean, everything's on there. I mean, I pay it as a whole.
Okay.
$490, $350.
Do you pay vision?
Yes, I do.
$13 a month for you and the children?
Yes.
Okay. Do you pay, and that's $13 a month. Do you pay $35 a month for the children's health insurance?
Yeah.
Yes.
Do you put $25 a month into your own health insurance, a savings account so that you can go to the doctor?
Yes.
Do you have a vision plan for your and your children for $500?
I'm going to object. Every question is leading.
is correct.
Every single question is leading.
And we're trying to get through the insurance, and he doesn't know. Judge, would we like to stay here all day?
No,
We're trying to get through the
what you say
speaks for itself.
And I understand.
Absolutely. But we've asked him twice if he knows how much the children, and he said he doesn't. So you can't put words in his mouth. So my objection is leading.
And the four sustained year to date.
I know it's year to date. I don't understand that.
Ooh. Caddy.
Okay.
Oh my
Can you
God.
look at this document without me leading you.
Okay.
And can you please tell me what comes out for your children so that we can have it for the judge so she can properly calculate
It
what
doesn't
you're
say.
paying. She's supposed to pay half of it, so you're supposed to get it to us, so we need to go ahead and tell her that. So what is paid for you and what is paid for the children?
Spicy.
It's separated out on here, but I can't
It's
read you.
not,
I hear
and so
you.
I'm asking the court to admonish you not to lead him.
$490.
Sustained.
Okay, can you, that says year to date.
Oh, sorry, $35.
Okay.
Let me see, 35, 13. That's
3513 and
and 581.
Is that what it is?
Yes.
And Your Honor, I object to for the children. I believe the paycheck stub is for him and an adult child and the two other kids. So as I asked, it doesn't apportion out the two children separate from him.
Understood. Sir, are you married?
I saw that.
So the total that's coming
God.
in would be an adjustment you want for your financial disclosure form would be $53.81 a month, not $35 a month for what you get out for the children. Is that correct?
Objection,
Yes.
leading.
Can you tell me what you pay for your children? I do not want to tell you.
Your Honor,
And I don't
as
want to
an
ask an
answer-
answer because we've had a sustain. I want to make sure it's in the record.
He said he didn't know. It's been asked twice.
We're so pissed at each other.
Could you tell? Did you sign up for these programs, sir?
Yes, I did.
Okay, so we
It's
just
a
need
yes
to know.
or no, or he doesn't know.
He said yes, he did.
No, he said he doesn't know how much is for his kids and him.
I believe that is his testimony.
I don't know the breakdown, so I'll be honest with you. I don't know the breakdown of it. I just know that I pay it as a lump sum. So
Okay. But would you be asking the court to ask for a contribution for half pursuant to the statute so that mom would pay for
yes,
half?
absolutely,
Yeah.
absolutely.
Okay, and
Thank
out of
you.
pockets as well?
Yeah.
And anything that you pay like that? Okay. Can you please go back to document 1A? Now, we want to understand how this happened. Okay. Can you explain how you went from making a great year to getting demoted by this letter? Did you agree with this letter?
No, I did not agree with this
What
letter.
did you do?
I fought it, and I just didn't agree with it. I even got my district manager even called me afterwards, wanting me to agree with her, and I told her that I could not agree with her because we were doing a lot of good things, and she felt otherwise. So, and I still, and I still got the demotion, so I did fight it though.
What were the biggest problems with your store changing from that good to great?
His attorney is questioning him.
What changed?
Well, what changed was going from good quality to just only having the best quality out, and making sure the store is like in tip-top shape, clean from from the corners to because of the competition. So.
And what were your departments that did the worst in 2016 that basically helped you to get demoted? What were those departments?
Objection, relevancy.
We're trying to find out how this happened.
Well,
I can stop. When there's an objection, don't answer, okay?
Just wait for the judge.
It's not in this document.
Yes.
There's nothing about his departments. There's nothing about store competition. with
Amazon.
This is about his poor performance, and it says it's documented that he's continuing to fall below company standards. There's nothing in here about.
And that's what I'm asking about. Can you tell me what fell below company standards? Because you said it went from good to great.
Yes.
But what fell below the?
What fell below was the standards in the quality of the produce, and then the service deli we had some opportunities as well, but for the rest of the store it wasn't bad. She just thought that not getting our first impressions to company standards would hurt our store, and she said that we were out of bed. So
tell me specifically about produce. What was not up to standards?
And once again, that's the quality. The quality going from good to great quality. And what I mean by that is, we were trained not to lose product. And
what does that mean? Trained not to lose product?
Trained not to.
I'm way beyond the scope of direct judge.
To get it through the check stand. To get it through the check stand, so we don't throw money away. Well, that had changed. That was changing to where you take it off the table, throw it away, even if it's good, and put the best out there.
Right,
That was the change that we didn't get to fast enough.
So would that be the fall below company standards?
That's correct.
And what fall below company standards is counsel referring to or reading to a client?
Could you look at the letter that's in front of you?
I have the letter in front of me. What I don't have is anything about produce.
The key retailing standards. That's
okay,
in
Your
our
Honor,
back.
I move to strike that about the produce. This is not funny. Okay.
Your Honor,
okay, good. For departments.
No, I'm going to
departments that
object
work
to your
underneath
testimony.
it.
I'm going to object to any testimony by Ms. Lozano, as she's not a grocery store expert.
I'm trying to get it out of him, and she thinks it's funny.
No,
it's not funny.
You can't get it out by leading questions. There's a document.
Oh my God.
It's admitted into evidence.
So
You can ask
mad.
them about it, but you can't feed.
Whoop her ass.
And so my objection is beyond
Sorry.
the scope of
Didn't
direct.
curse.
Because I asked him the reason for his demotion, and he said because he was depressed about the divorce. Nothing about produce selection.
Was the only reason that you had a problem at store was because of the divorce?
No.
Tell me the reason the demotion happened. She's trying to say
I
because
said.
of the divorce.
I said. Also, I was also going through the divorce.
Okay.
Okay, that's what I said.
That was
to
a
her.
piece of it.
Yes.
Okay, but what was the main part of the problem
It
that was
was.
at Smith's?
It was the store conditions, and that's what got me demoted.
So it was a changeover in company policy.
Yes.
Objection assumes facts not in evidence.
Look through this document. It says store standards are not being met, which includes but are not limited to not following the effective store manager. What does that mean?
And that's part of it. When you walk your departments, you walk the quality, you walk the freshness, you walk the cleanliness, and that's part of the effective store manager walk. So that's why when the issue came up, it was the produce department that kind of.
So Thale, to catch everybody up who's joining in, the purposes of this is that the mom is the father has gone, I guess, into arrears with his support and other obligations. The father is now suing for to reduce to judgment those arrearages. The father is claiming that he was demoted from his job, and therefore he had a reduced income, and thus he can't really pay the current amount that's there. Whereas the mom's attorney is alleging that he purposefully demoted himself to get out of paying his outstanding support payments. No, his wages were being garnished, Deacon. It's just that there were additional obligations that he was required to pay that he hadn't paid. But his wages are currently being garnished.
But was the last leg. So.
Did you fire the produce manager?
No, I did not.
Why did you not fire the produce manager?
Because he had other good qualities about him, and I did not hold him accountable quick enough. So.
If you would have fired him, would it have been better for you?
Objection,
so.
leaving.
Second, key retailing standards. What is that?
Key retailing standards is everything in its place in the back rooms and proper conditioning.
Back rooms?
Condition in the back, bring it to the front, fresh, and it's a lot. It's just everything in its place.
And did that change from 2015 to 2016 with this new corporate thing?
That didn't change, but there's always changes in it.
Okay,
so.
Explain how it's been evolving.
Evolving,
okay,
yes.
How's it been evolving?
Well, it evolves in many ways. It just it starts from the back door, and when you receive the product, making sure that you properly receive it, making sure that it gets to the right place in the cooler, in the right spot for the product.
And are you graded on absolutely everything?
Yes.
Okay. Was that changed from before to now? Was that part of the changeover in the corporates? Would you say competition?
It changes all the time. So yeah, it evolves. Yeah, they change things in it. Yes.
Okay. How are the standards evolving? Because I'm not an expert, and the judge needs to know.
Okay.
And if we don't get it out, there's no testimony.
Okay.
So can you please tell me how things have been changing without me telling you? So you have to tell me what changed in there that changed the criteria that got you demoted.
Well, what changed is that they wanted the great quality. Mm-hmm. They didn't get it quick enough. But nowadays we only need to put out the fresh stuff. We still have things that are bad. And I'll give you an example. If you
I'm going to object. Move to strike is non-responsive. I don't know if we need an example.
He's trying to tell us about the industry standards. He's very, very clear in pointing out that I'm not a grocery person. I don't know the industry standards.
Your Honor,
so I need someone who's in the industry for 25 years to show us how it's been evolving.
No, Your Honor. If in fact the store had changed and there had been a proof of criteria change, I'm assuming that would be something documented in evidence. In 20 years, if he was never demoted before, we've got a reason why. You look at it, you can't add a bunch of other stuff to it. I mean, that is what it is.
He was the store manager for 20 years. He was a bagger when he started.
Well,
so, Your Honor, can I go through the document?
You can, but I'm making the observation that nothing that you're saying is in this document.
Can you go through? Shrink boards not updated and maintained. Was that something you had to do when you got your bonuses?
Leading, objection, leading. You can ask what it is. You can
that
ask
is
what
actually
it is.
a leading
you can ask
question.
How it affects the demotion, but you can't lead.
Tell me what that means.
No leading.
And how it was different.
Okay, shrink boards. Those are I put up they're boards to show your loss, what you're selling, what you're not selling, what you're marking down, the process of where it goes to get it through the checkout to profit.
Okay.
That's the shrink boards.
And in 2015 and 2016, were they exactly the same or were they different? That standard in the company.
Those were the same.
Okay.
Those were the same.
Just you look in the letter and you tell me what changed from 2015 to 2016 to earn you this demotion.
Well,
that is leading also. Yes. There's nothing in this document that says store standards changed that led to his demotion. This document is replete
No, Your Honor. I'm talking about his testimony as to what was good versus a great quality.
You were asking him about this document. What in this document about store procedures has changed? Nothing in this document says that.
I understand that.
And you're leading.
And I understand that. Okay. This is what I want. What changed between 2015 and 2016 that they refer to in this letter? We can't talk about the company standards because we don't know about it. You must talk about the company standards.
And you can't coach your client while he's on the stand.
Absolutely not. Absolutely not.
But that's what you're doing.
You're doing that. I kind of are.
Anything.
If anything, absolutely.
You're leading. You're leading.
The competition is what changed.
And he's already testified to that.
The competition is what changed.
Okay.
You know, and
competition.
they were going from because the company it's always evolving. They want to stay ahead of the game. So that's what changes all the time. So for them to go, they work with they were doing customer service, in stock, meaning staying in stock. Even to this day, you know, it changes. So it has changed. But before, with the freshness, we used to not be able to lose that product that would be okay to buy today and tomorrow. Now they don't want it on the table. So that's the thing that changed. So when people take it home, they don't lose it. So then that way,
I still think of it at $2.
What was acceptable in 2015 was not acceptable in 2016?
Correct.
Were there things that you did in 2015 that were not acceptable in 2016 besides produce?
Your Honor, I just want to object because she's referring, it's a complete lack of foundation is what it is. It's a complete lack of foundation.
We can ask again. Tell me the difference in the corporate structure that you've been working at for 25 years, right? When did you start working there?
25 years ago next month.
Okay. What was the biggest change in the corporate structure in the time that you've been there?
Amazon and the home deliveries and, you know.
And what was the year that happened? The calendar year?
2015, 2016.
We got it. It doesn't matter.
Okay. No, Your Honor, I'm trying to find out when we've already got the foundation in from an expert in the area as far as what he's doing.
No, it's
why
plain-
is that not something that's changed? This is an industry standard from a store manager as to what changed. And you're saying
Again,
it's
this
not
is testimony. Again, this is her trying to testify and argue while her client's on the stand. Your Honor, I'm telling you,
You're leading, you're coaching,
it is
your witness.
It is. She's going to say he got demoted because of Amazon. Or he got demoted because of company changes. The question then is, where's the form that comes out every year? Where's the one for last year? Where's proof that the form changed from one year to another year? Where's proof of these standard changes documented? Nothing's documented. It's just words, and they lack foundation. So I thought this was something that could be done very quickly. I mean, all store managers across the board weren't demoted because of Amazon. So I don't understand the relevancy. What we should be talking about is what was the reason for the demotion. If that's all they've got, Judge, then I'm going to say it's repetitive and cumulative at this point. So I can get my client on and we can be finished.
What's your question, Ms. Lozano?
Thank you. I need to make sure this court feels like we were in this thing happening, okay? And if they don't know everything in your head, then we won't be able to go forward and make a proper ruling.
Okay, but you can't.
You can't even say that. So I'm going to move to strike the comments by counsel.
You're coaching the witness.
Kimberly, please look at your document and look what's underlined.
What
is underlined?
Where? What page? They're date stamped.
Page 1.
Exhibit A, page 1, Mr. Jimenez.
Yes, I saw it.
Okay.
Yes, this is something. Can you tell me why it's initial? Why is it initial?
Because they're telling me that I need to make sure that I do my job, and if I'm not, I can be terminated. And you know.
As a result of this, have you been moved stores?
3 times.
Okay. Can you tell me what stores you were at the time of the divorce and where you're at subsequently and then now?
I was at Buffalo and Flamingo at the time of the divorce, then Green Valley Parkway and Pebble.
Okay, can you tell me why you moved?
Yes, I moved because we were not on good terms, because I was frustrated with this demotion. I didn't agree with it, and they felt otherwise, so there was a bit of a tension, and so they moved me to Nellis and Stewart.
Was it the same pay?
Same pay as now, yes.
Okay. Have you, since the time of the divorce, 2000, it should have been actually May, and then you had the order entered to be October. Are you still making the same money, or are you making more?
No, I wish I was making the same money, but no.
No, I'm sorry. I'm talking about when you got divorced, 2016. Okay, you said that's when the demotion happened, correct?
Right.
Okay.
2015 they were divorced.
Okay. It's 2016.
No, we were divorced in 2015. No.
It's 2016. Okay.
So what's the question? I'm sorry.
Okay. divorce, and how much was you making? At the time the divorce decree was entered, were you assistant manager? Or were you store manager? Which were you? Or was it in the interim time? I'm sorry. I know that there was a time for, preparation.
Entered. I think I was an assistant.
Do you know when it happened, the demotion from store manager to assistant manager?
In April 2016.
So when you moved to Nellis, what happened?
So I moved to Nellis, and they were making moves, and then I moved to Pecos and Bonanza.
Why did they move you from Nellis to Pecos and Bonanza?
They were making changes with because they had new graduates that came through that graduated, new assistants. So they had to place them so they can get 3 in each store, and this store only got 2. So I ended up over here.
Did you have control over where you were moved the first time?
No, I did not.
Did you have control over where you moved the second time?
No, I did not.
Do you have control if they tell you right now you have to move to another store? Do you have control now?
No, I do not.
The other store managers around you, do they have college degrees or not?
I believe some, not all of them.
What about store managers now?
Not all of them. I thought you meant store directors. Assistants, I know they're looking for people that have been going to college and or have a degree or credits.
I mean, you can lay the foundation. It's just that his attorneys
they favor that. So
was that what it was before, or is that
no, not so much. Now it's like out in the open that's what they're looking for.
Do they actually put that in the recruitment documents or in their actual anything that they have that they want college graduates versus not college graduates?
I'm not sure. I'd have to look.
You've never seen that in writing from Smith, have you?
No.
Can you please tell me on page, on your letter, there's 2 paragraphs at the end of the page. Can you read that last letter where it says you allow your associates?
You allow your associates to operate in the same way and do not hold them accountable for their responsibilities either.
Wow.
When they talk about doing things the same way, why would they talk about doing things the same way?
Objection calls for speculation. How would she know why they were asking?
I can ask them if you
Oh, sorry.
this letter. That's not, okay. Was that when they're talking about how the old way versus the new corporate way?
And again, I'm objecting to they even speaking. That's hearsay, but it calls for speculation. I've never seen anything that they said that.
What portion of the exhibit are you referring to, Ms. Lozano?
The second paragraph from the bottom, Your Honor.
On page 1?
Yeah.
It starts out, these are just some of the issues that have already been addressed with you.
Correct.
Okay.
At the very last, it says you allow your associates to operate in the same way and do not hold them accountable for your responsibilities either. Okay. Is that what you were talking about with the produce manager?
Yes.
And also you said the deli manager?
Objection leading.
I'm refreshing the earlier testimony. I'm not leading on anything. I'm not talking
I never heard him say anything about any deli person.
The record will show differently.
It does. Overruled.
Yes.
It's just holding them accountable. That's not holding them accountable is what didn't help.
Okay, so does this show that their departments were deficient and you did not hold them accountable?
No, it doesn't show that they were. It just shows as overall because I'm in charge of the entire store.
Does it also show that there was a change in policy and you weren't holding them accountable to it?
No, it doesn't show
What
that.
does this mean? Did you talk to her about this? You allow your associates to operate in the same way. What does that mean? What does that sentence mean?
That it wasn't. How would I say it? That I wasn't consistent. That's what that means. That it wasn't consistent. So the company standards weren't there every single day. The inconsistency is what it was.
So they're telling you new stuff, you're not sticking to it.
And the stocks, yeah, I have that.
And this was a letter that was showing that if you didn't do things.
Objection leading.
Sustained. What did this letter tell you?
Oh, asked and answered. Asked and answered 100 times. That's my objection, Judge. Asked and answered. The letter speaks for itself.
Sustained.
Can you go to page 2? Tell me what page 2 says.
Lupe, you have been warned multiple times concerning your performance. Despite these repeated attempts to help you improve your performance in a marked and consistent way, your performance continues to be deficient and unsustained.
And the areas you should discuss on that with was the snack deli and the produce. Was there any other areas?
Grocery at times, but more often produce.
I know you said your customer service was incredible.
Oh, yes.
Okay. Was anything else incredible?
Overtime, labor. I had there was a lot of good things. Just the conditions of the store weren't to company standards. And that's what got me demoted. And then not only that, we only have one assistant to the 2 and 3 that we have currently because it's a lot of work. Yeah. So
you had less people.
Less people. Yeah.
More competition. How close were the other stores again? You said that you had
Objection, relevancy.
Sustained.
Okay.
Oh, we had about 4.
Don't answer.
You did tell me that.
Yeah.
Sorry.
That's okay.
Let me get the rules stuff. Did you sign this?
Yes, I did.
So what's a PIP program?
Personal improvement plan.
Did you do that?
Yes, and that was a 30-day, and then after 30 days, that's what I got demoted then. So.
Okay, so tell me what the PIP was that got you to the demotion.
Well, the PIP was once again she came in, walked my store, and went through the produce, and the produce was it had quality issues. It did, and so.
Hang on, were the quality issues acceptable in 2015, but not in 16?
Objection calls for speculation. How's he going to know?
Yeah, it is true.
So I'm asking the question.
I just don't know that it's relevant.
Neither.
Ms. Lozano.
I just don't know, was there a change? Was it,
There
was it the same manager?
was-
Was it the same manager? Was
No.
Sherry the same district manager?
Yes, yes, she was the same manager.
Okay.
So.
There's just no evidence of what you're pulling out through testimony. The produce in 2015, 2016, I can read this letter, what it says. I don't understand your line of questioning. I'm confused.
You already said that you fought this demotion. Okay, and are you trying to get a job somewhere similar to where you could be a manager again sometime soon for Smith's?
Yes, well, I'm trying to do that through my work. You know.
Can you go to this 15-week program that they're talking about?
I haven't looked into that, so.
Do they want you to go to that first because you've already?
Leading. Objection leading.
Sustained.
Not sure.
Sustained means that you don't answer.
Do you have to do
Stop
anything to
answering.
move up in the company? Do you?
Well, yes, I have to make sure that I'm performing excellent, every day. I don't miss a day from work, even if I'm sick. I go to work, so, and I just have to show it through my work.
What will it take for you to get a higher paying job within the same company if you stay in that company?
Actually, a lot, because the job that I have now, it takes a lot to get everything done. And what I mean by that is reports and walks and security walks and whatnot. It's just a lot. But as long as I comply with that, I should be able to get up there.
And will we be able to get up to that same level in 2015?
Well, the only thing it'll be difficult because of the competition. We have a lot more people now, a lot more assistants with degrees, schooling. So I couldn't tell you. I just know that my experience would talk for itself. Other than that, then I don't know.
Did you want this demotion?
Absolutely not. I wish I would still be making the same money, but.
Would you do anything to make less money to pay less child support?
No.
Would you do anything to make less money to pay less spousal support?
No.
You gave us. Can you look at page 3? Page Exhibit C. Can you tell me what it is? In 2016, did you have any other income besides?
Are you
Smith's?
withdrawing the question?
Can you look at this?
Well, you have to refer. It's not in evidence yet.
I understand.
So.
Can you just look at this?
I think you want him to recognize the document. Do you recognize that document?
2016.
In 2016, I just want to make sure because there was a statement that you made earlier that I want to make sure the record's clear.
Okay.
Okay. In 2016, did you have any other job?
I don't think so.
Okay. So, and you said 2018
I don't think
was
so.
the first time you talked about Lyft, correct?
Yes.
Okay. So I'm just talking about 2016 on this one. Did you make $84,619?
Yes.
Okay. Did you have any
I'm
other
gonna-
source of income? Because I don't
I'm going
see
to, listen, I have to object to the leading question because he never gave an amount. This is not admitted into evidence, nor was it prepared by him, so it lacks foundation, nor is it complete, so I can object to the best evidence rule. So if you want to ask him what your understanding of what you made, and that refreshes his recollection, it's fine, but I have an issue with you saying, did you make $84,000?
That's not where I was going.
Is that what your
Any other
accountant
income, because you brought
reported?
up the lift income. I wanted to make sure it was clear. That's
Right.
all.
You're leading the witness. He can't testify from a document that's not in evidence, and you were not using it to refresh his recollection, so the objection is sustained.
Do you know what you made in 2016?
84,000.
You can't testify from the document. So
Oh,
it's not in
323. 84,000.
Okay.
The testimony is stricken.
Thank you.
So we don't look at this then?
It's not in evidence yet.
Oh,
So
okay.
you can't look at it and testify from it.
Yep, you
Do you
can't.
know if you filed income taxes in 2016?
Yes.
Okay. Can you look at this document to see if this is an incomplete copy of your tax return?
I'd ask additional voir dire. Just if I could quickly voir dire him on this,
I
Your
just wanna
Honor.
make sure.
Voir dire.
And I would, if I could ask,
Voir
Lube, did you
dire.
prepare your own taxes in 2016?
No.
Did you provide your W-2 to your accountant in order to prepare it? Don't look at your
Am I
attorney.
supposed to answer? I mean, I don't know. I
She
just
can
want to
ask
make
you
sure.
these questions. Yes, she can ask you these questions.
If you did look at
That's
me
okay, yeah.
and not look
You
at
can.
them, you did not prepare your tax return for 2016, correct?
No.
You did not prepare it for 2017, correct?
Correct.
And you gave your accountant your W-2s. You have to, right, to prepare it? Okay. Is there any reason why you wouldn't give them your W-2? They'd have to have your W-2, right?
Yes.
Okay. I have no other questions.
Do you have an objection to the
Yes, I do, Your Honor. It
Well,
doesn't
she hasn't
include-
asked to admit it.
Yeah.
but-
Yes, Your Honor. I would ask to admit it for the limited purpose of the one thing, which
Your
is, again, because I wanted to make sure that there wasn't another income that was in that year, okay? Because he did talk about the lift income this year, okay? So I want to make sure that it was very clear for calculation purposes what he made in 2016.
And I'm going to object to the form of the word, what he made. A lot of times
What do
people
you-
report differently without his W-2s, which is really what we need, so you can see how much is contributed to a 401k, health savings plan, and the sorts. I would say it's incomplete, and it
And
doesn't
I
have
would
the
say it
schedules.
accurately reflects the wages and the salaries that are normally kept by the IRS. Ordinary business expense. I mean,
His testimony is good enough. I object to the document being admitted as incomplete.
and Your Honor, if I can as well, I can tell him that he had one. She went ahead and did this. Did you give him one document to prepare this? Your income
Yes.
regarding your income. So would he have made up the document, the wage on on line 7 for wage and salaries?
No.
Okay, so it would have been information you gave to him.
Yes.
Okay, is it the same person that's been doing your taxes for how long?
4 years, 3 years, 4 years.
Again, Your Honor, I would ask that he be able to testify just to his income.
The question would be, then why is it not included in all the schedules? The question would then be, why is your 1099s, which is another source of income, and your W-2s not included? And if he doesn't
Did
know.
you have any 1099s? So did you have one document which would be your W-2?
W-2s, that's it.
And that's all you had?
That's it.
And do you have any reason why? Do you know any
I'm
reason
building the Normandy.
I do not know.
then my objection is just for the admissibility of the document itself, but his testimony can be whatever it
Again,
is.
I'd like him to testify as to his wages and income on that. That's what the purpose of this for, Your Honor. And he's already testified. He didn't give any other wages or anything else to them.
Okay, it's admitted.
Thank you. In 2016, how much did you make?
84,577.
Thank you. Same thing as to 2017. How much did you make?
Hold on. Is he referring to a document, or are you just asking him for his recollection? You can't testify from a document
Correct.
that's not in evidence.
I don't even think you
Okay.
said. I
I'm
don't
sorry,
think-
Your Honor. I thought you said admitted as to that limited purpose onto the two, as far as income.
We went on to the next year.
Okay. So I was just trying to do them both. That was it.
Well, we haven't talked about D.
Okay. So we have
What should I have for lunch? Oh my God,
Yes.
lunch. I said. I already had lunch.
I'm using it
What should I have for
the
dinner?
actual income that he had.
And no what should I have for dinner and no tacos? I had that yesterday. What do you guys think? Actually, you know what? I'm gonna put a poll in. Somebody put a poll in chat. Wait, I could do a poll in chat. Hang on. Hey, Dracando's thinking of the 6 months. Chaos, I swear to God. I normally put people in timeout for retorts like that, but you're okay, so I'm not gonna do that to you. Dinner. And let's go with those choices. Yeah, that's fine.
I think you need to lay the foundation, as you did for 2016.
You got it. Can you see D?
You can't look at it. You have to. No, I'm going to object to looking at it.
Can you tell me in 2018, did you have your 2017 documents a W-2 given to an accountant for?
Yes.
Yes.
W do.
Same person
Ha,
you
she
used for-
misspoke.
Okay. What document did you give?
Argument
for the,
lost.
W-2s. That's it.
Well, then he can't definitely look at it because it's not included.
It's the same thing we did before. Did you give him one document regarding your income?
Yes.
Was there any other document regarding
No.
income? So this one on line 7
No.
would be your only income that you gave to your accountant. Is that
Ask
correct?
him how much he made.
Yes.
Okay. Now I ask it to be admitted.
It's the same objection. If you want to ask him how much he made,
I
and he
want it to be
doesn't,
admitted, Your Honor.
if you want to ask him how much he made and he doesn't know and you want to use it to refresh his recollection, that's fine. But the way you're doing it is not proper. You want to throw a number that's not accurate. So
I take note of your objection that the document is incomplete, and that goes as to the weight of the evidence, but he's identified this as his tax return, so it's admitted, but as to the weight, I understand your objection that the backup documentation is not provided.
Thank you. In 2017, can you tell me what your income was?
Now you can look at it, sir.
You can look at it now.
Admitted.
It's always that landing gear. Oh well.
84,
I think
322.
you're on page
Oh, hold on.
D. It
Oh.
was, if you look at the bottom, look at GM 19. See those state stands for lawyers? 19.
62, 582.
Okay. Can you tell me what the difference between the two? Why you had 84, 619, and 62, 582? The difference between the two. Why?
Because I make less now. I went through a demotion and I make less money now. I'm an assistant and that's the wages I make, 62.5. And bonus potential was 7,000 and I only received about 3,800.
And can you tell me what the bonus potential was when you were a store manager versus a store assistant manager?
Bonus potential was 20,000
For?
for a store manager.
Okay.
The year that I made 35 was because they had an inflator, which at the end of the year, which that means that the company was doing well, so they added like a customer service piece. So
What's an inflator?
an inflator is like say, they give you another goal on top of the goals you have, and if you hit that goal, your mark, then it goes over 100%. But that was just that 1 year.
Do you have inflators the years
And
before?
Chinese is winning out
They have them before,
hardcore.
but they don't always have them.
Did you ever get an inflator that got you this kind of bonus?
No, that was the first one.
I'm gonna give the
That's
the
why
poll
I
another
made
5 minutes.
35,000, because it inflated from 100% to 176%, because that's how good we did that year.
I'll be right back.
And can you look at E, please? Your Honor, for the records, I'm hearing C and D are admitted, but with the objections noted. Okay. Can you tell me what that was? E?
Yes, that is cashier's, the bonus that the other half of the bonus that I got to you to give to Valerie, to give to Angela for the other part of the bonus that she didn't receive, that was sent to me, was given to me, but I borrowed it from my family and gave it to her immediately. I wasn't sure what had happened to the other part, which it seems like it got lost somewhere.
Did you then go to Smith's and find out what happened to the? Was an order ever given to Smith's?
Right away, I went and I made phone calls, and as far as I know, that they said that it was sent out, and then so I don't know from there what happened, because I believe you took over and you called after I gave you this check, because I told you that I called 3 times, and when I went to call, they said that they already had given her part, so that's why I thought that part was mine.
And did they explain to you that they never got an order from the Susie's office?
No, they did not.
Well, then how did I get all the? There's like 5 orders in here.
I couldn't find one. That's why they were all shocked.
I don't understand your answer.
Okay.
The question was, did they explain to you? And you said no, they did not. So
What do you
is
mean?
it that they didn't explain to you, or they didn't get the order? I don't understand your
No,
answer.
they said
the way
that,
the question was
no,
worded.
they said they sent her part when I called on it, because when I got when I got the check, I asked about it, and they said that she got her part. So I thought that was my money. So I spent it. So when I came to court, I thought, that it was my money. So then I was supposed to give it to her, and I already had spent it. So my family put money together, and I took it straight to Don's office right after we left.
I understood all that testimony, but the last
Whoops.
question was, did they explain to you?
No, they didn't explain. They just said that she received the money.
So they didn't explain anything to you?
No.
Okay.
So when you heard the words, and I'll quote back to you, she got her part. Did you think you were following the court's orders?
Yes.
I can't use the gear because I need.
I do now.
It's in the order.
Yes, I know. I know. There's a lot, and yes.
All right.
Is there a lot of this legal stuff that's been a little puzzling for you?
Yes.
Okay, what's been confusing for you?
Objection, relevancy, beyond the scope.
I would say,
We're not going to sit here
yeah, I
and
would
talk about
say.
what's been confusing with him. He's been represented by counsel all along, except
He
for
has
the
not
trial.
been represented.
Okay.
By counsel all along, and that's been the problem.
Bitch.
But I do believe it's way
Sorry.
beyond.
At the time of
keep-
trial,
I
he
keep
was
cursing.
represented
I
by
need to
counsel,
stop.
And I asked him a specific question: did he understand that she was to receive
Becky.
100% of the bonus? And he said he did not.
And just so you know, they did a poor job, because I was giving documents out to them to have here, and they weren't even turning them in. So
Are you talking about counsel?
prior counsel. So that's in my defense. I don't know. I mean, but there is a lot that I'm unknown with, so I do apologize.
Did you
for
understand that you should have gotten an order to your payroll department?
Objection, leading.
that. I should have.
Yeah.
Sustained.
I'm actually kind of hungry.
When you said you're confused about the law part, did you represent yourself at trial?
Yes.
Did you understand there was a lot of stuff that you were supposed to do that you did not do?
Oh, yes.
I'm probably gonna
I'm
get
not
my
sure how
usual.
Are we going? Because I've gone off mainly most of the testimony that she's talked about. Should we stop and then have my first case go forward with him afterwards, or should I continue this way? I'm not, because we asked that we took him as a hostile witness because we took him out of order. So, do you want me to can I continue with him after she's put on her case? 'Cause she's
I would love to
rehearsed?
finish it, but I don't know. We have a half a day. I don't know how much more we have. My questions are very limited.
Because I'd like her to be able to put on her witness and then go ahead and.
I don't even know if I need my witness. I just need to follow up my question, but if there's additional testimony, I don't know what it's about.
Do you want her to go outside the scope?
Yes, if she needs to.
I was just wondering because of when we were at, Your Honor.
I just want some offer of proof, Judge, because I don't want to spend, and I knew it would be very long, for their side. I wrote out my questions for my client. It'll be a quick 10-minute jobber, but we should be entitled to the equal opportunity. I just don't want a fishing expedition.
And that's why I
to go
said
long.
she can do it right now.
No,
That's
I
a good
don't want
idea.
him called again. Would like her to finish.
All right. She has completed her direct. She has agreed that you can go outside the scope.
I would like to only call my client after her client at this point, Your Honor. Absolutely.
Well, you don't get a rebuttal witness. This is it.
Yeah, I can rebut what he has to say. Absolutely, I do.
Well, yeah.
Absolutely, I do.
So are you finished? Are you finished with your cross-examination?
Well, I mean, I'm trying to figure out how we're doing it because it is a cross, really, of a witness that she took as a hostile witness.
Right. And she's agreed you can go outside the scope,
Yes.
but you don't have to.
Okay.
So if you are finished with your cross-examination, he can step down.
And I'll ask my
Let's do that.
follow-up
Yeah, and then
questions.
we'll just do yours on direct, so I don't have to ask the questions
All right, no,
backwards. where
you
we're doing.
still need to stay, Lupe. I'm just going to follow up. Lupe, do you have any evidence or any documents other than what your attorney has introduced into evidence showing that somehow Smith had changed some of their, the way they do their assessments of people?
I can look into that. I don't know of it.
Would it surprise you there's been no documents listed that show that?
No, there's got to be something.
Well, you're going to offer to it today. I'm saying you have no
I don't
evidence.
have anything to offer today
Okay.
as far as that
All
is.
right. And is it true in over 20 years, or 22 years, you have never been demoted before, correct?
That's correct.
This criteria change, you have no documentation to support that, correct?
I do have documentation.
To provide today?
Well, you guys have the demotion letter.
The demotion letter does not say that their criteria
They
changed.
put me on a 30-day. I turned that in. They gave me a demotion letter, and it says that I was demoted. What
So
else would you like?
Do you believe that is proof that the criteria for Kroger and Smith had changed?
No, it's proof that I got demoted.
Yes. Do you have no evidence or proof
I
that
like
the form
spicy, yeah.
that they used for the demotion has changed, correct?
The form, no.
Okay. And you say you get these every year. Is there any reason why you only gave us 2016 and didn't give us 2017 or 2018?
Gave you 2016 what?
The demotion letter. You said you get reviewed every year, correct?
It's evaluation.
Is there any reason you didn't provide your annual evaluation after this demotion in April 2016?
You didn't ask for one.
Well,
No one asked for anything, so
Okay.
no, there's no reason.
That letter says, Exhibit B, that it was a temporary, and that you had 30 days. Is that correct? What happened after the 30 days? You were demoted?
After 30 days, I didn't get demoted right after 30 days. It was a 30-day improvement plan, and then in April I got demoted.
And is there any reason why the improvement plan was not included in these documentation?
Well, isn't that the letter that says on there the key retail lien, the shrink boards, not following effective store walk?
So this is the improvement letter?
Yes.
Okay. There's no documentation, is there, that Smith's or Kroger managers require
got my
degrees,
order.
is there?
I don't know that
General
there
Tso's
is,
chicken
but I
with,
know that
pork
that's
fried rice.
what they're looking for.
Okay. You have no documentation today that evidence they require store managers to hold degrees. Okay. Now, this store you said that was doing so poorly, this is the same store you received, that you got demoted at, was the same store you received a $36,000 bonus, correct?
That's correct.
Objection.
35,000.
Isn't it true you still have stock options, correct?
No, I do not.
Did you provide any proof that you no longer have stock options?
Did you ask for any?
That is not a question. You don't get to ask me questions. Unfortunately, you ask you.
I don't have any.
Ooh, that's a spicy retort from the father. Do you have any proof of that you no longer have stock options? Did I have to show any? Jesus, damn. Spicy.
So I don't have to show that I have anything.
So what did you do with your stock options you've always had?
Well, I didn't get it. When you get evaluated, they give you stock options by whether you do your performance. And now they also changed it where the assistants don't get stock options.
So as you sit here today, you're saying you hold no stock with a Merrill Lynch account?
Correct.
You still have 401k?
Yes.
I believe last quarter your 401k was in excess of $40,000?
Yes.
Why can't you use those funds to make your support obligations?
Because I have a loan out and I can't borrow from that.
Where's the loan?
Well, the loan was before we were together when we got the loan.
Where's the loan from?
From 401k. Yeah, I was only allowed to borrow. I only borrowed like $2,200, and I'm paying. And we've been paying it real slow, like $25 a month. It's on there. It's on the.
007.
Oh no, it's okay. I've subpoenaed the whole file from Kroger. I have the whole thing. So it's your testimony today you no longer receive stock options?
No.
Do you still have stock with them? No. What did you do with the stock?
Well, remember I used the stock to live off of back in 2016.
You cashed out any and all stock that you had? Is that your testimony?
Yes, you know that.
And you have no other stock holdings?
No, I do not.
Okay. The divorce in this matter was filed in 2014.
16.
The divorce in this matter, the complaint was filed in 2014. You did not get demoted by your own testimony until April 2016. This letter was drafted in February 2016. Other than what you've explained, when we read in the letter, it says, Goal 1, effective store walks are completed daily. You weren't doing those. You have...
Are you telling me? Or are you asking?
That's what it says, so the document speaks for itself.
Okay.
And you're telling me the reason the effective store walks weren't completed daily was because of Amazon and because you were depressed.
Objection. Objection. Misstates the testimony.
Were there any physical limitations on
Your Honor, objection.
I don't recall his testimony about the effective store walks being linked to anything.
Okay. All right. Then I'll withdraw the
But it's
question.
cross-examination. Technically it's direct, but he's a hostile witness, so...
I'll withdraw the question, Your Honor. If it's not tied, it's not tied. After 30 days on this demotion letter, did you get a subsequent letter evidencing your demotion?
No, I got demoted in April.
Can I ask a question?
Yes.
Is there a reason why you didn't improve your performance after being warned that it could result in possible separation from employment?
What do you mean, like when we were coming to court?
No, this letter is dated February 22, 2016, and you're being warned.
Uh-huh.
And it says in here that you've been warned before.
Uh-huh.
Okay, you have a track record of being warned.
Uh-huh.
And you were demoted 2 months later.
Right.
Is there a reason that you didn't meet expectations, so they went ahead and demoted you?
No, we actually...
After you'd been warned.
We worked hard to get the store to where it needed to be. And still, she came in, and because when I had a conversation with my boss, she said that I wasn't going to make it. She told me before I even start.
The expectations of you were that you do the store walks. Did you improve that?
Yes.
And did you improve the product being outdated?
Yes.
Did you improve the shrink boards being updated?
Yes.
And so you did all of the things that they asked you to do in this performance goal plan, this performance improvement plan?
The produce still had quality issues, is what put the into that, because we did better and it looked better and the store was cleaner and all that, but the produce still had quality issues, and that means they pulled out product. They went through all the product and see if there was bad quality in it, and of course they found some. You're going to find that in any produce. So yes, there was quality issues in there. So that's what I didn't.
Is there a follow-up letter to this performance improvement plan that you failed to meet this plan?
There should be another letter in there that says that you were demoted.
I saw that.
Well,
But my question is, did you get another letter saying you have failed to meet these 4 goals that we have given you?
Well, no, there's a letter that says that you are demoted. This one is saying.
Understand that.
Did you see that? Just 2 letters, right?
Was there a letter after this February 22nd performance improvement plan
There is.
that told you you did not meet these goals?
There is. They should be on file somewhere in there. There is.
Okay.
It's
so
in April.
05?
Oh, there it is. There's the letter right there, right after.
05 in Exhibit A?
Yeah.
Those are the only things we found, Your Honor.
Yeah, it's the one that's, that's the one.
And it
It
says
says 4/22/16.
Okay, so you were placed on the performance improvement plan to address your work performance issues. And they said you had not met the objectives. And some of the areas were store standards not being met daily, not following the effective store manager walk or following up on tasks assigned to you, and store not to key retailing standards including backroom conditions, out of codes, and cleanliness. So those are the
Yeah,
reasons.
and they did. They did have out of codes in the grocery department. So those 2 things.
Thank you. You said you had no stock after 2016. If I were to indicate to you, you cashed out stock as of July 30th, 2016 for $7,378.71, and we're still receiving stock dividends at that time. Would that be a lie?
How much was it?
$7,378.71.
And that we talked about. That's the 10,000, and then they take the taxes out. It's 2017. It wasn't 2016.
And that was July 2016.
Yeah, that's the one.
So let me get this straight. So after this demotion, you still had stock, but you cashed it out.
Used it to live off of.
And when you had that money, you still hadn't paid any of the outstanding orders at that time, correct?
Any?
Correct.
July.
I'll withdraw the question. In 2012, you were making $71,365. That's 2012. You had only gone up every year ever since. Now, all of a sudden, none of this paperwork...
Objection, Your Honor. That's Ms. Stacy's testimony earlier.
I can show it to him, but if I can get my
Ms.
question...
Stacy's testimony where he said that he made $53,000.
Disney ad. Uh-oh.
That's Ms. Stacy's earlier testimony.
Your Honor, if I may approach, refresh the witnesses used for impeachment. I'm going to show you a document from Kroger that I received via subpoena duces tecum, 3 of which I submitted on Kroger.
Your Honor, this is not a W-2, so
You're
this
gonna
is just a
check.
pay range, and I have his actual from his Social Security. So that's a pay range document. That is not a W-2.
I'm showing you a document from Kroger Company on their letterhead that says the pay range, minimum 70, maximum 91,500, but then it lists at the bottom your current base pay of $71,365.08. Do you disagree that at the time in 2012, your base pay, absent bonuses, was $71,365.08?
Objection. Ms. states her own recollection of the testimony from trial, as well as the trial exhibits that we already have on record, as well as the Social Security statement that we have.
Trying to lay a
And
foundation.
his earlier testimony.
I'm trying to lay a foundation. I just wish you'd make an objection.
Objection. Doesn't represent his income.
You don't dispute that Kroger gave this document and list your base pay. Do you recall what your base pay was?
Objection does not say his base pay is that. It is not a W-2.
You looked at this, right?
Yes, it is not a W-2, Your Honor.
I understand that. I understand it's not a W-2. She's stating it was a Kroger document stating what his base pay was.
For 2012. And it's a foundational question, if I could get it out.
Corrected. It shows a range of pays, not hers.
Please
Again, just like you had a problem with not having the document attached to it.
So catty. I love it.
I have a problem with the actual document.
Well, she'd probably have a big problem if I introduced all of Kroger, which I have forced.
Which should have been done before trial. We've had none of this done.
Judge.
She's using this for impeachment
And any
purposes.
exhibits, again, should have been done.
You got it too. You're on my subpoena.
Right here.
And there's a reason it's not in.
Proceed, Ms. Fuji.
And Your Honor, we've got none of these documents that she subpoenaed, which she's required to give me a copy. We opened discovery. I got none of them. Zero.
I can get my question out, Judge. I'll withdraw the question. If your base salary, according to Kroger Company, if I can finish the question, in 2012 was $71,365 without bonus, and it continued to increase every single year, how come these documents in Exhibit A don't show what your salary was demoted to?
Objection. To any of the documents that she did not produce to us. We had discovery open.
She's not using it.
I'm not using it. She's got it.
Objection misstates his
I would like him to
testimony as
answer
what his income was.
It's a pretty easy question.
Overruled.
This is so wild.
Don't look at your attorney to answer your question.
Well, I need to know what I can answer.
Can answer.
Yes, you can answer.
Everybody.
Well, it shows on the Exhibit A on the last page where I'm getting paid $62.5.
And did you choose that amount yourself?
Absolutely not.
Is
Wouldn't
is there any reason why you didn't present evidence that showed that was a salary that they chose for you, not one you chose for yourself? And what document are you pointing to that shows your salary in
Exhibit
Exhibit A?
Go to page 4. It says salary would be
$2,500. This is not proof that you were demoted. It was an offer you accepted.
No. I was demoted. I did not. This is not an offer. This is either you're going to do this or you're going to not have a job.
Well, it says you were eligible for a pay review on GJ0004.
Uh-oh.
A pay review.
Uh-oh.
Did you get that pay review?
No.
Is there any reason we don't have a copy of that pay review or subsequent pay reviews?
No.
I have another question, John.
Ms. Fuji was worried. You said the sentence, this is an income you chose for yourself. Are you able to set a salary for yourself at the Smith Corporation?
Not at all.
Did some of the problems with your new standards have to do with you being in a remodeled old Rayleigh's?
Objection calls for leading.
Sustained.
And calls for speculation.
Okay, within 3 miles of where your store is, when you were being demoted.
This is going to be leading.
Yes, it's sustained, and we've already had this.
I understand.
These questions have already been
I understand.
proffered, and He's
Were
already
you given the
testified.
stock options in the divorce?
Was I given?
I just
No.
read the decree. Were you given the stock options in the divorce?
I don't know. I don't know.
Okay, if I can read to you what the judge said that you were given the stock options, would you believe what the judge said that you were given the stock options in the divorce?
No.
Hang on a second.
I'm object to relevancy.
I'm wondering why we're going about stock options when it was already talked about. It's already been done. Let's muddy up the waters more. Again, in page 13, line
angry.
8 and 9, it says stock received and liquidated by the husband. 14, 15, and 16, right in the decree. Why are we talking about stock options? Other than he got money. It's already been litigated.
Is
Your
that
Honor.
a question
Anything
or an
regarding
objection?
stock options, I ask to be stricken.
I have no idea.
Your Honor, I ask that that be stricken.
I don't
This
know
is
if
not
I-
additional funds that we're looking at.
I don't know if I need to
I think her point
respond.
that you
They need to
she was
start
trying
fighting.
make was that did he have additional
Correct.
funds available
Sources.
to him, and he said that he did not.
Did you understand that stock options were dealt with in the decree? That order I just read to you from the
That he
judge.
did not.
No.
Okay. When you got the stock options, was that part of the stuff that you thought you were taking away from her or you were living on?
I was living on.
Okay.
It's part of the conversation. He was taking the money.
Because the thing is, I was paying her as much as I can, and after the 4th month, when I was paying the alimony, I ran out of money. I had no more money.
So how many months did you pay the child support and alimony?
I'm going to
Alimony
object.
4 months and child support.
Hold on. When there's an objection, stop talking.
Okay.
It just has to relevance at the time. All this was already discussed, and we have schedule of arrears. I don't know what the relevancy is. He
Other
said he
than the
couldn't
fact that
pay.
she says he's paid nothing. Nothing is not nothing if it's paid. And I cannot have you ever thinking, Judge, that he paid nothing. He paid as much as he could until he couldn't pay any
Your Honor,
more.
And I know that neither one of you have asked him about these schedules of arrearages, but I would like that to happen before we conclude.
Yes, Your Honor.
I think you have a duty, Ms. Lozano, because they're under oath
Correct.
filed by the plaintiff.
Correct.
So there is a presumption that they're correct because she filed them under oath, so you need to address those things with him. There are 3 different schedules: the equalization, alimony, and gymnastics. I don't think there is another one for child support. I think it's just those 3. We're going to take a 5-minute break.
Okay.
Oh, thank God. Is that it? Oh my God. Wait, I thought this had all parts. Uh-oh, hold on. All right, take care, Deegan. Judge Rena Hughes 1-3. A 1 of 3. Okay, so that's part 1 of 3. Where's 2? All right, I see 2 of 3. Where's? No, excuse me. I see 3 of 3. Where's 2 of 3? Uh-oh.
We're back on the record in Jimenez. You have further questions, counsel?
You helped us prepare this, right? This pretrial that we had, the pretrial memorandum that we did when we filed this with the court, so that before we went to court, right? You helped us do this, where we went back and forth, and you made sure that we got all the information in there. Do you remember regarding all the issues that we had in court today?
Yes.
Okay. The judge asked us regarding the schedule of arrearages. Okay, I don't have a copy of the schedule of arrearages, Your Honor. I didn't get a copy of those either.
Well, we could have printed them out during the break if I'd known that.
No, I don't have those.
I'll do that for you.
Okay. However, but in this, was it pretty clear that we didn't say anything that the judge has already done?
Objection, calls for speculation
It'll
leading.
take care of 2 seconds. Your
I
Honor.
can't hear both of you at the same time.
But I
So
think-
finish
Oh my
your
God.
question,
Yes.
state your objection,
Correct.
and do not speak, please, until I rule.
Please. I think she'll be
Thank
fine with this. Were we fine in our pretrial memo with all the things the judge had already reduced to judgment? You understand what that means?
Yes.
Do we agree with the judge's number up
Yes.
until we file, which would be September 29th, 2017?
Yes,
Okay.
we do.
Bless you, bless you.
All right.
Yeah, he'll get
agree
up and stand eventually.
Until you submit it for reduction October 1st, 2017.
Okay. And did I tell you why it was important for us to go forward and that forward?
Tell you why.
Stop.
I have to object.
Can we at least put the judgment in the record so
Let's
we
do
have
that.
an
Let's do that.
entire record?
Let's do that. That'd be wonderful.
That'd be poggers.
I'm printing those schedules for you, so you can also ask him about those. Without all the exhibits.
Thank you.
I'm just there's 3 of them, Madam Clerk.
Oh, Frank, it's
They're just for Ms. Lozano, and there are
I
3
have
of
them.
them.
I can
Do
go
you
dig
need
them
the
for
exhibits, Ms. Lozano?
Yeah, I've never seen these before, Judge.
Do you need all of the exhibits?
Are there lots? Is that what I'm hearing?
No, they were filed. You were here in court. The judge told us to go for us to file these.
And we
You
had
received
discovery
them.
opening. We were supposed to meet and confirm. We didn't because we were withdrawing. I get it.
No,
Okay,
no, these
okay.
aren't. This isn't.
Oh my
something
god.
In their entirety for you.
So fucking catty.
I would have done this during the break had I known you didn't have them.
My god, it's so angry.
Time.
I'm sorry, Your Honor, but as I was leaving, I said I didn't get a schedule of arrearages. I said that's news to me. That's what I said.
And I'm going to state she did.
Okay, so we'll take another break and you can read these.
Yeah, that's a short one. All right, where's 3 of? We got 3 of 3 next. Oh wait, did a judge get disciplined?
We filed defendant's brief on financial issues, and then plaintiff's
This judge actually got disciplined. Uh-oh.
brief updating the court on defendants on the financial issues. So both of us on that same day filed briefs on May 8th, 2018, which precipitated the court's thorough order on May 16, 2018. Nothing's been filed since then. So this is, maybe she just forgot.
Or maybe I was just told that there was nothing paid and it showed that everything was paid. So that's why I'm just kind of confused, Your Honor. So let's go through it.
You want to help?
Let's go through it.
Wait.
No, I'm fine, Your Honor. I don't need it. I don't. Let's go ahead and do this.
Okay, stop.
Yeah.
I need it. I need to have a clear record. I want the judgment. I want the schedule of arrearages. As I said before the break, she has verified them. So your client needs to testify to them. And there are multiple pages. You said you haven't seen them. I don't want him to be prejudiced. So I'm going to print them out and tell me what other order you need.
I got it.
The one reducing to judgment?
I know.
Counsel, do you
The
agree?
May 16th, the one that's filed July 7th.
No, they're not best friends.
Because we had the child support set in one, and we had the financial issue set in another. Because there was 3 separate days for trial. There was 2 separate orders. There was an order in May, and then there was an order in October. The order in May was regarding the child support. The order in October was the rest of the financial issues, including everything that was reduced to judgment. So that's why it was a little confusing, Judge.
So you need the October one?
Correct.
Okay, Frank, can you give this to her, please?
And,
Your Honor.
Well, Your Honor, just so the court's ready, there were judgments, so you know, if you pull our register of actions, actual judgments filed October 24, 2016 for unreimbursed gymnastics, for spousal support arrears. In addition, August 14th, 2017, and if I can approach, I printed out the register of actions. And then, since the judgment, the court required me to file
Tiffany, when it says judgment in red, how come I don't have an icon to click onto it?
And then, Your Honor, see the judgments at the top, that's how we do our registers here. And then after that, in May 2018, see how the judgments are first, right here? And then in May 2018, I supplemented, and those are the arrearages that have been filed since the judgment, notwithstanding what you already mentioned. And you actually summarized it in May, your May 16th order, this one, order after hearing me. You summarized it all for all of us after we briefed it to the court.
You know I don't have that.
So these start October.
And Your Honor, the only thing I'm going to object to is that we have 3 things. There's no financial disclosure form. Okay, that's new.
There wasn't.
All right? That is new before trial. Okay, because we have a new raise coming on here, and we don't have these updated because we don't have any of the $20,000 that's been garnished on any of these pages. None of them have been accounted for. So if she's swearing under oath
August
that she hasn't
14th,
gotten any documents,
I can't click on any of these judgments.
Your Honor, if she's swearing under oath she hasn't gotten any money, then I want to know where that $20,000 is going.
What? May
I have an
2000.
opportunity to ask her when she testifies.
I understand, but Your Honor, we have got zero payments on any of these schedule of arrearages.
Maybe if she could see, maybe understand the prior orders. There was child support arrears, alimony, spousal support arrears, equalization payment, and
There's one for
gymnastics.
attorney's fees, there's one for gymnastics, and there's one for child support.
And the $500. She doesn't know. Don't worry about it. Don't worry. Just the judge has it.
And all of these judgments, I can't even.
We don't have to cater to make her understand.
I understand all of it. She should sign everything's paid off. It's
Nothing's paid off. She doesn't.
He's making 2 payments. The payments he's making are
I know.
the garnishments.
The garnishment is for the $690. I thought it was $597. Let me see.
Yeah, it is.
Is it $597?
And then a $50 arrears payment towards back child support. That's what the $50 is.
Here we go.
And the gymnastics.
Right.
May I approach, Your Honor?
Well, I'm not ready yet.
God, this is such a scuffed Normandy. But I gotta go to other places to go buy it, to go get the other parts.
He's got a schedule of arrearages for alimony. Well, where's the
Which
child
one? We
support?
filed like 3 in a row. So which
Let's do child support first, and then alimony second, and then we do last one.
Just for the alimony payment. That's not. Oh, okay. And then the judgment.
Which one?
He just copied.
This one? So I don't want to do that one. Okay. Okay. And then okay.
Do you have the new one that you just had, Marshall? I got the schedule of
know
arrearages
which
for
one you gave
equalization.
Lupe.
I got the schedule of arrearages for gymnastics, and I've got it for alimony, but I don't have it for child support.
I don't have one.
Do you have a schedule of arrearages for child support?
That's the $50 payment
Oh.
coming out.
For the child support arrears of $1,050?
It's the $50 payment that's coming out.
Okay,
of
that
the-
one
of the
has been reduced to judgment. That's the child support arrears of $1,826, filed in August 2017, long
a little
before you
bit.
got involved, for which
Pro
they're
se.
garnishing $50 a month towards.
My
And this is
understanding that he does not have any continuing arrearages for
correct.
child
So
support
it's
after that.
so it is in my pretrial memorandum, the breakout of exactly the money that was ordered and what is being paid. So for maybe this will help counsel move along. The child support of $597 is still coming out. $900 alimony for 72 months was stayed beginning June 1st, but he had owed temporary support arrears of $21,400, already reduced to judgment. So I don't want to reiterate the new stuff. The arrearages that were filed, the schedule, is from the judgment date going forward.
That's why we need the judgments in the record. just
Correct.
To have one clear record for this hearing.
And you did it, Judge, in your notice and order after the 2000, can you give me the order after 2016?
This is the 2016 order.
No. The, order after hearing May 2018, my apologies. The May 2000,
This one?
from my schedule of arrears, so.
And Your Honor, what we
Here it
did
is.
in our pretrial, like you just testified to, is that we took your order and we went from there.
May 16, 2018.
Okay?
So, Judge, if
So the
she's
only
using-
thing I would have to ask is there's no payments that have been shown on these schedule of arrearages. We would ask that the credits be given. We've already, so that we don't have to waste this court's time, already said that from this order, if you look at our pretrial.
Are you arguing now?
No. I just don't want to have to go into a whole bunch of testimony on this. But Judge, we've already agreed that from this order forward, those amounts are reduced to judgment. Please look at my pretrial.
That is my understanding.
So I don't think we need to go belabor
Hold
this,
on.
Fuji. If we have to go, no, I just mean the orders, the judgments are what they are from before. Like I'm saying, I'm not re-arguing those. We filed September 29th of 2017,
Yeah,
Your Honor.
he
We're
does.
asking for the consideration to be from October 1st of 2017 forward. So I don't believe that you need anything other than what her schedules are with your orders, because the orders are what we went by, Judge. Okay, and then with the proper credits for the garnishment of $1,600 a month, it's $1,597 a month.
And Judge, and my client can testify what exactly the money that's being paid, what it's for, I can represent, because he does not know. It's the DA's office. Kroger won't take anything. It's just the DA's office, and it's child support and alimony, the combination of the two. The $50 towards arrears of the child support and alimony. When, in your order of May 16, 2018, you reduced, again, the things that were already reduced to judgment, and the payments that he, like the equalization, the $500 per month, that's already reduced to judgment. So you can't ask for credit, as I claimed in the Colati case, not only stuff reduced to judgment, but retroactively when he owes of accrued payments.
And we're not asking for that, Judge.
Okay.
We're asking for the change
Then it won't
October
be-
1st.
then it won't-
October 1st would be the only change that we're asking for forward.
It won't be October 1st because some sums were already reduced to judgment as of May 2018, and he had
And that
owed
was
them.
already taken into account in my pretrial, like I said, Your
If
Honor.
I can just get a whole sentence out, what I meant, and what it says, Judge, is your order, and I did too, go off your order from May 16, 2018. 0 towards the equalization, 0 towards the arrearages, 0 towards gymnastics, 0 towards the arrearages. $50 a month, that's it for the child support arrearages. Still $50 a month. Still happening because those arrearages still aren't being paid off. Alimony arrearages and spousal support arrearages of $21,000, and my fees is $7,000. None of which, the only thing that's getting paid is garnishment 2.5 years later by the DA's office. And in your order, you said, Judge, that I will suspend the garnishment for going forward alimony. However, he will still have to pay towards arrearages. And that, I don't think, is what they are understanding. So the amount, $1,600, and it's right there in your order, you said, I am allowing, beginning June 1st, defendant's alimony obligation is temporarily stayed, but not modified, until the evidentiary hearing on whether he's willfully unemployed. Alimony arrearages may continue to be garnished. They were never garnished until right then, boom, right in June 1st. The DA's office is crediting it now towards the $21,000 that he owes in arrearages off this report. So my client can tell you exactly how much he's received to date, and it's listed and identified in the pretrial memo. But I used your numbers, the court used, after May, after all the judgments, after reviewing all the orders. I think the argument counsel and I are having is a legal one, because you don't get to go back on things when there's a judgment, nor do you go back when it's already been accrued. So I think it's just a legal argument that I can brief if the court wants more of that, because I did it in my opening, not so much in my pretrial. But I think she's going to ask the court to recalculate and go retroactively back, as opposed to going forward should the court find it credible of a changed circumstance or not willfully unemployed.
And, Your Honor, from the beginning, you will look at my pleadings from the beginning to now. They have not changed. It's been since September 2017. I've been saying the same thing.
Yeah.
We litigated this stuff to death because she was going to get a whole bunch of stuff to tell us how horrible this person was. He can't find it because those are the only two letters, Your Honor. We don't have it in evidence, okay? We had to continue this because she got the same 2 letters that I got. If you remember that, that's what's been dragging this thing out. Okay?
I object to her making comments about what I received. I've gotten, she doesn't know what I've received. She doesn't know.
Nothing's in evidence. Nothing's in evidence.
Right, exactly.
Okay?
Exactly.
So what we're going forward
and it's
is
your
Except
burden.
your mom's in evidence. How about that? Take that.
It's your burden.
For a judgment. That's what's happening here. There was only $1,000 that was owed for child support by the time we were here before. It's been paid 19 times over because it's almost $20,000 that he's paid. He has paid $19,857.07. That's what's been garnished to this date through the DA's office.
I'm going to object to testimony. Where's the audit?
Your Honor, that's what's been audited. That's what's been done, and she's going to have to testify to it too. But if she says it's not, again, we'll just show
it's
the
your
DA's
burden
office.
to prove he's not.
Today is the day that I need the evidence. Where's the DA's audit?
Your Honor, we don't have a DA's audit. We did not get it in time. We did not get it.
Okay, proceed.
Okay, but for the record,
No, not proceed arguing. Proceed with questioning the
Please.
witness.
How much has been garnished from your check to this date?
About $20,000
Okay, it comes out of your check?
out of my check.
Do you see it like in this exhibit from Exhibit 1? Oh, excuse me, Exhibit A? Actually, it would be Exhibit B.
It should be on here, 823.
Oh, they're not here.
And do you see garnished out?
See child support.
And how much has been taken to date?
800 to date, 11,529.
Okay, and then last year? Is that when the other 10,000 was taken?
Yes.
I'm going to object to the form of the question. What do you mean last year? And what are you looking at?
Okay. When did they start garnishing your wages?
Right. Okay. That's a fair question.
Last year, May.
So in 2017, which would have been last year, did they also take about 10,000 out?
Yes,
I
they did.
object to the form of the question. I've seen nothing that's 10,000. I've seen
When did you stop beating your wages? How about
nothing that
that?
it started in April.
I don't have any proof of when the garnishment
Exactly.
started, what they were garnishing
Exactly.
If I remember correctly, it was back in May.
Okay, May. And do you know or not know where the money that is taken out of your check, where it specifically goes in the judgments?
No, I don't know the breakdowns. No.
Okay. Would you know it's going to pay?
I thought it was going to child support, and then the rest to alimony, which that's what I thought. Pay the child support first, and
So you understand that you have no child support arrears now?
no, I did not.
We don't have to
He
guess.
still does.
We don't have to guess. There's an audit somewhere.
Right,
that we
and
need.
Judge, and
Okay, hang on.
I
Are
just
you
I
only
have-
asking the court to do what the judgments are already been done? Are you
Wait
asking
a minute,
the
she
court-
withdrawing the question or the statement? Because when you make a statement, the child support plan in full, when in fact it's not, if they don't have evidence, I just object and would like that stricken, Judge.
I just
Okay, sir, you don't need to speak right now. I need the documentation of what has been garnished from his wages and what it's been credited to. Okay?
Have you tried to get any information from the district attorney's office regarding this?
no, I have not. I went to child support, and they did not have that case in there. So there
Okay,
was,
so you tried
I
to.
did. I did.
So you said no. Is that correct?
Well, no, I don't know
You
what
said
the district
no.
attorney is. I went to the building itself
Which building did you go
on
to?
Flamingo and Burnham,
Okay.
and they did not have that case in there.
So you tried to do what?
So I was trying to find out what was going to what, and they didn't have it at that facility.
Okay.
They didn't have our case.
And did they tell you to go somewhere else?
They said it was probably in the court. So I just stopped there.
Okay. Now, as you sit here today, are you asking the court to remember the order that we did and remember the pretrial we did?
Yes.
Are you asking that the court do what we asked in the pretrial?
I'm asking the
Change
court.
child support.
Yeah, I'm asking them to change it as of October 1st, because we're not going to change the arrears. I understand that I owe that. So
Do you understand when a judgment is entered by the court that we are supposed to do?
Objection calls for
Yes,
speculation.
I do apologize.
Go ahead, finish.
Yes, I do understand that now. I didn't before, so I do apologize for that. Like I said, there's a lot going on, so I apologize to you because I didn't know how it all worked. So
And are you asking the court to enforce the prior orders, which is the judgments, and then just change the child support from October 1st forward and to eliminate the alimony obligation? Is that correct?
that is correct.
Okay. Is it the same request that you had all the way back to September 29th of 2017?
Yes, but I felt that fell through. So yes,
Okay. And is it the same request that I filed on your behalf back in September
yes.
Of what year?
of 2017?
Thank you. I just want to
Because
make
he
the
was
record.
2016.
I want the record to be clear.
Correct, Your Honor. I'm sorry. He filed it in November of 2016, and I believe I might have said 17. I filed in September 29th of 2017, Your Honor. Okay. And then the order that we were going off of to get all of our judgments was the order that the judge entered herself this year on May 16th, 2018. Is that correct?
Yes.
Okay. And that's what we based our pretrial memo was on?
Yes.
Okay. And I see that we have schedule of arrearages. Okay, and it shows in the garnishment that, in the schedule of alimony that you paid the first 4 months voluntarily.
Yes.
So you
Until
did pay her without
I
a
paid
court
it,
order.
and without a court order until I ran out of money. I had no more money to give. I gave as much as I could. Even the 5th month, I gave, I believe, $300 or something like that, and that was it. The rest, I had to make sure that I would be able to live and take care of the kids, and so.
So the first four, let's see, the first four was 1, 2, 3.
And not only that, at that time.
Up.
So this doesn't even start until the arrearages on the alimony doesn't even start until October 1st of 2016.
Objection
Is that correct?
calls for speculation.
Yes.
Your Honor,
I'm looking at the document. It has a date on it.
I just want she just said that child support arrears were paid. Your
No,
own
no,
pretrial
no,
memo.
this is alimony.
Arrears. I'm just going back. I'm just trying to follow your thought process. If she would like to argue this in close, I have no problem arguing it in close, but it's painful when he indicated he doesn't know. He just knows how much is taken out.
He said he paid 5 months.
Painful.
He could not do it anymore because
And
of
it's
the painful
reflected in the schedule of arrears.
amount. No, it's not. The schedule of arrears doesn't start until October.
Counsel. Stop this back
I know,
and
Brad.
forth
These
bickering.
guys. This is like an all-day thing,
I
and
asked
they're
that the
like,
schedule of arrearages be
they are
made
gonna
exhibits,
each other's
and I
throats.
asked that he testify as to the schedule of arrearages. Okay, that's very simple. I want the record to be clear. I know it's already part of the case file.
I just don't have a child support one. All I have is a schedule of arrearages for equalization payment filed May 8th, 2018 at 12:09. I have a schedule of arrearages filed May 7th at 4:37 for a schedule of arrearages for alimony.
Oh.
I have one for the gymnastic payments that was scheduled May 8th 2018 at 9:54, but I don't have a child support arrearage.
So to help educate her on this, Your Honor, in your order of May
Educator.
May 16, 2018, it said, on October 24, 2016, the court entered the order amending the order of May 26, blah, blah, blah. The court found a child support obligation from defendant with claimed amount of $697. It is undisputed that defendant owes child support arrears of $1,176. Plaintiff filed a verified schedule of arrears. Defendant does not dispute that acclaimed amount. That amount is already reduced to judgment against defendant. This is in the judge's order dated May 16th. It is in Don Lozano's pretrial memorandum on page 5. In lieu of receiving child support from Angela, we would like it to be applied to satisfy the child support arrear judgment of $1,176.
Epiphanies, thank you for the gifted membership.
What?
One at a time. She wasn't finished speaking. I don't hear what you're saying when she's still talking.
I think it is misleading to the court to try and criticize or say, I have filed numerous schedule of arrears throughout this time, back in January 2017, back in 2016, but ultimately this court had to do the arduous task after updated schedule of arrears and financial disclosure forms were done to make a decision, and you did so very well in that order from May 16, 2018, order after hearing, outlining and detailing and incorporating the schedule of arrears. Testimony as to Lupe was not disputed, and therefore additional sums, which were already reduced to evidence, were still reduced to judgment. Were reduced to judgment yet again. It's disingenuous to say, "Where's your schedule of arrears filed for child support?" We were at the hearing. We asked. A schedule of arrears had been filed. He did not dispute it. It's already reduced to judgment. So what is the issue? It is being garnished at $50 a month. That I don't know if you knew that. But it's not paid. So
the issue is a mistake right there in the pleading. Right there in the pleading, Your Honor. It's very clear that you said $1,176. It's very clear that their schedule of arrears says $1,162. I was trying to clear up the discrepancy in the typo. I believe that yours is correct. I believe hers is not correct. So what?
Well,
it has to be cleared up.
There's a judgment.
You have a judgment
for child support arrears. Are they garnishing the base amount of mental
just
health?
$50 a month.
Just
$50 for arrearages. Just $50. Because if you don't order, you ordered $500, but that was for an equalization payment. They will only do child support and alimony. So they only would take $50 in arrears. That's it. So $50.
Plus the current of $697. Again,
Correct.
That's what I just asked.
Correct.
Yes, she's saying no, but she's getting $1,600 because it's going towards that. The way she's done these judgments is so confusing. The DA's office are not supposed to be collecting a judgment. They're supposed to only be collecting child support.
And they were.
And no, they're not. No, they're not, Your Honor. That's the problem.
God.
Is they're trying to keep that $50 in to get the rest of the judgments in. They're trying to make the DA's office be a collection agency.
Well, if that's your issue,
I said, okay, direct, no problem. Direct garnishment, we'll put it straight in our account, whatever we need to do. But again, it has nothing to do with child support when they're garnishing the rest of the judgment, which again we acknowledge in our pretrial.
I think my pretrial memo sets forth what the order from May 16th continues on, exactly how much being garnished, and what our prayer is for the future. I don't know how, when we don't, my client hasn't had the opportunity, Ms. Lozano's had several hours to educate herself, but I think this May order, if we go off the May order, he testifies how much is being taken away, what his understanding is that it's child support and alimony. When the court says, when Ms. Lozano says, the DA's office is not allowed to go back. Yes, they are. In this order, which was given to the DA's office, I'm assuming, it says you can continue to garnish for alimony arrearages. I'm going to stay it from June 1st. He doesn't have to pay that $900 anymore, and that's something we're asking for recouped. But
oh my God,
they
Brad!
can continue to garnish for
Goodness.
arrearages. If you have an issue, then that should be taken up with the DA's office. But my client is, how can you envision $80,000 or $68,000 worth of arrearages and trying to cut off zero going forward is my bigger question. If you're going to say the schedule of arrearages are wrong, go off the judge's order from May 16, 2018. I am fine with $50. I am fine.
And I am, Your Honor, but even your order doesn't match the schedule of arrearage. I'm telling you, there's a typo. I'm showing it to you. That's the schedule
Proceed
of
with your
arrearages.
question.
Okay. So, again, going forward, we don't have a separate schedule of arrearages, but this is a schedule of arrearages that was filed in January 2017, which he represents as the last one that's filed. Do you know if all that child support you paid? Have you paid more than $1,000? $1,162?
There's no arrearages. Did you file the January 25th or the January 26th schedule of arrears for child support?
I have. I want to make sure we're on the same page.
January
I have January 25th, 2017 at 9/10/05.
And there's a January 26th schedule of arrears for child support.
There's another one?
Yeah, I filed like 10.
Again, Your Honor, if we're going to go off the order, I want to make sure we're going off the right order, because this one is not what's reflecting in yours, and those are the numbers we're going off of.
She knows it's arrearages, not monthly. She knows.
So do we have a separate one that I can go off, Your Honor, so I can question my client properly, because she's saying there's another one after this?
After which one?
She said, I only have the one from
Here.
What are you looking for? Child support arrearages?
The 25th, she says there's
We're
one on the
almost
26th.
here.
Are you looking for child support arrears?
Yeah, there's one the next day. It was amended. Let me get it for you, Ms. Lozano.
See, it's a spousal support arrears schedule. It's not a schedule for child support
I
arrears.
filed a.
But I'm reading.
Yeah.
Filed January 26, 2017.
Thank you.
Schedule of arrearages. Child support.
Thank you.
Do we have a number? Is it different?
Thanks,
than that?
Thomas, for 29 months.
1162.
That says 1162. Your judgment reduces it 1176. I'm just trying to get the numbers right, Judge, so we can be clear on all the numbers.
Well, is that with or without interest?
I don't know, Your Honor. I have.
None of them are with interest, Judge. I did not have the.
Well, you have it on
form.
page 2, lines 25 through 27, into page 3, lines 1 through 4. If you'd like me to show it to you.
No, I have it.
Okay.
I have it right here.
But it says it's undisputed that the child support arrearages is 1176, and your number is 1162, and I don't think you would even know what a child support arrearage number schedule was.
Then why are we
he says he
asking the
agreed to
question?
it. I'm sure he agreed to the actual number.
Okay, so we're off $14.
Okay.
Is that what you're saying?
I'm not sure, Your Honor. I just would love to know where that number came from.
I'm so glad I'm not doing
Your
anything
judgments, and we're
close to
accepting the
family
schedule
law
of arrears.
anymore.
We would be in, we have a little bit of problem on math.
And I, at this point, I would cite Aztec Mines and say, you know what I mean, Judge? Can't now bring up an agreement that was not presented for consideration. I'd also argue that no error. I got it. Hang on. Pease v. Taylor. No error in either the admission or the exclusion of evidence. No error in defect of any rule or order in anything done or omitted by the court or by any party that's not substantive or does not substantively affect the rights of the parties. In this case, the schedule of arrears predated the two judgments afterwards, and his acknowledgement of the judgment on the record contained in the order, and therefore it's moved.
Thank you.
Your Honor, we would just ask that the court look at that and see if that's been changed.
Same objection, Your Honor. I'd go with the latest one.
Sustained. Here, Frank, you can get this back to Ms. Lozano, please.
I'm sorry, Your Honor. We had an interim order from the February 8th hearing that set it at your number, which is
Use
the
the year,
1176.
please. Use the year, please. Make the
I'm
record
sorry.
clear. Make the record
Order
clear.
from your order from February 8th, 2017 took into account the payments and the legal interest collectible by any means. That's what you did at that point. And then you took the last payment he did. You asked for that payment, which was like $650, and then you got the 1176 number from it because it was at 1826. You took the 650 payment from there, so 1176 is how you got to your number. So I believe your number was correct. So I'm actually showing Ms. Fuji that she's wrong. $14 to the bad.
Are you talking?
So good. So this one should be higher.
Are you talking this February 2017?
Correct, but it's been incorporated into the 18 order, and the 18 order is correct. Your number, not the schedule of arrears. Correct.
Okay.
I'm just trying to be good on all the numbers, Judge.
Your Honor, just to make a clear record, on February 8th, 2017, there was a motion he filed to review child support and obligations under the same change circumstance, orders modifying everything. He was present with counsel, arguments regarding his employment income arrears, living arrangements, FDF, modification of alimony, and the Fernandez case, and fees. The court noted a wage assignment was granted for the bonus, which was signed in open court and returned. At that time, the court made findings. He made over $100,000 a year.
Your Honor, again, this
And
is
there
all
was-
stuff that's already been looked
Don't
at.
interrupt. Don't interrupt.
Just making a record, and there were no grounds to modify. The court
Again,
further,
objection relevance.
because you made a
It's a matter
record.
of the record, and so it is relevant.
At that time, Your Honor, the schedule of arrears for child support and alimony were reduced to judgment at that time, carrying legal interest collectible by any means. Attorney fees were awarded for me, and I was to submit a brief pursuant to Brunzell analyzing the factors, which was done, and the order which was filed. And I'm reading from those minutes. So this is the order that is now, I guess they're having an issue with $50 a month.
No, Your Honor, what she's doing is she's trying to use the DA's office for collection agent. That's what she's doing.
I'd
She's
like
submitting
to
all the
strike.
orders and getting all of them
Take
done.
that up. Take that up with the DA's office.
Oh my God.
Can I have that?
But Your Honor, do you have any problems with any of the schedule of arrearages as long as you get credit for?
Guys, I don't think I'm gonna make it. I'm hungry.
We go back to
I'm done with this crap.
And then from October 1st, what are you asking that the court do?
I don't know if I'm gonna make it.
Child support and
My food's
alimony
here.
And just get it right.
And you know you guys did as your child support obligation before pursuant to Murphy, so you took your income and her income. Are you just asking that they do the same thing this time?
Yes.
Objection. Leading. Black's Foundation, if he knows what Murphy is.
Okay. And then do you know that Angela gets a raise every year?
Hold on, I want to finish building the ship.
Yes.
Hold on.
Sustained. Foundation?
Yes. Can you tell me about how long were you married?
Close to 20 years, 19 years.
Did you know about her raise history and her work?
Yes,
What
she
was
gets $1,200 every year raise.
Okay.
Automatic.
It's a cost of living.
Okay.
Cost of living.
And when did that always happen?
August, September.
So it would be right about now?
Yeah.
So if she has a financial disclosure form on file, she would need a new one?
Yes.
I have nothing further, Judge.
Thank you. No other questions.
Step down.
I'd like to call Miss Angela.
I could, but he's in his cubby hole, and I don't want to. And it's hard to set up because the cubby hole's in my bedroom, and it's hard to set up the camera where he's at.
Can you state your full name for the record?
Angela K. Pellegrino.
And where do you live?
6741 Corrine Hills Court.
And what do you do for a living?
I'm a first grade teacher with the Clark County School District.
At the time of trial in this matter, January, February, March 2016, did you have the same job?
Yes, ma'am.
Your income was approximately, at that time, $65,000. It is now like $68,000, almost $69,000. Did you get a raise?
No, we just get cost of living raises, and periodically the school district has taken away money, and then when they get more funding, we'll get it back. So, but I'm maxed out as a teacher. The $1,200 that he referred to was when I was a beginning teacher, and each year of teaching, you would get a $1,200 raise for more years in the district, but that subsided a long time ago because I've been teaching over 20 years now. On that scale, you maxed out at after 14 years.
Okay, so are
what
you
he's referring to
maxed
is-
out as a first grade teacher?
Yes.
Okay. Did you file a financial disclosure form since trial?
Yes.
Okay. During the trial, this court heard testimony as to Lupe's income.
Yes, ma'am.
Were tax returns, W-2s, and records from Kroger included?
Yes.
Were employment records received via subpoena duce tecum also admitted into evidence?
Yes.
Did that include stock dividend options, health saving plan documentation?
Objection, Your Honor.
And-
Anything that has to do with the stock dividend plan has already been dealt with. Move to strike.
Huh?
It was a full question. It's a foundational question about what was admitted to evidence. So until she hears the question, it's leading up.
Move to
So
strike.
it's
Anything regarding a stock option was already dealt with.
Please state your entire question before you.
Thank you. Were his employment records from Kroger obtained via subpoena duce tecum admitted to evidence? Sorry. Did that include his dividends options, his health saving plan documentation, and proof of his Bank of America Merrill Lynch 401k?
Yes.
And his bonuses?
Yes.
What about his U.S. bank records?
Objection. Still same objection, Your Honor. This has all been litigated before. You kept me kept me in on this. Objection. Relevance.
Ms. Fuji?
Thank you. And fair enough, because I did it to her. But I'm laying the foundation. This court had the same documents as today that it had then, the only difference being that Lupe's been demoted. So it's a foundational question for a purpose, that I wrote up for a purpose. So it's not so much to prove what I'm not trying to relitigate, more or less trying to prove the documents that were admitted to
Same
All
evidence that the court
right,
utilized.
sustained. Let's move past that,
Okay.
please.
One of the reasons we're here today is regarding bonuses.
Yes.
Strike that. I'm going to move on. The schedule of arrears that were filed at the time, back in May 2018, were those the amounts you had reflected, what you had received and how much was owed as of when?
Since the judgment that Judge Hughes filed in October of 2016.
So these were in addition?
These were in addition to
what was already reduced to judgment by order of this court?
Yes.
Objection, Your Honor. What I have is not from that time frame. So if there's another one, I need to know from that time, because she said she filed a whole bunch of them. So I need to know what she's talking about.
I
As
think
far
they're
as
the same ones I gave you.
We don't have anything from May of 2017. So if she has something from May of 2017, let me see. That's the one she's talking
Did
about.
you mean 2018?
I did, Your Honor.
Yes.
Thank you.
I've seen no payment.
To date, has Lupe paid anything that wasn't garnished?
No, I think there's a disconnect with his counsel in the of what, I don't think he understood the order, or if she understands the order that Judge Hughes filed in October of 2016, because there were two arrearages payments. One was to be garnished, the $50, which was solely for child support.
And that's mentioned in the order by this court and decision in October 26, 2016.
Yes, ma'am. And then there was another arrearages payment that he had to willingly pay, which was $500 that went towards the equalization payment, the spousal support, and that is a payment he has never made, and her order was filed in October of 2016. That is a payment that is never made, and we do have the schedule of arrears, and that's the $500 payment. And then he was also ordered...
That's why the equalization payment says $500. It doesn't. Yes. It doesn't go $29,288.40. It breaks it out.
Yes, that
$500 a month.
That equalization, the $500 that Judge Hughes ordered him to pay has never been paid. And the arrearages also reflect Ivy's gymnastics, which he was court ordered since May of 2015 to pay half of her gymnastics and has never paid 1 penny. And you can see the equalization the arrearages that were filed in May that we filed showed that his portion since May of 2015 is over $17,000, and that was in May. And now, even though Judge Hughes, last time we were here in court, told him very sternly that you will follow my orders, he left the court and still didn't pay for her gymnastics for May, June, July, August. So now that number, his portion, has grown to over $19,000. And this is in the last 3 years since May of 2015. His portion is over $19,000. So I have paid on my own close to $40,000, and that doesn't even reflect all the traveling I've done with her: Kentucky, Reno, San Jose, San Diego, Long Beach, all her choreography, her music for her floor routines. That's all money that I've put out that's not even listed in that. So his arrearages to date, and I have every invoice from the gym, everything's highlighted. I have copies for everybody who, if I'm allowed to pass them out. But his portion of her gymnastics is over $19,000 current.
Well, let's start with the gymnastics. Gymnastics amount was already reduced to judgment by Judge Hughes. You indicated.
Yes, and I did want to
objection. As far as the gymnastics, we've already agreed and stipulated to the judgment, and we've agreed to go forward to pay for it. And again, I don't exactly know, other than this garnishment, why he can't pay for it. We've agreed, stipulated, agreed to that. So wasting time on that just makes no sense. Objection, relevance.
If counsel's going to testify for him, I would ask you to please tell the court, why are you concerned that if counsel's stating correct, she agrees with the subjects reduced to court's indulgence. You saw a copy of our pre-trial memo we filed in this case?
Yes, ma'am.
In it, I listed and reiterated what Judge Hughes had reduced to judgment.
I did want to make a comment about Judge Hughes' May judgment that was filed. It stated in there, we filed a schedule of arrears in May that showed his portion was over $17,000, but then when the judgment came, your number was $14,000. So I didn't know if that was a typo or where that number came from, because he admitted that he owed the gymnastics, and our schedule of arrears was over $17,000, and there was no objection to that schedule of arrears. So there is a $3,000 discrepancy. So I don't know if you'll accept our new...
I'm going, the amounts that are currently reduced to judgment by this court, and I'll start with the equalization payment, which was $25,814.94. The court can take judicial notice of that. How much have you been paid of the equalization payment? Just say, do you know the amount?
Well, if part
say
of his
the amount, if you know.
Whatever I've received from his bonus that he was ordered to
So
give.
wasn't the court, didn't the court indicate that you would be paid that equalization payment from his bonuses, right?
Oh, yes, he knew that from the beginning.
All right. And did you get that bonus?
Only this year, not in the previous years.
Okay.
Every time we came to court, he claimed to have spent it.
All right. And this was the $2,609.06. You only got the $1,300, and then the invoices, I think that Ms. Lozano was trying to show you receipts. That was him paying you back the other $1,300. So you got the total $2,600 bonus. So that equalization payment of $25,814 now is only $23,205.
Yes, ma'am.
And how much of that is being paid via garnishment?
0.
Okay. And how much has he paid of his own?
0.
Okay. Have you added interest, prejudgment interest to that amount?
I haven't. I know that it is 2% that accrues, but I haven't done the math on that.
Spousal support arrears was reduced to judgment $27,700. How much of that has been garnished?
0.
Didn't you receive, as of June 2018, 2018, when the judge stopped it, didn't the DA start doing it towards
then
arrears?
The 900 would be applied, but I believe, according to Judge Hughes' judgment that came out in May, depending on what is concluded here today, whether that would be fully applied or not.
No, I don't want you to guess or speculate. The judge already ordered alimony arrearages may continue to be garnished. So arrearages, those arrearages of $27,700 were not garnished until June 1st, 2018, when the court stated in this order, beginning June 1st, 2018, defendant's alimony obligation is temporary stayed. Until the evidentiary hearing on whether or not he's willfully underemployed, alimony arrearages may continue to be garnished. So up and until then, none of them were being garnished, correct? So June, July, August, 3 months at $900 is $2,700.
Oh my God.
So that you've been
So angry.
received via garnishment.
Yes.
Have you received any sums from him
No.
directly? All right. Child support arrears, $1,176 was reduced to judgment. When did arrearages get garnished all along, or did that
right.
too just start in
I
January?
made my SR2 Normandy. Looks pretty nice.
The $50
But all right, I think I'm done.
getting garnished.
I can't yell
I
the
have June,
voices.
July,
There's just too many
and
voices.
August. $150 have been garnished. There's more?
Every month, the $50 is being garnished.
Okay,
along
and that
with-
is since starting when? Because my pretrial memo is incorrect, Judge.
since his wages have been garnished.
When did that begin? He said a different date than you told me.
The Kroger was garnished.
Just listen, don't
the
overthink it.
DA's, I filed with the DA's office August. of
Now
last
who's
year.
coaching
August
who?
2017.
At the Flamingo office.
Okay, August 2017. And if able, can you try, I don't know if they're going to give it to you because it's his paycheck. Can they give you to date and
Oh no. I'm going ahead. I can't.
yes.
Oh, I understand.
Use
Okay. All right.
2600.
Fine. All right. I'm sorry. I'll go back to where it was. I'm stopping this. I'm stopping this at the 45-minute mark. At 45:53. 45:53 is the timestamp. 45:53. The title of this. The title of this is Sparks Fly in the People's Court Occupied by Family Court Judge Rena Hughes. 3-3. That's the title of the video. Actually, you know what the hell am I doing? Why don't I just copy the link? Here's the link. There's the link to it. I am done. We got over halfway through the goal, so I'm happy. Thank you guys for helping me out. I don't know why I decided to do this. I'm an idiot, but I'm hungry. I'm tired. And I can't hear them anymore. Yes, this is Veterans in Politics. I can't listen to them anymore. They're destroying my brain. All right, I'm done. Have a good night, guys, and I'll talk to you later. Okay. See ya. Oh no, I'm done. Adios.